Hello, everyone, and welcome to Immigration Talk Show. I'm Napasa, your host for today, and I'm very happy to have you all join us. So, folks, before we have our guest of for today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, a very warm welcome once again to Immigration Talk Show. We have a very important discussion lined up for you. Yes, today we're going to discuss about the March 2025 Visa Bulletin, which released a couple of days back, and it's bringing updates and challenges for those in the U.S. immigration system. So we're going to discuss about that. And yes, to help us break it all down, I'm very, very happy to welcome back our very well known expert in immigration law, attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. Prashanthi, so good to have you back. How are you doing?
How are you?
I'm good too, Prashanthi. Thank you so much for joining us today. And how has it been lately for you? Otherwise, must be very busy with H1B season coming in, and also so many changes with the new administration as well.
Yeah, it is a challenge, and I have, I'm on the phone most of the time because I have so many phone calls. People worried about their status, unsure about what the new laws mean to them. So it is a kind of a roller coaster kind of time. So you know, we just take one day as it comes and hope for the best.
Absolutely. And well, it's been very amazing that and very fascinating that. So sorry. Excuse me, my throat still hurts, but I was going to say I'm very excited to speak about the March 2025 visa bulletin. There are some changes and interesting ones as well. So definitely we have some questions. So I have this first one. How should Indian applicants, interpret the slow movement in the final action dates for family sponsored visas, and what strategies can they adopt, while waiting?
So maybe in the past we should first go through the visa bulletin for those who haven't had a chance to look at
Sure.
it.
Sure,
I was
Prashanti, you
thinking we
can go
should
ahead.
just okay. So to start off with the visa bulletin for employment-based visas, um, USCIS has said that they look at the final action dates. So unless your priority date is um, before that the priority date in the final action date chart, you cannot file your 485. For the family-based cases, they're still looking at dates for filing charts, which is good news. That means there's still some scope for forward movement in the family-based case. So that's why they're still looking at dates for filing charts. Dates for filing charts. So with reference to final action chart for employment-based, let's go through the different categories and see how much movement there's been. So for EB2 and there's been a forward movement of 6 weeks. For India, for EB2 China, there's been a forward movement of 2 weeks. This is all for the final action date table, since we can't look at dates for filing. EB2 worldwide moved forward by 6 weeks. EB3 China advanced by a month, and EB3 other workers India also advanced by 6 weeks, and Philippines advanced by 5 weeks. All other countries for EB3 advanced by 2 months. So as you can see, there's been a good amount of forward movement of 6 weeks for EB2 and EB3 India, as well as EB3 other workers India, and there's also been some forward movement for China, forward movement for EB2 worldwide, and Philippines also has moved by 5 weeks. So that's in the nutshell what happened in the March visa bulletin. We can take up the first question, like you said, was
Yeah.
the slow movement for the final action dates for family sponsored visas. Um, yeah, I mean, the family based visas, yes, there has been a slow forward movement, but some categories have shown some promise and a certain amount of forward movement. What strategies can you adopt? I would say stay prepared. Keep all your documents ready so that when your date does become current, you're ready to immediately file your 485 because it may not be current the following month. So you have to be ready to file your 485 in any given month. So make sure your birth certificates you have, your non-availability certificates you have. Um, Make sure you're able to get your medicals on time. So scope out the places that will actually send medicals within, a week or two. And keep watching for your priority date. Look every month in travel.gov under the visa bulletins for your particular month and your particular date and country so that you don't miss out if it does become available in a particular month.
Prashanti, for giving us an intro to what we can expect. And folks, I would like to tell you that you can also participate in this discussion by calling us on this number 425-436-6335, and the access code is 988-888. Also, don't forget to hit the bell icon and follow us. Our channel is Immigration Talk Show. Subscribe to us at Immigration Talk Show and get in touch with us, friends. Hi, Asim. Thank you so much for joining us on comment. We are going to take your comment very, very soon. But for now, Prashanti, I have my next question to you. And that is, with the F2A category, which is now marked as current for filing, what does this mean for spouses and children of permanent residents? And how soon can they expect to move forward with their applications?
Well, current for whom? It's not current though for Indian nationals, but it's close to current. It's June, I think June 2024. So pretty good. Very close to being current. You saying it's current for worldwide? I haven't checked, and I will check. But with reference to the visa bulletin in general, when once it becomes current, um, it's important, as I said, for you to file as soon as possible, right? Uh, because it may not be current the following year. So you want to make sure that you file it ASAP. And in order to do that, you obviously have to be prepared. Unless you're prepared with all your documentation, you will not be able to file. So while I was talking to you, I'm looking at the dates for F2A. Even for the dates for filing, it's July 2024 for everyone, for India, China, and all chargeability, all countries. For final action dates, it's actually 2022. But the good thing is, since we can use dates for filing, a lot of you should be able to file your case as long as you filed your I-130 in July on July 15th or before July 15th of 2024. So if let's presume that your date is current, then I would say that you're able to file. You're able to get your application ready in the month of February, whatever is left of February. So you have about 10 days in February to get your application ready, and you should be filing your application in the first week of March. In order to do that, obviously, you would need to get your medicals done quickly. You should, if you have not done them already, you should have your birth certificates ready. If you don't have birth certificates, then you should get secondary evidence, such as the non-availability certificate from your hometown, and also you should be getting, your secondary evidence for birth, which is affidavits of support or school leaving certificate, a letter from the priest, etc. Whatever you have to show that to prove your your date of birth. This is great news for spouses and children of permanent residents, which is what F2A is, um, because they'll be able to file 485. They'll be able to, whether you're outside the country or you're in the country. If you're outside the country, you can at least start the process. Um, you know, by hopefully your visa number will continue to be available and you'll be called for your interview. If you're in the country, you can actually file adjustment, which is a 485. And of course, you need all these documents that I just mentioned to file your 485. How soon can they expect to move forward with the application? As I said, if your date is current in March, you can file your application on March 1st. So the sooner the better.
Thank you so much, Prashanti, for taking that up. And I would like to say hi to Yashwant. Thank you so much for joining us. We'll take up your question. And if possible, folks, why don't you join us on call? Our number is 425-436-6335, and the access code is 988-888. And folks, you can also call Attorney Prashanti Reddy on her number 212-354 1010, and you can email Prashanti at prashanti@reddyesq.com, and go visit www.reddyesq.com to get to know more about Prashanti Reddy. So, Prashanti, I have another question, and that is with regard to the F4 category. So, siblings of U.S. citizens. So, has also seen significant delays, and what are the main reasons for this backlog? And do you foresee any improvements in the processing times for F4 category?
No, because there is a huge backlog and there continues to be a backlog for siblings of US categories for all countries, including India and China. And I don't foresee any improvements in processing time because there is so much demand and there's only certain number of visa numbers available every year. So, as I said, the main reason for the backlog is the high demand and the limited number of visa numbers. So, unless there is some change, and there may be less numbers used up in other categories and they fall down to F4, which seems unlikely, or if there's some legislative new law passed where they increase the number of green card numbers for family based, I don't think we'll be seeing a significant change in the backlog for F4s.
Hello, everyone, and welcome back after the short break on Immigration Talk Show. I'm your host, Napasa, and with us today we have our guest, none other than Attorney Prashanthi Reddy from the Law Offices of Prashanthi Reddy. So, Prashanthi, it's been a great discussion discussing about the March 2025 visa bulletin so far, and yes, we've taken up some questions. We also have more people join us. So, this is on your channel, actually, Prashanthi. Melly Caldito has joined us, and I think we should take it up. So, how about the F3 category, ma'am? They file August 25th, 2015. My room is City. Hello, ma'am. About the F3 category, please, we file August 20th, 2025. My mom is a US citizen. How long to wait, please?
It's difficult to actually say how long the wait will be. So if you're looking at F3, and even if you look at dates for, I mean, if you look at the final action date for India, it's July 2010. And for dates for filing, it's a little better, but not so much. It's July 2012. And for those who don't know, F3 is basically married sons and daughters of US citizens. Um, so it's hard to tell. Sorry, we can't predict exactly how long it'll take. Um, and if it's 2015, then they're working, as you saw, in 2012. Um, and it doesn't move every month. So it's not like every month it moves a month. Yeah, so sometimes there's no movement at all, if you might have been noticing, for 6 months, and sometimes there's a movement, sudden movement of 6 weeks, or 5 weeks, or a few months. So it's very sporadic, and it all depends on demand. And USCIS has said that they have a high demand for this year as well, um, just as previous years. And they've also said that they don't have that we will not have as many visa numbers available um, as last year. So last year we had 160 something thousand visa numbers available, because the basic number is 140 that's available, and then they add unused visa numbers from other categories. So they don't think there'll be much of the unused visa numbers from other categories. So you'll have a minimum of 140,000, but maybe more, depending on how many are unused. And so with the family-based category, it's the same. Um, you know, you we're not expecting a large surplus of visas, so I think the movement forward will be slow and sporadic, unfortunately. Um, and not much you can do other than, hope that there'll be some change in the law, which will then speed up the processing time.
Okay. Thank you so much, Melly Caldito, for joining us with your question. If you could call us also, it would be great. And we have RK also. Hi, RK. Thank you for joining us. RK is asking, why can't DOS can't tell us in February, for example, that between October and January, X amount of green card was issued between USCIS and DOS. They have this information because they used to make the VB, visa bulletin.
Right, I don't know exactly why they don't give us that information. They do give us, for example, they have given us the information for 2024, as to, how many numbers were actually available.
Mhm.
But for 2025, they have simply said that what they've said, and I quote, the employment-based annual limit for fiscal year 2025 will be higher than was typical before the pandemic, though lower than in FY 2021 to 2024. We are dedicated to using as many available employment-based visa numbers as possible in FY 2025, which ends on September 30th, 2025. So they always tend to give the information for the previous year, um, but we don't yet have information for the present year. And I think even with reference to moving the visa numbers, they move them slowly, um, based on every month what the usage is. So I think they're able to, give us a number only towards the end of the fiscal year, because they are waiting to see how many 485s are filed every month, because that makes a difference as to what the visa numbers will ultimately be. And I can discuss that a little bit more in detail. I do have some numbers with reference to the 485s, that the number of 485s that are pending and have been filed, because that makes a huge difference with reference to what the visa bulletin will look like. So basically, every quarter they release these, USCIS releases these numbers. The last time they've released them is in September of 2024. They've released it for that quarter, and they've basically said for visa numbers that are current, the 485 spending for EB2 are range from 13,000 to 36,000 for last year. And EB3, the pending 485s for priority dates that are available, were between 9 and 51,000. So you see, even for available cases, there is a backlog. That's 13 to 36,000 for EB2 and about 9 to 51,000 for EB3 cases. So this shows that even if your visa number is available for that particular month, you can still expect there'll be some delay in processing because there are so many cases that are in the backlog. They seem to be, on the whole, slightly less number of pending cases for EB3 when compared to EB2. So if your visa number is available only, say, for a month, you may not get the green card that month if it becomes unavailable the next month, because as you see, there is a backlog that they have to go through. Now, to your point with reference to visa numbers that are pending right now, priority dates that are awaiting availability, there is a huge backlog. For EB2, it's about 900,000 to 1.3 million for EB2. For EB3, it's about 500,000. So you see EB3 again, the number of cases is less when compared to EB2. So you can expect there'll be more rapid forward movement in EB3 when compared to EB2, from just based on the pending cases from last year. Of course, this changes every month, right? But this is, gives you an idea as to what to expect or what the average numbers are,
Yeah.
for any particular month. So you see that there is a huge backlog, continues to be a backlog. So, that's why we're seeing slow forward movement.
Yeah, and he was also saying, RK was also mentioning our monthly just published of the 140K green cards, how much is remaining, just so they can announce. But of course, we don't know why
Yeah,
don't they inform.
right, right. I don't know either. Maybe it's more complicated than it seems.
Maybe.
I don't know.
Yes, RK, thank you so much for joining us once again. It's always good to have you. So if you can also join us, and Melly Caldito says, thank you, ma'am, Prashanthi. So let's move on now to our next question, Prashanthi, and this is with regard to the same F category only, but F1 and F3. So for applicants filing under the F1 and F3 categories, how do the dates for filing impact their overall timeline, and what key steps should they take while waiting for final action?
I think we kind of discussed this, the F3 category, through a question.
Yes.
um, what can they expect? I think we kind of discussed this, Nipasa, so we can move on to the
Okay,
maybe the
let's move
next
to the
one.
E category, the EB2 and EB3 categories. For India, they continue to experience significant retrogression. So, what factors are causing this delay, and what are the best options, for affected applicants?
As I said, the huge backlog. I just read out a few numbers with pending 485 cases that were published last year, about 900 to 1.3 million for EB2, about 500,000 for EB3. These are cases that don't have priority dates available. And for cases that do have priority dates available, there is still a backlog of about 13 to 36,000 each month for EB2 and about 9 to 51,000. I think for a particular month they had very high backlog. So that's why that 51,000. But about, a few thousands for both EB2 and EB3, even for cases that are pending. So as you continue to see 485s being filed, you will see that the backlog just gets worse because the demand is so high and the number of the priority date is not available because there's only 140,000, as RK pointed out, every year for them to work with. And if there are 1 million cases being filed, or there's a backlog of 1 million cases, there might be more cases being filed every year, every month. 1 million versus 140,000, you can do the math and figure out why there is a backlog, right? Um, and also in previous years, we had some cases not being like EB1 worldwide, or maybe EB5 or some family-based cases. They were not the numbers were not being used for worldwide, so they were trickling down to India and China. So for last year, we had 160,000 available. That means that 20,000 more than the 140,000. That was because of the trickle down effect from the other numbers. And for 2023, we had 197,000 numbers available. So, that's like 50,000 above the normal level of 140,000. This was again due to, because about 6,000 EB5 visas were carried over from 2022 to 2023. Just giving you an example of what usually happens. And about 10,000 EB5 visas that Congress allowed to carry over for the next fiscal year for EB5. So, these are the reasons why there were more visas available. There was also trickle down from the other visa categories. And so, we had more numbers available in 2023. 2024, we had, as I said, 160,000 available. I think 2024, there'll be less than 160,000 available because they have said that there won't be as many numbers available as they were from 2020 to 2024. So you see, because of the high demand, there is a definite backlog, and we don't expect to see any changes unless the demand reduces for some reason, and we don't see that happening, or there is some legislative action taken. For example, there have been bills in the past, the Eagle Act, where they have asked for, various things. They've asked for the visa number limitations to be removed completely. They've asked for visa numbers from previous used years to be, that were, not used and went to waste, to be put into the present so that the availability becomes more. So there have been various things that have been proposed, but nothing has happened so far. So that's why we continue to see backlogs for EB2 and EB3 as well.
Right. Right, Prashanti. Thank you so much for updating us about EP categories as well. I think we should take up more comments from our audience since
Yes,
they are very actively participating. So
yes,
this next
certainly.
one is from Sagar and Manisha. Hello, ma'am. My name is Manisha and I'm from Nepal. I've got my PD February uh, 26, 2024, EB3 skilled worker. What's your prediction? How long do I have to wait more? Thank you.
So EB3 skilled worker, and the good thing for you, you're not from India. Um, so if we look at let's go to the EB3 and look at employment based category 3, all other workers it's 2021 for final action dates, and for dates for filing, it's 2023. Um, Actually, no, it's 2021 as well. So there's not much difference between the two, final action date and dates for filing table. For all other workers, we're not talking about regular EB3, we're talking about all other workers, which is EB3s for jobs which don't require a bachelor's degree. Uh, Difficult again to predict when the numbers will become available. Um, Obviously, we're not going to see a jump of 4 years this year unless something drastic happens. And again, we don't see a jump every month of a month, so it's difficult. I can't say that it'll be available in 4 years or 5 years. Um, you know, but something could happen where suddenly there becomes an availability of numbers. I mean, COVID was the last thing that happened, which really drove the dates forward, but we don't want another thing like COVID to happen. So I'm hoping that some legislature, some change in the law happens, which will make the numbers jump forward. Otherwise, I don't see any change in the demand. I think the demand is going to be as it has been in the last 5 years.
Right. All the best to Manisha. Thank you for joining us. Folks, let me remind you that you can also join us on call, and the number is displayed on top of the screen. So please join us 425 436 6335. And when they ask for the access code, dial in 988 888. And also, I mean, Manisha, RK, Meli Caldito, and all you folks out there who've joined us, especially whose questions Prashanthi has already taken up, please do not forget to subscribe to us, hit the bell icon, and thank you, everyone. Next up, we have Nikki G. I have an EB1 with priority date 12 2024. My old EB2 is 12 2018. Now, when I did I-485, USCIS rejected, saying dates are not current. How to fix this?
I have an EB1 priority date of December 2024. My old EB2 is 2018. Now, when I did 485, well, if your visa number is current, then you should be able to file. But again, we have to look at the visa bulletin. I don't know which country you're from. If you are from India, then obviously it's not current. EB1 is still in 2022 for both dates for filing as well as final action dates. But I see what you're saying, that you have a previously approved I-140 and you're trying to port your priority date, in which case then you should inform USCIS. When you got the I-140 for EB1, your old priority date should be reflected in that. If it's not being reflected, then you cannot file a 485. So in order for it to get reflected, you have to file an amended I-140 and ask USCIS to correct the priority date to 2018, that you want to port the old priority date. And that's the way to do it. You have to have an I-140 with the 2018, I-140
Mhm.
with EB1 2018 priority date, and then you file the 485.
Okay. She's currently in India, she says. So does it make a difference?
If you're in India, then you basically are asking for the I-140 to be ported. And then once it's current, then you file an immigrant visa petition through NVC. But for that, you have to show that you have a current I-140.
Okay. All right. Thank you so much, Prashanti, for taking this up. And Nikki G, thank you for participating. This next one is from Shriva. This is also on your channel, Prashanti. Can site visits happen for people on GCEAD?
Um, GCEAD, which means 485. You have a 485 pending and you have an EAD based on that. If you're presently on a H1, that's when site visits happen. If you're on the EAD for based on a 485, site visits shouldn't happen, because it really doesn't matter whether you're working or even not working. Because if you have a pending 485, you can choose whether you want to work or not. There's no constraints on where you should work, how you should work, terms and conditions, or even if you should work. But if you have a 485 from company A, and if you're not working for that company, then there could be an issue at maybe the 485 interview, where they're asking you if they're questioning whether the job offer in the 485J is valid or not because you haven't started working for that company. But other than that, um, the site visits that you usually see for H1s should not be there for GCEADs.
All right, right. So, do you see EB2 or EB3 PD January 2014 to be current soon?
Uh, January 2014 is a long way off. I don't think it's going to be current soon. I
Thank you
mean,
so much.
in the
Yeah.
sense that I know they are working on 2012, but still, I don't think that EB2 and EB3 um, will move that quickly.
Mhm.
Let's maybe by in the next couple of years. It's difficult to say, really. I'm just, putting it out there, but it's difficult to say.
Speculating,
For
yes.
dates for filing, it's closer because it's 2013, so you're 2014, but it is January 2013, so there is a long move. For EB3, it's June 2013. Um, so it's about, depending on which month you are, um, it could be a wait.
Okay. Shriva, thank you for joining us. This next question is from Abha. What are the predictions for F4 PD July to 2006 for India?
Everybody's asking me for predictions. I don't have, I'm not a soothsayer. I don't have a bowl which I can look into and predict what the dates are likely to be. And for those people who, I know people release videos with predictions and they get a lot of likes, but that is, really, I mean, you can't take it seriously because you don't know, bottom line is. F4 is, of course, um, the most retrogressed. That's brothers and sisters, and they're working on 2019 cases for India right now, um, and 2006, in fact, for dates for filing. And yeah, so it's not 22, sorry, it's 2006 for F4. Uh, that's a long wait. And your priority date is July 2006. Um, yeah, so you're closer. Let's see. So July 2006, they're working on August 2006. So we've not yet reached, maybe a few months. Um, what are the predictions? I haven't seen a huge amount of forward movement for F4. Um, I know it's only a month, but wait and see. Maybe towards the end of the year, you'll see some more forward movement if they see that not many cases have been filed. Then you see like a jump sometimes towards the end of the year. That is, end of the year is September. So wait and see because it's only a month. I'm hoping that the date will become current. But again, we don't know for sure.
I'm sure many folks out there are hoping that. But yes, we got some more questions from our Facebook group. So let's take them up quickly, Prashanthi. So this first one is from Sagnik. My previous visa was F1. Have scheduled a Dropbox for H1B visa first time stamping at Chennai for March 7th, 2025. Do I need to cancel and schedule OFC and interview? My hometown is in Kolkata. Can I schedule for both offices and interview OFC and interview in my hometown? Can I reschedule the appointments now or do I need to wait till March 7th?
So, first time stamping, why? Okay. Why, if you have a Dropbox, why do you want to cancel and schedule for an interview? Um, I don't know why he wants to schedule for an interview, but it could be that sometimes with Dropbox, since you can't submit a lot of documents at the Dropbox, they are, sending out administrative processing 221G notices to Dropboxes, uh, and then asking questions or asking for documents. So in order to avoid that, if you go for a personal interview, then you can submit documents, on demand. Go with the proper documents and submit them. I mean, mostly they're asking for end-client letters or contracts, etc., at the consulate. They're also calling the clients to find out whether the job is actually available. They're contacting the employers to find out if the job is still available. So we're seeing a lot of 221Gs. Um, you'd have to cancel one. You have to cancel one visa before you schedule for another visa appointment. So I think that was the only question that they had.
Yes. Thank you, Prashanti, for taking that up. Now,
And you
this
can
next
schedule
question.
it, you can schedule for an interview anywhere. It doesn't have to be hometown, it could be any other consulate that's close to you.
Okay. Thank you so much, Prashanti, for taking that up. Control, if you can tell us what's the next question, please. I dropped my passport on January 31st, 2025, and mine is H1 renewal. On 11th February, status changed to refused, waiting for passport to be returned. Is that due to the new rule? What will be my next step? Usually, how many days it will take to get my passport back? Any suggestions, please?
Uh, well, as I said, there have been a lot of 221Gs issued. Refused basically could just mean that it's gone into administrative processing and they're not immediately giving you the visa. But it's possible that they can give you the visa upon conducting their investigation, and doing their background checks, to see if the job is available, client is available, etc. So it's possible that they can still give you a visa. It's just that immediately, they've refused it, at least temporarily. That's what usually refused means, unless the 221G was refused, in which case then the refusal is permanent, and then they might send back the H1 to USCIS, and USCIS might send a notice of intent to revoke, at which point then the employer will be able to respond. They usually have 30 days to respond.
Okay. Thank you so much for taking that up as well. The next question, please control if you can display it. Okay. I am reaching out to seek assistance regarding and I have encountered while to start a new application. It appears that my profile details match existing record and preventing me from proceeding further with the application process. Since I have no longer access to my old email ID and profile, what are options open in this situation? Any guidance?
I think what they're asking here is, I'm not sure what exactly they're asking, but are they asking for filing a new application? They want to get access to my USCIS website.
I think yes, it's
Maybe
the
that's what it is.
Mhm.
Um, I mean, you can use a new email address to open a new account. If you already have an existing account with an old email address, you need a new email address to open a new account, which you can certainly do.
Right. All right. So the next question, please, control. This is from Darsh. Hello, I had H1B Dropbox for 13th February today, and when went there for Dropbox, they denied and told there are changes in regulations on 10th February, and not I would need fingerprints and interview. Is anyone familiar to this scenario? I think he's talking about biometrics. Is it
Yeah, they
necessary now?
denied and told me that there are changes. Uh, I would need fingerprints. Yeah, I've heard this as well. Uh, And I've heard that, Dropbox, I mean, Dropbox is still available. I've not heard otherwise that Dropbox is not available. But, even with Dropbox, the officer has the right to call you for an in-person interview. And I'm seeing more of that happen. So that's what must have happened.
Okay. All right. Next question, please. Or okay, I think that's done. So this is Sarmad. This is on from our viewers. I'm going to submit my perm. Currently, they are processing October 2023. Do you anticipate the process time to increase?
The problem is under the Trump administration, they don't care about, how well they process it. They don't care about adding resources. They're basically against any kind of immigration. And in his last term, we saw processing times really skyrocket because they really cut down the staff. They did not hire new people. This is at USCIS, and the same thing might happen. We're seeing a lot of federal employees being laid off as well.
Mhm.
So from that point of view, yes, I think processing times for labor certs could increase. For that reason, also, DOL usually becomes more strict under certain
Mhm.
administrations, and also they become more strict when there are more layoffs. And when that happens, then audits increase, denials increase, and that also, you know, uh, causes your processing time to go up.
Mhm.
So yes, you can expect in the future that processing times, might go up.
Yes, plus there's so much vetting processes also going on. I think
Right.
themed things will be held on for quite some time. So, Prashanti, before we go, if you still have some more time for one more or a couple more questions, I wanted to ask about the religious worker category. It is set to expire in March this year, 2025. So, what would happen to pending applications if no legislative action is taken? And are there alternative visas for religious workers?
Um, I mean, you could use the visas that exist, which is the H1B, provided that it's a specialty occupation, which it may not be. So that's why religious workers are a niche category because they are very unique in what they do. So they might not be other visas that unless the particular job requires a bachelor's degree in a particular field, and if it's something like that, then it could be a be you could possibly file a H1. If you belong to a different country like Australia or Canada, you could possibly file a TN. Again, if you meet those requirements, which um, may not be for a lot of religious worker um, jobs. So let's hope that they extend it again because uh, it is religious worker is always for a set period of time and then it is extended. So let's hope that it gets extended again.
About the DV visas, the diversity visas category, which remains current for all regions right now. So, what advice would you give the applicants who have been selected in the DV 2025 lottery and, but maybe they are unfamiliar of what to do in the next steps? So, any tips for them?
Um, File for adjustment as soon as you can if you've been selected. That's the only advice I have.
Thank you so much, Prashanti. Also, what policy changes or legislative actions could help address the ongoing backlog for Indian applicants, maybe across both family and employment based categories? So, are there any potential reforms in the horizon?
We are waiting to see what happens this year. There have been many bills that have been introduced previously, but didn't see the light of day. So let's just wait and see what happens this year.
Yes, we'll really have to wait and watch because there are a lot of changes happening. And also, I mean, you must have heard about the 20 judges who were, fired just recently. Well, how do you think this is also going to impact the immigration scenario? Is it going to add to more backlogs or you think it's I don't know.
Well, immigration judges, luckily, they don't process USCIS cases. So it will increase the backlog for asylum cases, removal cases, those kind of cases, but not cases that are processed by USCIS.
Okay. All right. Thank you so much, Prashanti, for your time today, and it was great to have you. So, maybe any end notes for folks out there, especially with regard to the visa bulletin for March 2025.
If your dates are current, please file your 485 immediately. Make sure that you file with your medicals because you can no longer file without. USCIS has said that they will reject all applications that are filed without medicals. So make sure you have all your documentation before you file.
There you go, friends. All the best. And Prashanti, I hope that I'll see you soon again with another very interesting topic to discuss.
Sure, see you next week.
See you, Prashanti. Have a great day ahead. And folks out there, thank you so much for joining us. In fact, you can also contact Attorney Prashanti Reddy from the law offices of Prashanti Reddy. And every case is different, so it's best you email her directly about yourself and ask your questions. So her email address is prashanti@reddyesq.com. And her phone number, by the way, is 212-354-1010. And you can also go visit www.reddyesq.com to get to know more about Attorney Prashanti Reddy. Also, friends, don't forget to subscribe to us at Immigration Talk Show. We are on YouTube, and also hit that bell icon so that whenever we have discussions, you're also notified. Also, check us out on LinkedIn, Facebook, X, and on Instagram. We are there as Immigration Talk Show. Follow us, connect with us, and stay in touch with us. This is it for now. Have a great day ahead and stay tuned on Immigration Talk Show because we will be back with more. Bye for now.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are here with another very exciting webinar that is lined up just for you today. So make sure to watch this session till the end, and you can also ask questions. That is the best part of our webinars, that you can participate by asking as many questions as possible. And with that, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So check out us there, and also like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared by our experts and attorneys, including user comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And today, the topic that we are going to talk about is another very important and very essential, especially for E2 visa applicants. And that is, what should investors know about the E2 visa changes in 2025? So, to help me in diving into this discussion and also to make this webinar a wonderful one, I have a very special guest who is joining us for the very first time. an immigration talk show, none other than attorney Jessica Weiss. But before inviting her to this webinar, I would also like to tell something about her, that attorney Jessica Weiss is a nationally recognized immigration lawyer with over 2 decades of experience and remarkable list of achievements. She was honored with the prestigious Immigration Services of the Year award from the Global Chamber for her outstanding achievements and exceptional services in the field. Jessica also serves as national mentor for the American Immigration Lawyers Association, guiding fellow immigration attorneys in the areas of adjustments of status and also on E2 visas. The great thing about her that she takes the time to understand each client's case in a very unique way, and she also guides them every step on the way. And whether it's coming to the US as a tourist, moving to a green card, or one day becoming a US citizen. So I'm really thrilled and honored to have a show with her. So, Jessica, thank you so much for being here. We are really honored, and we welcome you wholeheartedly to Immigration Talk Show for the very first time.
Thank you so much. That was quite an introduction. I very much appreciate that. And I can't explain it, but I love doing E2 visas. I've done them for more than 2 decades, and I really, really enjoy them because it's such a great way for people to come to this country. So I look forward to this show today with you.
Absolutely. I'm sure our viewers are really excited for this session, and that too, it's a very important topic. So I think without any further ado, I would just like to know it from you, Jessica, that what our viewers would expect from today's webinar.
So I think what they can expect is a better understanding of where are we going with E2 visas. Is it going to be the same story as the last, what I mentioned to you a little bit earlier before we started the show was 1815 is when E2 visas started. That's over 200 years of E2 treaties. And do we think in the next year with President Trump in command of this country, is it going to change drastically? So I want you to understand, what are the changes? Will there be any changes? Are we in for another several years of a great ride with E2s? And I think you'll get that from this presentation today, a much better understanding of that.
Absolutely. I think that's great. Our viewers are going to know a lot of things in today's webinar. So, Jessica, let's begin with our very first question. What should investors know about the E2 visa changes in 2025?
Okay, first thing is, I don't think there are going to be a lot of changes. I think we're in for a great ride. If you look at the last time that President Trump managed this country, we didn't have a lot of changes. In fact, we had 2 countries that were added to the list of E2 treating countries. We had Israel and New Zealand. And I think we're in for more countries may get added on, which is very exciting because there are so many countries that want to be part of this E2 treaty that we have process, and they're left out. I don't think every country, like mainland China, I don't see that one happening so fast. It just depends on our relationship with a country and how much trade we have and how much we want to benefit each other's countries by allowing them to do this E2 treaty. So I think we're in for could be some more countries added. There are a few things, actually very recently something changed, that it used to be that you could have a waiver of your interview, let's say for an E2 visa, if you got it within 48 months of the last one. They just changed recently that it has to be within 12 months that you got your visa, that they will waive the next interview for an E2 visa. So a lot of people are out of luck now. So there are probably going to be way more E2 visa interviews, which also can slow the system down. So that's what's going to be, that's happening right now. That just changed. In terms of if there's going to be a larger investment, like right now, substantial investment, we'll talk about what figure is substantial investment. I would say that figure is not going to change too much because that's the beauty of the E2, that it can be a small investment, could be $100,000, $150,000, could be less even. I've done them smaller, could be $1 million E2. But I don't think that number is going to change so much. I do think that the Buy American, Hire American policy that Trump puts in place could affect some of the E2s. It could be that when you apply for an E2, they want to hear, tell me about all the American workers you're hiring, because we want American workers to get jobs. So the E2, if someone says, I'm going to hire a lot of foreign workers, non-immigrants, green card holders, but not a lot of American citizens, I'm keeping an eye on that to see where the Buy American, Hire American policies will go. And I also would say that scrutiny of the cases, I think there'll be plenty more scrutiny of the cases. Sometimes I'm shocked what they scrutinize over. One gentleman, we just refiled his case again. Why did they scrutinize it? They said, well, you never ran a dry cleaning business before, and you wanted a dry cleaning business to run in the United States. So I'm thinking, what you for an E2, you never have to have the exact experience in the business you're going to be buying, but you need to have, let's say, managerial experience or some business background. Just depends, but it's never so precise exactly.
Mhm.
This man said, I didn't have dry cleaning experience, but I have management experience. So he refiled it because we were like, this is ridiculous, and he just got it approved today, actually. So he's really excited. So some more scrutiny could be out there, but we deal with it as it comes. If we know what the rules are, we push on the rules. We know what the regulations are for E2s. So that's some of the stuff I think coming, some more scrutiny, maybe some more E2 treaties, which could be exciting. More American workers they're going to look for in some of these companies. The visa waiver, the being exempt from the interview, that's basically taken away. It's going to be, everyone's going to be interviewed for extensions, for renewals, for brand new E2s, all that. And yeah, so those are some of the changes that I could see coming.
All right. That's great. And I love the energy that you're putting up and, beginning our
I love
sessions.
this stuff. I don't know why.
Absolutely. I think everyone is loving, and that too, that's so great that you have put up so many different pointers, that too in very first answer. And I'm too getting a lot of questions in my mind, but I have to be very much particular about the topic. But with that, Jessica, I have just a random question from my side that you put
Sure.
up about trade and tariff from President Trump's administration. So, do you think that putting up tariff and trade, all these things may hamper the relationship between the two countries, majorly the US and the other one? Do you think they will have a hostile relation, or whether the relationship will increase and become better?
It's a very interesting time for that question because half of my clients are Canadian, and we see what's going on in Canada. Trump is taking a very tough approach, putting more tariffs, saying, look, we don't want to give you as free a ride as we gave you before, but there are neighbors. Mexico's our neighbor. And I still believe that we'll work this out somehow. But I do believe that it does factor in. I think because it's a treaty, an E2 treaty, the reason for it, the basis of it is because we have ongoing trade with another country, and we want to give our citizens and their citizens an opportunity to benefit, to build a business, to create jobs in the various, respective countries. So I still believe, I'm telling you, I've been doing this 27 years. It is a great way to come here. And even though there's tariffs and even though there'll be, more restrictions, I still think it's going to keep going because it benefits both countries. And it's all about, how can the U.S. get ahead? The U.S. has benefited so much by having all these E2 foreigners come here, create jobs for American, bring their capital here. That's all good stuff. For to build an economy, that is all really good, what we want here. So I still think even with the tariffs, it's still going to be good. It's good news. I am so positive about E2s. I love them. Besides the fact I love them, I think it's just such a great way to come here. And it's not just for the investor, it's for the spouse too. It's the children. It gives everyone an opportunity to come here. So it creates a whole life for a family in this country.
Wow, that's great. All right, I'm sure E2 E2 visa applicants are really looking forward to this session, and they are going to have a lot of different information with this. So thank you so much, Jessica, for putting up those very important pointers. As we are not having much changes, so I would like to know it generally that how is it going to affect foreign investors who are seeking to establish or expand businesses in the US?
So one thing you have with foreign investors is the currency. They have to see the currency. Like I've had clients, because I deal with a lot of clients from Canada, that say to me, well, I don't want to pull all my money out right away because of the currency difference. And right now our Canadian dollar is not as good as the American dollar. So they're slowed down a little bit of like, if they're going to do it, maybe they'll wait a little bit, see what happens with the economy or whatever. But overall, I think that the changes, because there's so few changes and because they still believe that America is a land of opportunity. I know it sounds cliche, but they still believe that they will keep coming. Even some of the changes that we see, like will there ever be a higher investment figure? They say substantial investment for an E2. They never give us what is the figure. So it's based on, they look at the whole picture. They want to see what does it cost to run this business. And years ago, I had a case of someone who invested $40,000 in an E2. It was a little one because I usually like them closer to 150,000 investment. They invested 40,000. It was an administrative office. They would use their administrative office staff at different offices. They had very little overhead, and they only needed to invest $40,000 in cars and computers and advertising, attorney fees, and that was it. And it worked, and that was like all they had. So will they look at the investment number and say, well, 40,000 is so little, maybe we want it to be higher? They haven't changed that yet. It's still out there. Your investment can be little. We like it bigger because we want to show that gross sales are strong and their net income of the company is positive. So it's very hard to show that the workers are going to be paid minimum wage 40 hours, 35, 40 hours a week. We need two of them for the E2. It's hard to show that if you buy a company that's so tiny and the gross sales are so tiny. So they look at the whole picture, and they're going to look at the finances, and they maybe even scrutinize it a little bit more to see, do we want to bring this foreigner here? Are they really going to have a productive company? They also look at job creation. They look and see, so you committed to 2 full-time workers, which is required for an E2. How soon are you going to get them on board? I like the workers on board right at the beginning. Even if I get 1 full-time worker on board within a couple months, I got the next one on board. But I really like the workers on board. And then the documentation. I mean, I had a client once, they were from Pakistan, and they had to prove every bit of where that money came from to invest in the U.S. company. Not only that all taxes were paid, but also where did it come from? So they had to show their bonuses, their paychecks. They had to go back to the very beginning, and we had to get a letter from the employer confirming exactly what they paid them. And that was pretty specific. I usually don't have to get that specific, but it's out there. I mean, we go back to the origins. We really want to know who gifted you that money. Where did the source come from? Years ago, a client said to me, I'm so happy I got money out and I put it in a bank account in Switzerland and I never had to pay taxes on it. And I said, that's ridiculous. I can't help you with an E2. You have to pay taxes on the money that you're going to use for the E2 business. So these are some of the, the little nuances that, we were going to look for, and they may look for more as these E2 cases, and they're becoming more popular because as other categories max out, like H1B, some of the H1B people say, well, I missed the lottery. Let me try to create a business. So the E2 system can get, there's still plenty of E2s available, but it definitely, I think it's going to get busier, actually.
All right. And also, I would like to know, Jessica, that how much money do investors need to invest to apply for an E2 visa? This is the most demanding questions that most of the investors ask.
Yes, it's a very good question because they don't have an answer out there. There's no specific answer. Substantial investment they look at. So you could have, like I said before, I had a business, $40,000, that's all they invested. I tell people to stay around $100,000 to $150,000. So what does that mean? Let's say you find a business that cost $80,000 to purchase. Well, that's not $100,000, $150,000, but there's so many other expenses that are involved in making that business happen. Attorney fees, travel expenses, maybe you buy a car, other fixtures, any renovations. So now we're getting it over the 100,000 mark. So the contract itself doesn't have to be exactly 100, 150,000. If you're creating a business from scratch, you're going to keep track on a spreadsheet every time you pay something, and you're going to show proof that you paid for it personally as the investor. And you're going to keep track of all that till you get to a substantial figure. But what is substantial? I would say, look, as close as you get again to 100,000. But I have clients that say, look, all I can do. One gentleman, he was creating a painting business. I have some great stories, by the way. I've been doing this a long time. But one gentleman, he was creating a painting business, and he hired 2 painters. Only needed so much money for all the painting supplies, advertising, overhead, office location, whatever. And that was it. He said, I can't get higher than 60,000. That's all I have. That's all I need to run this business. Another gentleman, he bought 2 trucks. Each truck cost over $100,000. That got him to over $200,000 as investment. He bought 2 trucks, had 2 full-time truck drivers, and he had plenty of opportunities to, use the trucks to bring products to different locations. He ran the business as an E2 investor, and that was it. So, it just depends. What does it cost to run this business? And the other thing I'll just mention is that when you're going to buy a business versus creating one from scratch, you can create what's called an E2 contingency clause, where you say to the seller that the whole entire deal is contingent upon me getting an E2 visa or a change of status by immigration in the United States. And either way, so then you're not putting all your money down. All of a sudden you're like, what? Why didn't my case work? You can, if it doesn't work, you get your money back because it was a contingency clause. The seller has to be willing to do that. And sometimes the seller wants a non-refundable deposit, a small amount, could be 5, 10,000 something, but it holds them for a few months while you're waiting for this case to get approved. And sometimes that's what the buyer needs, because they're nervous. This is like, could be all their money that they've saved up, and they're throwing it into a business, and they don't even know if it's going to get approved or not.
Mm-hmm.
But thank goodness I have a very, very good track record. I mean, I'm telling you, I do one E2 probably every week for the last 27 years. I'm always doing E2s. Always. And my track record is very, very good. In fact, one of my cases they use to educate their staff at the US Consulate in Toronto. So that's pretty exciting. My client was like, they asked for permission to take that file and show it to the staff. I'm like, yeah, sure. Why not? So
That's lovely. That's lovely, of course. With that, Jessica, here's another very interesting question that most of our viewers are waiting for. That how do you see the future of E2 visa under the Trump administration?
I see it as great. I see it as great. I'm telling you, this is what Trump wants. He wants to bring in more capital into the country. He wants to create jobs for Americans. He wants industries to thrive. There's certain industries that are very popular with E2s, like salons are popular. I'm not saying Trump wants all the salons to thrive, but he wants it definitely can build up different areas in our country. And it's a win-win. It's a win for everybody, because there are people in countries, they just can't wait to get out of there. They don't see a future for themselves. And coming here, it also doesn't take that long. And E2 can be done either E2 visa at the consulate, which takes usually a few months, the whole process, or it can be done in the United States. If you come in as a visitor and you do a change of status, then and you can expedite it. So you can get an answer very quickly in 15 calendar days. So it works. I see a great future.
All right, that's great. Most of our
Yeah,
viewers were really worried, the Trump administration, because we are going to hear a lot of executive orders nowadays. So they were really worried. But I think, as
yeah.
per your expertise, they shouldn't be, right?
Look, they can worry if they want, but that's what our job is as immigration lawyers. We hold their hand. We try to make the most successful case we possibly can. We look at the regulations, we look at what they have, we try to make it work, and then we give them the confidence they need to go to the interview, or before we file the case, we make sure everything's there, and then that's it, we file. So we don't take cases that we think have a very difficult shot of working. I really want this to work for them, because this is everything. Sometimes this client is all the money they have. And we know that. We feel that. And we work with them on that. And I'm telling you, it's like immigration is a little bit like social work, because you're dealing with somebody that this is everything to them. And I literally have clients say to me, do you understand? This is all my life savings. I had one gentleman tell me, my house burned down in this location, my house burned down in that location. This is all the money in the world I have, and everything I do, nothing ever works out. And I'm like, we're going to make this work, because this is important to you. Yeah, that's how we do it.
That's lovely. I'm sure you are filled up with so much positive energy when any client comes to you, they are just quickly becoming so happy, right?
We
Just by
try. I'll tell them the truth too. If they show me how we do it, usually is a business broker gets involved. And a lot of times if they want to buy an existing business, and I have to see the paperwork. I have to see, what are the gross sales, the net income, the employees, are they legal? And I tell them, look, so far things look good. Let's keep going. But if I start to see red flags right at the beginning, I tell them, do you really want to commit to something that's probably not going to work? Because you don't want to be going to that interview at the consulate and asking for a favor that, like, sorry, my case isn't fit so well, but please give this to me. We want to have a solid case when we go. And then they don't have to be so worried about, oh, what Trump going to do, whatever. But we always ask them right from the beginning, is there something in your background that prevent you from getting an E2 visa? Because they do. We have to know anything criminal, any, bunch of DUIs, we have to know. So we don't get to that point where they need a waiver at the interview and we're like, why didn't you tell us that you smoked marijuana and were arrested for it and it's in your record? Like, we need to know these things up front.
all right. Okay,
Yeah.
that's great. And here's another question, Jessica, about the key requirements. So, what are the key requirements for obtaining an E2 visa, and how can investors ensure that they meet these criteria?
Okay, so key requirements are: number one, substantial investment. Okay, we discussed it a little bit, 150,000 roughly, can be less, can be more, but substantial investment. It could be gifted to you. It could be your parents want you to have this opportunity to come to this country and they gift you $200,000, but it has to be a gift. It cannot be a loan. So substantial investment, you want to make sure you hit that around that range. You have to play an active role. So if years ago a gentleman said to me, I bought a gym, it's a 24-hour gym, everyone just goes in with their key and I don't have to do anything. I said, that is not an E2. You have to be there to run it on a regular basis. You don't have to be there 9 to 5, but you have to be there regularly and know what's going on with your business. Also, you want to buy something that you're not hiring your whole family. So I have clients that say, if I'm going to invest in an E2, I'm going to bring over my sister, my aunt, and everybody. I'm like, that's not going to work for an E2. You have to create jobs for people other than your family. So there's something out there called marginality. And if they deny your case because of marginality, it's because they feel that you do not make enough gross sales to cover the expenses to run the business properly. And they call it marginality, and you don't want that. You also have to have intent to depart. So I had a client once went to an interview and said, yeah, I sold everything off, my house, my business, and everything. And I'm just waiting for my E2 to get approved. And I told him, you don't do that. You have to always show in the interview at the consulate that you have intent to return to your own country, that you have something to come back to. So it's important that you have that too. So these, and also that all taxes are paid and the money was received legally. That's another thing. I usually don't have this issue, but if you got it through drug sale or something, terrorism or something crazy, like it's going to be a problem. We have to know really the legit source of that money. And then a strong business plan is key to these cases. They want to see over a period of time, over 6 months, 1, 3, and 5 years. They want to see, how are you going to build this business up? Who are you going to hire? What are your gross sales going to be? And we do strong comparative market analysis in the business plan to show similar businesses and how yours is going to thrive like theirs. And we put all that together, and usually it's several hundred pages, and then we have to shrink it. If you file with the consulate, you have to shrink it to the amount of pages they require. And for example, Canada is 50 pages. So my clients are going to be like 200 pages, and I have to spend time just shrinking the case to like 50 critical pages. And then the rest they bring with them to the interview. So those are the keys. And when you hit them, that's it. You hit these requirements, you can have a great case. I also want to share, though, sometimes you see a case and it has potential to be a great case, but it's not a great case, meaning like the numbers aren't so great, but you're going to build it up. So immigration says, show us in a strong business plan. We want to see how you're going to build it up. So if your gross sales are good, but you have a negative net income, even if it's 10,000, 100,000 gets harder to justify. But let's say there's a lot of deductions on the tax returns or whatever. If we can explain what happened, what went wrong, and this is how you're going to turn it around, sometimes those cases can work nicely too. So I wouldn't say every case has to be really strong net income, really amazing gross sales. We look at each and see, can we turn this into an E2?
All right, that's great.
Yeah.
Also, here another question, Jessica, that have there been modification to the minimum investment amounts or the types of investments considered eligible for the E2 visa?
So there hasn't been changes to the minimum investment amount, but the types of investments considered eligible for an E2, I would say now with a lot of remote work taking place, they've opened up themselves a little bit more E2s to some more remote, like remote offices, but you still have to justify, why do you need to come to this country? So if you have a business that all runs remote, like it's a sales business, you sell a product online, maybe you have a factory in the US, and maybe we could show how you have to check on it regularly or something like that. But when they come to me and they say everything's remote and I just need, workers in this state and another one in that state, and I'm like, it doesn't work so well. Like I had a woman years ago that she had a facility in California that made facial products and for skin and stuff, but her headquarters were in New York. But I explained that she has to go back and forth. And she really lived in New York, but most of the activity of her business was California. But we explained she had to go back and forth regularly, so she needed to be in the United States. But with so much remote work, people try to say, well, it's just all remote. And I'm like, you got to create a little bit that's not remote to work for an E2. But other than that, the types of investments, well, the thing is, people always call me up and say, I bought a house and I want to flip it. And I'm like, E2s, you flipping houses does not work for E2s, but let's get creative. There are ways to do things with the house, a house business. For example, you could have joint like apartment complexes, several of them, and say, look, I need to hire a manager, renovation person, et cetera, and turn it into an active business. When you buy one house and you flip it, it's not active. They don't like that. But there are a lot of ways to. I had one lady who she would buy the houses, she would create financial mechanisms for people to live in the houses, and then eventually they would buy the houses from her. So her business was the financial part of it. And that was the active part, even though she owned all the houses. But you can't just, one guy's like, I'll buy a house, that's my business. I'm taking care of the house. I'm like, no, that does not work for any two. It still doesn't work for any two. So.
All right. Okay, that's really interesting. Also, Jessica, why is the E2 visa country specific? We know it's obviously a country specific, so we
Yeah.
want to know the reason. And why is it available to citizens all countries like other visa types?
So the beauty of the E2 is we say to another country, you have so much trade and interaction with us at a business level. We want to continue that. And this is another way of continuing that by having E2 treaty that we have, and they have something similar in their country. For example, the country of Israel, we didn't have it for so long, and now we have it because there's a mutual agreement that they have an equivalent that if our American citizens want to go there and build businesses and hire workers, whatever, they have something equivalent to our E2. So that is why, because we have these ongoing relationships, and this just continues that relationship. But there are certain countries we don't have relationships with, like Iran. We have no relationship, no E2 with Iran, but there are other countries that who knows what'll happen maybe that will get it. I mean, New Zealand just came on board a few years ago, and there's a lot of talk about Greenland. We don't know what's going to happen with that. There are countries out there that are very interested in this relationship. So, but it's not with every country. That is true. And as I mentioned a little bit earlier, that it's very interesting the date that the treaty started can be 1850s, can be early 1900s. These relationships have gone on for a long, long time. So that's another reason why I don't think they're just going to go like that. There are changes that have come between the agreements that we have with countries, like France originally had an E2 visa, it was a 5-year one. Then they took it away and made it a 2-year visa they issue. Now we're back to 4 years. So sometimes the agreements that we have for the E2, there are adjustments that come about, but they give a lot of notice if it's going to happen usually.
All right.
So,
But Jessica, talking about the country's relationship, if we specifically talk about India, then India doesn't count in the E2 visa, right? But
right.
similarly, we have seen President Trump and Prime Minister Modi, they are having a very good relation. And not too in the second term, but also during the first term also. So, is there any chance that India can also count under the list of E2 visa, maybe after having good relations? Or what's your call?
Right. This is a good point that you make. The issue also becomes there are certain countries that the population is huge, like mainland China, India. If you look at the visa bulletin where they're seeing, the certain amount that we issue of green cards to certain countries like Vietnam, India, Mexico, there are so many people wanting to come here. But I think there are a lot of factors that play into which countries we have the E2 treaty with. And I think India would be flooded with candidates if E2 visa came about. This is just my own personal thinking of this, or mainland China, we would be flooded with them. So part of it is the ongoing relationship we have. And part of it is we have to look at the numbers. What would this do to our country if we open the doors to certain very large countries? Look, we do have it with Mexico. Right? We have an E2 treaty with Mexico. That was a long time ago it was established. Our relations are tenuous right now with the border and all the issues there, but it hasn't really been talked about that we would get rid of it. So there's probably a lot of factors that go into why do we have an E2 treaty. I'm only mentioning a few, but there could be behind the scenes things. Like, for example, with Israel, there was a lot of visa waiver overstays. So that was delaying it. They were like, Israelis need to stop overstaying on their visas. They respect our laws. And then, they were working out all the little details. So I don't know what ones are on the burner, so to speak, right now, but I'm hopeful that there will be more countries that we do have it with.
Absolutely, because nowadays we are seeing that we don't know whether the relationship are being very friendly or not with USA, but at least with India, we
Mhm.
have been seeing a better relation, and as compared to Mexico, Canada, the other countries who have the E2 treaty. So
I
I think let's hope, and if you are saying, then I'm sure our viewers would be hopeful, and they should also be positive about it because most of our viewers are really looking forward to the E2 visa. So
I hear you. And I love the E2 visa. I don't care what country it's from. I'm happy to help any country. I've done some very interesting countries, E2s, and all the requirements are very similar. Usually all the countries except for the UK. UK requires that you have physically lived in that country for 1 year before you file for your E2. Yep. And now it looks like Grenada and Portugal. These two countries, there's a way to become a citizen, and then you have to wait a certain amount. If you got it through a financial investment and you became a citizen, you have to wait a certain amount of time before you can apply for the E2. It's sometimes a 2-year waiting period or a 3-year waiting period, but that's another path in. If certain countries do not have E2 visa and you become a citizen of these countries, within a matter of a few years, you can apply for the E2. That's what some people do if they don't have a country that has E2 treaty. It's an unusual way to do it. You want to be a citizen of those countries, then go for it. You know.
All right, that's great, and I'm loving that. But Jessica, I really don't want to take a break, but I think it's almost 30 minutes, and we didn't
Oh,
even realize that. So, friends, we are just taking a short break. That will be 2 to 3 minutes break, not more than that. So don't worry, we are not going to keep your wait for long. But till then, you keep on posting questions, keep on commenting, and ask as many questions as possible. And we are here definitely, and we will try our best to ask and as I mean to answer all the questions as possible. Till then, you can also look for the contact detail of our today's attorney, Attorney Jessica Ways. The contact number is 888 and the email ID is jessicaw@waysIPlaw.com, and the website is www.attorneyjessicaways.com. So please go ahead, and you can also contact her, and you can let her know about your immigration journey, about your concern, what process you are going through, or what complexities you have. And I'm sure she is going to give you the best advice. So, with that, friends, don't go anywhere. We'll be right back. So, keep watching Immigration Talk Show. Hello, everyone, and welcome back once again to Immigration Talk Show. And now we are going to have a second segment of this episode. Till now, we have been going through a great discussion with none other than, I would say, wonderful and great attorney Jessica Weiss. And today, the topic that we are discussing is very important. What should investors know about the E2 visa changes in 2025? So till now, we have gone through a lots of information. What will be the future under Trump's administration? Then, what are the key requirements? How the investor should invest? What are the key pointers? And also about minimum money. So till now, we have gone through a lots of information, and now I think let's pick up our viewers' question. But with that, Jessica, before diving into our comments, I would just like to ask one more question because I think that is very important to answer. And that is, what are some common problems that investors face when they apply for the E2 visa?
Okay, so some of the common problems I would say is that the investment amount is too small. You have to watch that. That they don't have the hired workers properly. So, meaning like if they have one full time worker, they don't have any plans to hire another worker. That's a problem. That there needs to be a role for them and need to clearly have a role, and it cannot be hands on. So, if you own an ice cream shop and you say, I'm going to be scooping the ice cream at the interview, that's a problem. They have to understand they are CEO, they're overseeing the operations, and they have to make that clear. In terms of I would say during due diligence, the whole due diligence process while they're buying an existing business, a lot of them don't have the financial background. So they rely on a business lawyer to help them understand, but they have to make sure it's a legit company they're buying. On paper, everything can look legit. Some of my clients literally like park their car outside the business and see what the foot traffic is like and stuff. Because this is something I always tell them buy a business you like and buy a business that you think is going to last because we need this to last. Because as long as you're here in your E2, you've got to keep your business going. And they joke around, people say that E2 is like the retirement visa because you could buy it, you could be 70, 80 years old, and you could buy an E2 business, but you know what? You still have to take care of it. But a 70-year-old can check on their business on a regular basis, and they do. And so it is like the retirement kind of E2 business because snowbirds want to come here and eventually they love it here. And so I'm in Florida, so snowbirds. So eventually they love it here and they're like, how can we stay here longer? So that's my business, and they run it, for the rest of their lives, or they turn it into, they find it somehow switching into a green card. And I know we didn't talk about that really too much, but there are ways to go from E2 to green card and not just EB5. I do that. A lot of my clients, we go other ways to come here. It is possible. And I get that question a lot. Like, okay, now I'm here on an E2. How do I stay here long term? And I tell them, as soon as you get in here, let's talk because let's set it up the right way so you can have, a long, long time in this country. So,
All right. Okay. So I think we have come across with lots of questions. And
great.
I can see, Jessica, we got really a great amount of engagement here. Vihan, Trizer, then Arpita, Vihan. I'm really confused whom to take first, but let's take up Vihan's question. Vihan is here asking, looking ahead to 2025, which industries or business sectors do you believe will be the most attractive for E2 visa investors, considering the potential changes? Yeah.
Restaurants are coming back. During COVID, it was very difficult. E2 companies really suffered, but they're back. Restaurants are back, salons are back. A lot of the services that people need to go into to get those services, they're all coming back. I find even a simple coffee shop does very well for an E2. You have two workers, a certain amount of income coming in. So that whole industry, restaurants, I think is very nice for an E2 and can slide you sometimes very nicely into an EB5 too, a green card. I would say other areas, I think real estate will come back, not flipping houses, but could be all sorts of things related to real estate. It could be property management companies. It could be any kind of renovation business, like window wiping business. All those areas that are related to real estate can come back too nicely. And it could be something completely like, who would think like a dog grooming business? Well, there's never a shortage of dogs. So those kind of like narrow, even newspaper, like, I don't know, some people have newspaper routes and stuff, and that like we get creative. The point is like there are certain industries that, yes, I think will be more popular now because now that COVID's long gone, they will be better. But we don't care what industry it is. Like we'll try to help you. If you have a dream, I always tell people, if you have a dream and you want to make a business in the United States or buy, let's help you because I want you to buy something you like. I have clients call me up, they're desperate, just find me anything, whatever. I'm like, no, you really should find something you like because you're going to spend your time building it. So,
Absolutely. That's very well said. Thank you so much, Jessica, for putting up this very interesting, I would say, information. And Vihan also, thank you so much for putting up this question. In case if you have any follow-up question or would like to know more from Jessica, then please go ahead and ask those questions. Santosh is here, and Santosh is asking, are there any expected changes to the process for renewing or extending an E2 visa? For example, will there be more leniency or stricter evaluation process after 2025?
so there's two ways, as you can see here, renewing or extending, you said. If you do what's called a renewal of your E2 in the United States, you get 2 years to stay here. Those cases, I believe, are scrutinized more. and you don't get a chance for an interview. But there are situations where people just want to renew here and they don't want to go to a consulate to get another E2 visa. So when you have that, they're going to scrutinize them, and they could scrutinize them more, meaning they're going to look at, tell me about your gross sales. Let me see your tax returns the last few years. Were they positive? Do you have a positive net income? Do you have two full-time employees? Did you have a gap and you didn't have two full-time employees? Why do you have a gap? So these things are going to get scrutinized, I believe, more if you do it as a renewal in the United States. In terms of going to a consulate, again, it's so based on what officer is interviewing you, right? So you could have an officer that knows their stuff and knows exactly what to ask you, and one that's clueless, and you're just like, why are they asking me this? My attorney prepared me, and it makes no sense, but they have the power. So they have the power. They can ask you whatever within the requirements of an E2 to evaluate it for the strength of it. But I think the E2 visa interview is your chance to address any questions, any concerns they have. And I think, will they scrutinize it more? I would say the general trend is right now that everything's getting scrutinized more, but I don't see it to the point that it makes it so difficult. E2 visas overall, it's very, it could be 80, 90%, like a huge number get approved. It's a very high number of the approval rate for E2 visas because we don't file them unless we think you have a very good shot at it. We're not going to waste everybody's time and everybody's money. So that's where I see. Will there be more leniency? I don't see leniency. No, I don't think we're going in that direction. But I don't see it's an impossible situation. But I do think consulate processing still is a little bit easier than doing a change extension of status in the U.S.
All right, all right. Okay. Thank you so much, Santosh, for putting that question up. And let's move ahead with Ananya's comment. Hi, Ananya. Thank you so much for being here and participating. Ananya is asking, with the potential changes in the E2 visa policy in 2025, do you anticipate that there will be variations in eligibility for investors from certain countries?
Hmm. So, as I work mostly with Canadians, or at least half my clients are Canadian, when I saw in the news all the things with the tariffs and restrictions, and I thought, oh, I wonder if they'd stop their treaty. I still think they're very close, and I don't see that happening. I mean, don't quote me, whatever. But where do I anticipate any variations or changes? It's really the regulations are codified and there's certain set criteria. So if a consulate wants to be more specific, like the UK is like, okay, we have a 1 year physical presence requirement in the country, consulates can do that. But the overall requirements, I don't see. I don't see that there's going to be a lot of variation. Even in countries, I've done E2s in so many different countries. It's the same criteria and it hasn't changed. I could just see maybe like what happened in France. Like a country says, no, we don't want 5 year visa anymore, with America. So they change that. So some of the terms of the agreements, the amount of visa, also the filing fees can change. They could increase them. You could have a larger filing fee when you apply for an E2 visa in certain countries. So some of that stuff, but not the basic criteria. No, I don't see that. I don't see changes in that.
All right. I think that's a good thing, if not the basic things are being changed.
It is because it's a great way to come here, and people they think, oh, it's $1,050,000. It's not. They get confused because EB5 is the 1,050,000. E2 is tiny, way tinier, and even though $100,000 is a lot of money for people where they make so little per year, 100,000 is a very big figure. So,
Yeah,
but it's not, you don't have to hit the 100,000 for an E2. You just has to be. It makes sense. What you've invested makes sense for what you need to run your business.
absolutely. And that's the main important thing that everyone is noticing.
Yeah.
All right. And okay, so here's another question from Ananya, that are some countries expected to benefit more than others from these changes? All right. Okay.
Well, see, there aren't a lot of changes taking place, except some of these, to not have the interview for the E2 visa, that it was
Mhm.
waived. So certain countries, then things would process a lot faster. So now, if they have to have interviews all the time, every time you want another E2 visa, certain countries, the E2 visa is not 5 years. Sometimes it's 6 months. Sometimes
Yeah.
it's 1 year. So you have to, every time you want to come to America, you can come in, you get your 2 year stay, but when you leave, if your visa is finished, you got to go get another visa. So some of these countries, they don't qualify for a waiver of the interview for the E2, it's going to get backlogged. Do I know all the countries this is going to happen to? No, I don't know precisely which ones, but it could cause some delay in some of these countries. But there's always expedite request. If you need it, if there's a real emergency, you can try to approach the consulate and ask for an expedite, and it's up to them.
Absolutely, I'm sure. All right, the contact details are on the, I would say, the end of this bar you can see. And with that, thank you so much, Ananya, for putting up this very important question. And let's take up Raghav's comment here. So Raghav is asking about, can you explain how the revised E2 visa requirements will impact the duration of the visa and the possibility of renewal or extension for investors?
Well, there aren't a lot of revised E2 visa requirements other than the waiver interview has changed. That just changed.
Mhm.
The impact of it, well, right now, some of these consulates, it's 2 or 3 months, right? They have to review the file. They take like 2 months to review it, and then they schedule you for the interview. So will it get worse? So then they could take longer. Some consulates could take 4 or 5 months, so it could cause a delay in that sense. In terms of it says extension. So extension's different because that's in the United States if you're extending the E2. So when you
Mhm.
extend the E2, what are any of the revised changes or anything? Well, again, if they're going to see that you have employees and there are very few Americans that you hired, they could come down tough and say, please explain your strategy for hiring more American workers. We'd like to hear it. So we don't know how that's going to filter in to the cases in the queue or the ones that are just going to get filed. What we do know is that if you have strong gross sales, usually if it's a small company, we see a couple $100,000 in gross sales. We see a net income with, even if it's 10,000, it's a positive net income. And we see over several, the financial statements look good. You should be okay. You should be okay for your extension. And we tell them, you got to work on it. I have clients that they have problems, that their financials don't look right, and it comes time for the E2 visa renewal. So what we tell them is, if you have a 5-year visa and you have, let's say, 6 months left on it, we tell them leave the country, re-enter. That gives you another 2 years to stay here. Because every time you leave and re-enter, you can stay another 2 years. So
Yeah.
the EU visa, although it's going to expire while you're in this country, you still
Mhm.
get to stay another 2 years, which gives you maybe another two tax returns possibly to fix the problem. Because if they can see that your most recent tax returns look good, then
Mhm.
that's what helps get you that extension or the renewal. And so that's what we tell them. We have to strategize sometimes so that they can have the strongest case. And sometimes we can't. Sometimes we just tell them it's a mess. Your E2 is a mess. You're not going to get a renewal or an extension. It's time to close up shop and do something else. And if we can transfer any of the assets and they start another E2, we try to help them with that too. Because we don't want to give them a dead end. We want to find a way for them to stay here. That's what they want. That's our goal. The worst thing an immigration lawyer has to do is say, I'm sorry, there's nothing I can do. Please leave. You have to leave the country. That's the worst. If we have to say that, it's like, it's so sad. I spend all day because I do all different types of cases, marriage cases, telling people, okay, you're getting married, congratulations. I have to tell a guy, fly to Vegas to get your marriage certificate faster than whatever. I tell people all the time, leave, stay, when are you getting married? Are you buying this business? These are critical things for people's lives, but we
Yeah.
do it because we want to make the best case for them.
Absolutely, that's beautiful. Thank you so much, Jessica. For putting these very important pointers, and that too in a very positive way. Our viewers are really filled with lots of positiveness, and because
It's
they
good.
learn about two visas, and
It's a
I'm
stressful time for me, so I'm glad that I can give that positive over because our field, I just attended an immigration conference last week. There were 2 classes on happiness. And I'm thinking, what do you need to give us happiness classes for? But our field, it's so stressful because we want to help everybody. And the Trump administration has so many laws and executive orders and things coming our way that we just have to digest it all and just try to do the best we can. We have
Mhm.
clients, yes, we have to tell them it's over. There's so many things going on right now in our field. But we try to give positive. Positive is that E2 is still a great way to come here. That's the positive.
That's great. All right. Thank you so much, Jessica, for putting that up. And Raghav, also, I hope you got your answer. In case if you still have any follow-up question, then please go ahead, and we are definitely going to answer that. Arpita is here. Arpita has another very good question. That what is the potential for increased scrutiny in E2 visa application due to the 2025 changes, and how can investors navigate these challenges?
So we are like a surgeon. We go at the case like everything that there is a gap or something that doesn't seem right, we're like, fill that gap in. Okay. So we start with, where did the money come from? Tell us all the sources. One guy says, "Oh, I didn't have to pay taxes on it." I said, "Give me an accountant letter explaining why there was no taxes required, because immigration doesn't know your tax laws and how they work." Then the money's transferred. We show the proof of that transfer. We explain where it came from. We have them sign a detailed statement of the source of the funds. We deal with every issue of the E2 case as precisely like a surgeon as we can, so we can leave no gaps. And that is what we're doing more than ever. That's one of our bigger changes, is that we always filed strong cases. We did our best. But based on my experience and what I know now, when my clients give me feedback after interviews and things, you know, this is what we have to do now. We have to make it even more precise. We don't want a client coming back and saying, "We hired you, you had all this experience, and what happened?" We're like, "No, we're covering." And even when a client pushes back and says, "I gave you enough stuff, why are you asking for more?" We tell them it's 2025. Trump's our president. We have to be even more precise. So that's what it's done. That's what 2025 will be more about. A lot more precision than what we do.
Right. All right. That's great. Okay, thank you, Arpita, for asking the question and participating in our webinar. Pooja is here with another question, that what are the most common challenges that investors face when applying for the E2 visa? And with the anticipated changes in 2025, do you foresee any new obstacles for applicants?
So obstacles is something that's negative. I want to say E2s are there's there's a path. There's a way to come here. There are great opportunities to come here. So I wouldn't say I foresee obstacles. I foresee opportunities. There really are opportunities. I mean, I have clients that search and search and search for businesses, can't find anything that exists, and they're like, "That's it, I'm creating my own." That's an opportunity. They're creating their own business. And then we talk about how being very precise of all the things that we need, and they have to get their funds in order, but sometimes they'll contact me like a year before they even start the R2, because they just want to make contact with an immigration lawyer before they start the whole process. They want to understand what are the challenges, what are some things I need to be aware of. Like, I'll have a client call me up and say, "Well, I have $100,000 and I gave it to my friend in the United States and he's going to put it into the business." And I'm like, "That's not how you do it. It has to be in your name, and the transfer has to be from you. You can't just give it to a friend for an E2." So they'll call me if they made a mistake, and I'll be like, "You should have contacted me 6 months ago." I've had clients have to redo deals because they don't set them up right. I've had a client that said, "Look, it's $1 million. I'm going to put 200,000 down. I'm going to do a seller carryback note for the other 800,000." I said, "Well, look, it's not really going to work because substantial investment. They look at what it costs to run the business. But tell me about the business." So he says, "Well, it's really a building. I'm buying a building, and the active part of the business is really 200,000. 800,000 is the building." So I told him, "You know what? Break it up. Have a contract for the building, 800,000, and pay 200,000 and buy the active part of the business. That's your E2." And that's how we do it. Because otherwise it makes no sense. You can't really do not like you securing a loan from the business that you're buying, because they're afraid they give you the visa and then all of a sudden you're like, "Oh, company didn't work out, but oh, I still have the visa." They don't like that. So.
Absolutely. And I think those are, very important guidance that our viewers should really know about, because just for the sake of friendship, they are being into such a big obstacle. But I think that's not how it should work. So I'm sure that these pointers are really being going to helpful for them.
Sam,
So
I
yeah.
would just tell you one other thing also, that I feel like sometimes people are discouraged because they need it to fit into a precise box in order to work for an E2. But we don't do it that way. We look and we see what you've got and what you want to build and what's going on right now. We try to make it work if we can. We try, because they bring us their dream businesses and we're like, if we can make it work, we'll try.
Mhm. All right. Okay, let's move ahead with another question that I got from Vihan. Vihan is here asking, what are the specific legal and financial risks that investors need to consider with the revised E2 visa guidelines in 2025, especially if the investment does not meet expected returns?
So on your business plan, you have the projections in 6 months, what you're hoping to get from the business, in 1 year, 3 and 5 years. They do not lock you into those projections. Those are just rough estimates. So if you can't bring in what you thought you'd bring in, they're not looking at your case every year. Only when you do your E2 visa renewal or you do your extension of E2 status. And then they're not going to say, "By the way, you said in year 3 you were going to make this kind of money. So what happened? Case denied." It's not
Mhm.
like that. Those are just projections. What's really important is they want to see, do you have enough money to pay your bills? And let's say you don't. Let's say 1 year you don't have enough money. So let's say you're a wealthy individual and you're going to put more of your money in to help the business grow. Well, you're going to have to explain that. If it comes time for the renewal or the E2 extension, you're going to have to explain, look, I had difficulty. It could be an industry that suffered, or you could have been, let's say it was a hurricane or something happened and it's explainable why your business suffered. Then you can explain that when you file your case. And usually with a valid explanation and to show the potential for growth that you're coming out of that rut, you should be okay. So it's just very case specific. If there's really financial loss or risk and what happened, we have to explain it.
All right. Okay. I think let's take Trizer question here. And Trizer is asking that, hi, I have a business partner. We are in the process of starting an offshore IT and production studio. Now, during the E2 application, which should we focus on as a company works on both aspects?
So I will just wonder where this business is located. Okay. Because if it's offshore, and they also have a production studio. So I'm
Mhm.
wondering if the production studio, I assume it's in the United States. So this is where we talk about how much time does the person physically as the investor need to be here. We want to make sure we build something here that they have to come and check on regularly. Otherwise, it becomes everything so remote it doesn't work. But the focus should be on the sales, the clients, the employees that they have. That's to build it up. That's what I would say, and make sure that there's enough activity going on in the U.S. It's not all offshore.
All right. Triza, you could let us know from which location you would like to have a business on, so that we can give you a better advice on that. Next, I would like to go with Srujit's comment. Okay, and Triza here also had a comment that your show popped up on my feed. Found it interesting.
I try.
Absolutely. It's really interesting. Okay, we are based in India.
Oh, India. Okay, yeah. So that's pretty far. Okay, so he just needs to the production studio. I assume it's in the U.S. That's why he's wanting to come here. By the way, this is all about E2, but don't forget there's something called E1. So if he has a majority of the trade or services are between the US and their home country that they're providing, then that could be an E1. And majority means substantial means at least for 1 year, there's been trade or services. And substantial is usually 150, $200,000 in sales, but it could be anything. It could be services like IT services. It could
Mhm.
be trade, it could be a product that's made in, let's say, India, and they're selling it. Majority of their sales worldwide are with the United States, and they're substantial. That's E1. I didn't say anything about the amount of investment. There was no substantial investment. It is an easier way to come here actually than an E2, but you have to fit the box. It doesn't always fit for people. So it's out there though, E1. And we have to have a treaty, of course. So
That's right. All
yeah.
right, Trizer, I hope you got your answer. And in case if you still have any follow up, then please let us know. Meanwhile, Jessica, we also have some questions from our Facebook group as well, because there also we have a lots of viewers over there. So I think let's take some questions from there as well. So here's another question: that can we travel on B1, B2 if we have applied for EB2? Any issue in it?
Okay, so EB2, employment based, that's the second preference. um, so that's green card application. So B1, B2 is temporary. That's a way to come here as a business or a visitor. So the question is, what ties do you have in your home country? And when you're coming in as a visitor, does a officer who's uh, seeing you when you enter America, does CBP really believe you're going to return? So just having an application in the system doesn't mean you can't come in on a B1, B2. But if the officer sees it and feels you don't have enough ties to return to your home country, then they don't have to let you in. So we do entry packets. We put together a whole package showing what your ties are there, what you're doing here, and then we prepare you. So hopefully you can get in, because the process can take a lot of time. It can take several years before you actually get the green card.
Yeah. That's right. Okay, let's go ahead with the next question. Hi, I'm an E2 dependent spouse, currently pregnant, due on March. Will the birthright citizenship removal take effect that soon, or will it be on hold due to 22 state lawsuits contradicting it?
It's on hold. They're waiting right now. It's being litigated. So I don't know what's going to happen. We don't know if it'll take
Mhm.
effect. Yep, stay tuned. But anyway, March is pretty soon. So it's on hold. So having that baby in March It sounds like you'll be okay, but who knows if the courts speed up the case or not. But yeah, we don't
Mhm.
know.
Absolutely. Let's see what comes at the end decision, and we all are hoping for the best. All right, let's move ahead with the next comment.
It's the same thing, the birthright issue, right? It's a problem. Non-immigrants who have kids born here, this
Mhm.
is what it's about. They don't want to give them citizenship. Trump doesn't want them to have automatic citizenship. So yes, they are affected by this if the rule goes into effect. And then there was going to be a procedure. There should be something in place of how they turn into an E2 dependent, right? Because if the kids were born here right now, they're probably not E2 dependents. So there has to
Mhm.
be some procedure in place to get them the proper paperwork.
That's right. Okay. I think we got this another question. And Control, if you could let us know about that question, please. Okay. I think we might have. Okay, I think Jessica, there might be some technical issue regarding the FB questions, but not to
Oh,
worry. We do have still a lot of questions, from our viewers. And okay, let's take up one or two questions lastly, and then okay, here we have Yash question. How will the 2025 E2 visa changes affect the ability of foreign investors to hire employees from abroad, especially from their home country? And are there additional steps they must take for this?
so I think that they're referring to the E2 qualifying employees, right? So you can be an essential worker, you can be a manager executive. So the criteria, again, everything will be scrutinized. We need to be more precise, but same criteria. You have to have the same citizenship as the E2 investor. You have to be coming here to work in a capacity as a manager executive or someone with specialized knowledge and skill. And you have to show that you have that experience to do that. So, and then they issue you the visa. And depending on our treaty, how long that visa is valid for, and the dependent spouse can work
Mhm.
while you're on your E2 qualifying employee visa. So, yeah, that's the process.
All right. Okay, next up, let's take up Kunal's question. Kunal is here asking, are there any new pathways or benefits for investors looking to transition from an E2 visa to a different permanent visa or green card options following the changes in 2025? Yeah.
It's a very interesting question because right now, the EB5 is the most popular way. And it was not the most popular way because it was such a long process. It was like 4 or 5 years. Now it's a 2 year process because if you're an E2 and you file the first part of your EB5, you can file the second part, which is called adjustment of status, together, which means you
Mhm.
can apply for a work permit and travel document. The whole thing can be filed together. Some of these other categories, you can't do that. EB2, EB3, you can't do it all together if your priority date's not current, which it's not for these categories, but EB5 is for certain categories. So this is becoming popular. And what's also becoming popular is the regional centers. So regional center says you need to invest $800,000, not $1,050,000, and put your business anywhere you want. You invest in a regional center. So I asked one of my peers, I said, what if you don't have $800,000? And he says, you would be surprised that people either take equity from their house, they have relatives that are wealthy, they are gifted money from friends or whatever, and they make it happen because they want that EB5. And this right now, we see that EB5 is getting very popular. And I used to say EB3 was the way to go, but it's backlogged. And and EB5 really is, even though it's a 2 year conditional green card you get, if you've invested the money, the regional center helps you create the required jobs, and then you have to remove the conditional status after 2 years. But people are doing it. They're finding ways to get that money. But that's what I see for 2025. EB5 is very popular.
Absolutely. That too. Thank you so much, Jessica, for taking all these questions very patiently and answering them in a very detailed way. So again, I would say thank you so much. It's really appreciating. And I think, Jessica, we already crossed 1 hour. So with your
Sure.
permission, I would just like to know, would you like to answer more questions or should we put an end to it?
I think a lot of the questions are a little bit similar, like because they want to know in 2025 what are the changes, how will it impact them, and I think we addressed a lot of them. So I
Yeah.
think that's good. I just want to share one other thing that I offer a free brief consult so people know to anyone who is thinking about doing an E2. It's usually 10 minutes or so, but it gives them a little bit of direction because a lot of lawyers just they get on they're going to have a consult charge right away. But a lot of people just want to get some of the foundation. And also, my website is very helpful. I made charts that talk about the E2 process along with other processes, and it shows the steps and stuff involved in the requirements. And I think that's really helpful too. So if people are thinking about, okay, this E2 sounds interesting, that's where I would start. And they can always reach out to me. But I think for now the questions, because they're all a lot similar questions, that I think we've addressed, like what changes 2025 and how concerns and any financial concerns, and they just have to like find that right business and just call an immigration lawyer or me, and you know just get started.
Of course, they will, because I can see a lot of questions here, on our webinar, and because viewers are really loving this episode and they are having a lots of queries regarding that. But don't worry, friends, keep on posting as many questions as possible. We are definitely going to take them up, maybe if not in this session, in our next session. But with that, Jessica, thank you so much. We have come across 1 hour. We didn't even realize. So it was your first time with us, and it's not only me who enjoyed. I think everyone enjoyed this session a lot. So we are really honored that you are here. Thank you so much for taking up this time and investing it here. So we really enjoyed, and thank you so much for being here.
And thank you so much as well, because I love educating people, and without education you cannot make the decisions. So that's what I do. I give you all the information, and the client makes the decision what's the best for their family and their lives. So thank you very much.
That's lovely. We love the energy that you bring us in this show, and also the insights were that too very helpful and wonderful, I would say. So again, thank you so much, Jessica, for being here, and we are looking forward to have more shows with you.
Thank you.
All right. Thank you so much, everyone, for being here and asking a lot of questions. I'm sure if you guys are not very much happy that we didn't take your question, but don't worry. We have asked all the questions, and in the next show we are definitely going to take them up. So till then, don't forget to like, share, and subscribe to Immigration Talk Show. We'll be coming up with very exciting webinar, and that will be lined up just for you. So make sure to press the bell icon also, so that you can get notification whenever we come live. Until then, everyone, take care. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. It's me, Sam, signing off for now. Goodbye, everyone, and take care.
Hello, everyone, and welcome to Immigration Talk Show. I'm your host, and I'm going to be with you for this next hour, this session, which is lined up for you, a very interesting one and a topic which you would love. So stay with us. And before we head on with the discussion of the day and also have our guest join us, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. use of information is at your own risk. So, friends, I hope that you've kept that in mind, and welcome once again to Immigration Talk Show. And today's lined up discussion is going to be a very interesting one. The topic of discussion is, can H1B visa holders be detained? And we're going to try to understand the immigration policies and also the risks involved. But yes, there is increasing immigration enforcement, evolving policies, high scrutiny, and so much happening, right? Especially with this new administration coming into the picture. Well, we also have many H1B visa holders and employers who are very concerned about the potential risks, and especially when it comes to compliance, legal pitfalls, and even detention for that matter. So, today we're going to discuss with none other than this very distinguished guest who's going to join us today, and she's none other than Isadora Velasquez. Yes, please help me welcome her. Hi, Isa. How are you doing today?
Join you. Well, very happy to join you. I'm doing very well today, and I'm sorry we have to discuss this topic, but I think it's really relevant, as you mentioned in the introduction. There are detentions going on today. It is a bit of a promise that we had from the administration that took over. So it's good to know our rights and what we can do to protect ourselves, and whether we can run the risk of detention under this current precedent that we have. So I'll let any of you ask me questions, including, of course, of you, Nipasa. So take it away.
Thank you so much. And folks out there, we have attorney Isadora, who has dedicated over 15 years to immigration law, fighting for individuals and families, in a wide range of cases. So please feel free to join us with your questions. And yes, we also have a phone number actually where you can on call to ask the questions yourself and maybe even get onto a short discussion. And the number is 425-436-6335, and the access code is 988-888. So, yes, Isa, like you said, this is a very timely topic, and it's crazy because it's not like earlier, when you talk about H1B this year. And there have been changes, of course, since fiscal year 2025, we saw that. And now the fee hike, and so many things are, governing what is happening to H1B right now. So, where should we start? What can people out there expect from today's discussion?
Okay, so when it comes to detention, I want to point out that it's not that the law itself has changed. Nothing has actually changed when it comes to detention. The elements, the requirements to detain anyone in the United States are the same. What has changed is the intensity in which these detentions are occurring. During the campaign, we heard a lot from the Trump, or current president, about conducting mass deportations. In order to get to the level promised, detentions had to occur. What we've noticed in the first 100 days of this presidency is a large volume of detentions. Most of them have not led to the deportations promised, because there are due process and steps that need to be taken for these deportations to occur. People have rights, and you can present your case before a judge. But we have noticed that many cases that normally wouldn't lead to a detention, that would normally lead to a case maybe let go or just overlooked, are now being processed in detention. So that's why I appreciate having the opportunity to explain when a case, particularly an H1B visa, could be subject to detention, so that we know it's not a change in the law. It's just something that we need to be on the lookout. Obviously, the most common way is we need to understand that a visa can be revoked in all candor for any reason. The U.S., the same way they issue the visas, they have the authority to revoke said visas. The most common way to revoke a visa is when we are accused of a crime. This is an important distinction, because we don't necessarily need to be actually convicted of a crime. The simple accusation is enough. And this is also important because the government recently passed significant law, a new law called the Laken-Riley Act, that also encourages the government to actually seek forward detention of anyone accused of certain crimes, particularly violent crimes or crimes of theft. So keep that in mind, that if you are accused of a crime, of course, that will lead to the revocation of your visa, but it would definitely lead to your detention, but based on this new law. If you're coming into the airport, that is typically the most common way for H1B holders to be detained, because that's typically the most common way in which they tend to find out whether or not their visa has been revoked. Based on past experiences, the Muslim ban was very controversial back during the prior Trump administration. And it was a very controversial way in which people found out their visas being revoked. And it actually led not so much to detentions, but to people not being allowed into the US, even when they had a valid H1B visa. So far, we haven't received any announcements of any potential bans. We have received potential travel bans for particular countries such as Cuba and Haiti. They have yet to go into effect, and we don't know if they will affect visas such as the H1B visa already issued. We will keep you informed if that were to happen. But revocation of visas, to answer the broad question, would be the main way that H1B holders would be detained if they're already in the US. And now, if they're coming into the US and they seek to come in, they could be detained seeking to come in, if they're either to be returned or to simply not allowed into the country.
And when you talk about the Muslim ban, I'm sure you know there are folks already in the United States from maybe few from those countries. What's going to happen to them?
Well, the Muslim ban, although it was upheld by the Supreme Court, what was interesting about that particular section is that it only affected individuals who were already out. So if you were in the US when the Muslim ban went into effect back then in the prior Trump administration, it didn't revoke your visa in the US. It simply meant that when you were trying to come in, you were not allowed into the country. It did force many attorneys like myself back then to make sure that the visa that you had, that the status that you had was being enforced, because there's a difference between seeking admission. When you're coming into the airport, you're seeking admission, and that's where people found that their valid visas were not eligible to come into the US. But for people who were already in the Muslim ban, they were already admitted, they already had a valid I-94, and although their visas may have been revoked based on the Muslim ban, meaning they couldn't no longer travel, their I-94, which is the document we received letting us know how long we could stay in the US, allowed the individuals to stay in the country for the amount of time allowed. So for the individuals who are already here from the countries listed in the Muslim ban, they're okay as long as their I-94 allows it.
That is very interesting. And I think at this moment, we should just not travel, stay in the United States. And what do you say, Isa?
Yes, I would recommend. I know it sounds sad and extreme, but I agree with you, Nipa. I think if you have your I-94 and it has a set amount of time, very important. I encourage anyone watching, check your I-94. If you don't know where to have it, you lost it, you've never had it, I maybe we should put it on the chat. There's a website where you can find the status of your I-94. And once again, this document is the one that tells you how long you're allowed to stay in the US, and take advantage of it. It will tell you when you're supposed to leave. And as Nipa said, don't travel unless you have to. I know it sounds sad. We want to visit our friends and family, but now is not the time. Things are interesting. There are many changes happening. We wake up every day to a new executive order. Until things settle down and we know exactly what's going on with immigration, let's stay still and not travel for a while.
Yes, good one. Thank you, Isa. And with that said, and what you were just speaking earlier, do you have any cases or examples of recent cases this year, where H1B visa holders were actually stopped and at the airport and even detained for that matter? And what could be the main reasons?
Yes, and I'm actually going to go and take advantage to answer your question and go ahead and answer Vika's question. So Vika's asked about she has been on H1B for 3 years and heard about somebody getting detained at the airport after returning from India. Why would this happen? That has actually been a case that I have dealt with recently. People returning with H1B. Why would it happen? And that's why I gave the example of my clients being accused of crimes, returning on an H1B and getting detained at the airport, and at the airport finding out that the simple accusation, what we sometimes may call an arrest warrant, was enough to have that visa revoked. So it's very important that we keep track of our visa the same way I mentioned before, keeping track of our H1B. We need to understand that the US, when it comes to visas, and this is not just for H1B, it can apply to a student visa, it can apply to all visas. They can't be revoked unilaterally by the United States government. So if a visa is revoked, you could be detained coming from any country at the airport because you are seeking admission. Now, when you're detained at the airport, one of two things could happen. The government can ask you to withdraw your admission, which would mean that you're simply choosing to go back, or you can state the reasons. You can try to fight your admission. Understand that if it is that your visa is revoked, they have to state the reasons, but they also can, coming into the US is the analogy of coming into the club. If I don't like your outfit, I can tell you no sneakers allowed, and I'm not going to let you in, and I'm not going to let you in. The only people who are allowed into the club all the time, no matter what, would be US citizens. Not even residents have the privilege of going into the VIP room all the time. So because of that reason, keep in mind that even if you want to fight for your right to get in, you might not have the right to do so. The only way to fight all the way to get in is if you're seeking asylum. So the only way to actually push for your entry would be to seek asylum, argue that you're afraid to go back home, have a credible fear interview. Be very cautious with this, as they would close your door to go back home. Personally, I would not encourage anyone to seek asylum, to have what they call the credible fear interview, unless it is absolutely necessary. Coming into the US seeking asylum solely to continue working, I do not believe it's the best choice if in case a visa has been revoked and for any reason they're not letting you in. The,
Well, yeah.
the question continues to worst case scenario, if you get detained, how long could you be held in the process to get released? And I kind of hinted as to the worst case scenario. The worst case scenario is when they're not giving you a chance to explain, when you haven't been allowed visas at the airport in particularly. It's not a place where you can appeal a decision. Once a visa is revoked, there's not an appeal process. It's not when a visa is denied at the embassy where you can apply again. It is revoked at the airport. There's not an appeal process. You could be detained up to 24 hours until they send you back. So the worst case scenario would be just that you have no other choice but to seek a credible fear interview in order to come to the US. Understand that, for example, if your visa were to be revoked, as one extreme example, because they think your employer is not real, or because if they're a student and they think you're not studying full time, or the example I gave because of any criminal history, you don't
Mhm.
have the right to appeal the particular circumstances of the revocation of your visa at the airport. You can only fight to come to the US to seek asylum. So that's worst case scenario. You can only either go back home or seek asylum to come to the US. Sorry about
Okay.
that.
I know it doesn't sound really pretty, but also when you talk about, crime, I mean, for a person under H1B, crime, whether you're talking about the home country or in the US or both ways, it's still
Both,
a crime.
both. Keep that in mind as well. Sometimes it's a very interesting question because we are asked, have you committed a crime? And we tend to respond, where? I understand that when ask the question, it means anywhere. And technically, they do have access to all the records anywhere. So we may
Mhm.
think, oh, but I have never committed a crime in the United States. But what about that DUI or that minor marijuana charge that I have back in Canada? Well, the US may be aware of it, and maybe it was legal over there, but it's not legal here in the United States. We need to be very conscious of that. And sadly, these are minor things that they can use against us. And again, these are minor things that you can fight and appeal to reapply for your visa. But there might not be things that you can fight and appeal to enter the US in case you're stopped. And there might not be things that you can fight or appeal if you're in the US and you are detained to seek your deportation. And we need to make that distinction. There's a big difference if you're detained coming into the US at the airport, in which your only choice would be to, like I said, seek asylum or get kicked out,
Mhm.
or if you're in the US and you have an encounter with ICE officers and you are detained in the US in an encounter with ICE officers and you are detained, you do have certain rights. Only an immigration officer can remove you. I'm sorry, an immigration judge can remove you. If you have been in the US for more than 2 years, and this goes back to the individual who mentioned that they have been in the H1B for 3 years, If you have an encounter with ICE and you are detained not at the airport but in the US, you have the right to appear before a judge, even if your visa is revoked. And there you may have the right to fight for why your visa may be revoked. So that's the big difference between at the airport, where your rights are very limited. You may only have the right to go back home or to fight for asylum, while in the US, where you can fight for why is your visa being revoked. Is it because they're alleging that your job is not real? Is it they're alleging you're not really a student? You can fight for it if you are detained in the US, while it's different if you are detained at the airport.
Okay. Thank you, Isa, for taking that up. And it relates me to this question from Chandra asking, if I get arrested for something minor while on H1B, does that automatically put me at risk of detention?
Yes, because and I'm sorry to answer so quickly and so adamantly, but yes, because technically the Department of State can automatically revoke your H1B. We see that this used to seldomly happen. If it was something minor, shoplifting, smoking a joint, we noticed that H1B wouldn't be affected by it. But lately, or in certain administrations, H1Bs could be affected by a minor DUI. So keep that in mind. Because the H1B could be affected by minor crimes, any visa could be revoked by minor crimes, leaving you without status. Yes, you could be detained by being without status. If a visa is revoked, you lose your I-94 status. The argument here would be that you remain legal until your I-94 expires, which is why I encourage everyone to keep checking your I-94 regularly, because the defense for anyone whose visa is revoked while in the US is that you're still allowed in the US for the time allowed when you came in on your I-94, which once again is a document you that allows you to stay in the US for the time mentioned in it.
Mhm, mhm. Right. And, before we really started this program, we were talking about scrutiny, social media. So, of course, there has been a lot of changes, especially with the new administration coming into the picture. It's President Trump now. And how has these, latest immigration policies changed things for H1B visa holders? You're saying that there's not real change in law, but there are changes happening and it's governing. Even it's affecting H1B visa holders for sure. So, are they facing more scrutiny now?
Correct. You will notice that your applications will get a lot longer. They will include a lot more information that are already there, but in greater detail about your social media. You may notice the lines at the airport also getting a little bit longer, maybe because of shorter staff, but also because this already started before, but now it has been announced that it will be done with greater scrutiny, as Nipa mentioned. The going through your phone, the checking your social media, and by the way, this is also going to be done allegedly to U.S. citizens, and it's not just with this administration. It was announced with the prior administration as well. But it has been emphasized that for all visas, not just H1Bs, there will be greater scrutiny placed on social media. And now, once again, your phone, your WhatsApp messages. I personally encourage my clients, all of them, to delete social media when you're coming in through the airport. Then again, I must confess, officers do ask you. They find it rather suspicious that you don't have TikTok or WhatsApp or Instagram on your phone, especially depending on our age when we show up. So they will ask you about it. So just be ready to answer. Maybe you're a very healthy individual who has no need for social media. If you're an individual working on tech, it might be kind of interesting if you don't have any of it on your phone. So just be ready to explain it, because yes, there will be a lot more scrutiny on it. And we do expect the visa applications and renewals to include many more questions and to get a lot longer. They keep growing every year and they might be getting longer. If we have any repetition of the 4 years before that we had with prior President Trump, we know that a lot of money was spent investigating people, and this is probably going to be another year, another 4 years of more investigations, just to make sure that when visas are approved, your background check is very clean.
So true, so true. And I think we would just have to say goodbye to side businesses, whether it's even selling a small thing or making a small amount of dollars. But I think, yes, high scrutiny is just going to be there, not just now or just for the next month, but I think it's going to prevail for the whole of Trump's 2.0. So let's get ready for all of that.
Yes.
And Yeah. So also, Isa, if you could also tell me about the the talk about fairness for high skilled immigrants act. There has been this talk, and could this really help H1B visa holders feel more secure, or does it not really affect detention risks?
It depends who you ask, because the focus of the act has been more on the caps, and but the caps on country conditions, on certain countries, and saying that some countries, particularly India, would be more delayed because there are certain visas issued per country. This is the most you can get. That has been the focus, to make it fair for everyone. No caps. We're just going to apply blindly for everyone. Some people say that's not fair, because for example, the visa lottery, which is a separate visa, is based on people who can't come to the U.S. On other visas, and they apply to the visa lottery because there's not enough diversity of certain countries inside the US. So that's the balancing. There's a lot of debate on it. Personally, the President Trump recently issued an address to Congress in which one of his few remarks on immigration said that the government didn't need immigration reform. It just needed a new president, and he was it. So I do not believe that this act will actually be approved, at least this year, for or in the near future, as long as Mr. Trump is president. I do think that if it is tweaked in certain areas, it would be beneficial, but the focus so far has been on the caps for visas, not really on ensuring that protections such as not revoking visas unilaterally are taken seriously. I do hope language is included, because I do think revoking without letting the person know it's not fair. But so far, that has not been the main focus of the government.
I know it's all surprising whether you talk about raids, you talk about anything that the Trump administration is doing just to catch hold and let you off the country.
Yeah.
So that is there. And also, I'd just like to say hi, once again to Chandra, Vikas, and folks out there who have joined us with your questions. Please don't forget to like, share, and also subscribe to our channel if you haven't as yet already. It is Immigration Talk Show on YouTube, and you can also check us out on LinkedIn, Facebook, Instagram, and also on X. I mean, it's just because we were talking about social media. I remembered that I have to do this too. So connect with us and stay connected, friends. And yeah, we have Ayush. I also was reading this news yesterday. So DHS has really introduced this new app where migrants can share their intention to self-deport. So if I
Yeah.
do so, will this ban me from coming to the US forever?
Okay, so let me explain. If for individuals, if you leave the U.S. and you have been in the United States without status, or you enter the country illegally to the border, or you've been in the U.S. for more than 180 days without status, you may think you're leaving and everything's okay, but in reality, you are deporting yourself, and which is really important. So this app, I actually think, is helpful for people who have been in the U.S. for less than 180 days without status, meaning your H1B expired, you didn't renew it, and you've been in the US for less than 6 months without status and you want to leave, it would be helpful to put it in the app, because that way the US will know, okay, you left, and there wouldn't be actual any negative consequences to you, because you didn't accumulate enough time illegally in the US to have these negative consequences. However, if you were in the US illegally for more than 6 months, the app doesn't really clarify if there will be consequences or not. It will simply say that you will be letting them know that you left. You will be helping the government because they won't have to look for you to deport you. But it doesn't really clarify. It says that maybe later on you could apply for the visa, but the government hasn't really guaranteed that it won't have any negative effect. So what I've been telling my clients is to use it only if they are sure 100%, I know I'm going to leave, there's no way I'm going to stay, I'm leaving, I want to let the government know, then yes, go ahead and use it. Might as well do it because you're leaving. You want to let the government know, but don't use it expecting that by doing so, or by reporting yourself, you're going to be able to later apply for a visa and come in with a problem. Reality is that if you stayed in the US illegally for more than 6 months, you
Mhm.
cannot return for 3 years. And if you stayed illegally for over a year, you cannot return for 10 years and you must apply for a new visa. And it may be that even after the 10 years, you might not be allowed back. So the app is a bit tricky. I think it's lacking some language that clarifies. But if you know you're leaving and you really want to go, might as well report. But don't assume that simply by reporting, you will be okay. There's another important app that I think you guys should know about, and it applies for anyone who comes in. Interestingly, for H1B in particularly, it wouldn't apply immediately. It applies mainly to tourists. Canadians, for example, are very upset over it. And the government has always requested that all immigrants keep the government informed when they're here for more than 30 days. This is an auto report app, I guess you could call it, or a system, or now all immigrants must report to the government. It's mandatory. It has always been mandatory, but now there's a specific website that we must use. I mentioned Canadians because they have always been allowed into the US without visas for up to 6 months, and now they're being forced to report, which they're not big fans of. But it has specific exceptions. For example, asylum seekers don't have to report. H1Bs, because you report at the airport, technically don't have to report. But it's important to be on the lookout because the government keeps changing who has to report, who doesn't have to report. I wouldn't want any of you to have to report and miss it and then have your visa revoked over a simple technicality. So keep on the lookout to these executive orders and memorandums that come out, maybe in case you have to put your information in another website, something simple that you may have to do depending on what the news say tomorrow.
Just like an attendance register or maybe like a biometric system. So different ways, but you still have to sign and let the authority know that you're in the country. So treat it like that. And it's always best to do your research properly and play safe. So I'd always say, if you are confused about anything, or just like Ayush has asked about this new app, I mean, consider consulting with an attorney or an expert who knows all these things at the tip of their hands, and they will guide you in the best possible way. So why not also, you can choose to consult with attorney Isadora, and you can do so by calling her on her number as well. Her number is 305-938-0676. And you can also email attorney Isadora at isalawyers.com, and go visit www.isalawyers.com. So thank you for that. And thank you, Isa, for telling us about this other app as well. So,
By the
so
way,
much
the
out
app is
there, right? Yeah.
called CVP Home. It used to be CVP1. Now it's called
Yeah.
CVP Home. It's not just a self-deport. You can also use it if you're coming to the US, maybe through the border, and you want to get your I-94 ahead of time to make it faster. You can get it up to 7 days before, and it will make your process easier. So it has other tools besides just self-deporting. Just check it out.
Yes. Thank you. Thank you. That was really a good one. And also, we have Neha who's joined in with a question. We'll quickly take that. So, Neha is asking, are there specific warning signs that an H1B visa holder might be at risk of detention? And what should we watch out for? Interesting.
Well, I recommend all my clients, and this is not just in the Trump administration, all my visa holders, when they travel, I always recommend before they come back, check your emails. The Department of State typically announces any revocations, and if they have any issues with your visas, via email. Check your status of your visa online prior to coming in, just in case. I do so as the attorney, but just in case, you can be proactive and do so yourself. Check your I-94 prior to leaving, the one that you had prior to leaving the country, if you had one. So it's good to know that you never overstayed. Just in case you're asked, when was the last time you were in the US? How long did you stay? You will feel comfortable answering those questions. Those tend to be the triggers that may lead to an uncomfortable detention. You stayed more than you had to. Your visa was revoked, you didn't know. You did something or committed a crime, or were accused of a crime you didn't know. Sometimes we leave and there's an arrest after the fact, something we didn't know. Somebody with a similar name to us gets in trouble and we are accused. So it's just good to check what we can check. When we're traveling, it's also good to have that conversation. All my clients always have my card. The airport is very tricky because it is, I call it no man's land, the same way before I compared it to a club and they have discretion to allow you in or out. You don't have the right to an attorney like we see on TV. You have the right to no, that doesn't apply at the airport. So when you want say you want to call your lawyer, you don't, that doesn't really apply. But if you have somebody's card, which is why I always tell my clients travel with my card, they can call me even if it's at 5 a.m. You can call the attorney, and they tend to have the courtesy. Custom and Border Patrol officers tend to have the courtesy, so that would be a good idea to have with you, the attorney's card, or at least somebody's card. For example, your employer, if you're comfortable with your employer and you think there might be any issue with your job, it's good to have your employer's card. If they don't know where you work, it's a new place of business, it's good to have your employer's information. Those are warning signs, as you had asked, that you can have with you. Show, this is where I work, it's a new place of business. You may not be able to Google it because it's brand new, or because understand, Customs and Border Patrol, they're not immigration attorneys, and they're not even embassy officers. They're not as sophisticated as we may want them to be, so we can educate them. So anything you can bring with you, as annoying as it may be, to make their life easier, to show how good you are, and that's why you got your H1B, bring it with you, even if your bag is a little bit, your carry-on is a little bit heavier than you would have liked. That would be my advice.
That's a good one. And thank you so much, Isa, for taking that up. And Neha has another question to follow. So, is there any bifurcated data available of people who are detained or are at risk of being detained?
So let me see if I understand your question. You mean like know your rights, or um,
I think she means like where can she see how many people are detained? Is there a website or somewhere where they can check out the numbers of
yeah.
people who are detained or who are at risk of being detained?
So ICE, ICE.gov, ICE, baby, yeah, like ICE, the ICE. GOV will give you the number of detentions, and it will also give you the number of deportations. And you'll see there's a big discrepancy. And it should have it. But until recently, they were very criticized, the numbers, because they're big. There's a big difference. The reason there's a big difference is because, as I mentioned at the beginning, it's rather easy to detain somebody. You may detain somebody because when a visa is revoked, they're out of status, or they're accused of a crime, but it's something different to deport someone. It's easy to do at the airport, to deport someone because they're seeking admission. So you can tell them, no, I'm not letting you in, and that's different. But when you're already in the US, for people who have been here over 2 years, you can't send them away. They have the right to appear before a judge. And that's where the Trump administration has face a lot of difficulty. They've noticed a lot of increased detentions, and it's been very difficult in detention centers. So you guys know there's overcrowding in many detention centers. That's why they're using other facilities, like even Guantanamo. But there's not a lot of deportations actually happening because people know their rights. They know they have the right to appear before an immigration judge, and these rights apply to all of you as well.
All right. Well, thank you so much. And Neha, yes, we've already answered that. That's correct. I would like to see the list of people detained. I hope you can find that. But thank you,
Yeah,
Neha, for joining us. Yeah, sorry.
you won't be able to see their names, but you will get an idea of how many numbers. And there's a lot
Mhm.
in ice.gov.
Okay. Well, I wonder why does Neha want to see that? I really hope that you are safe and you haven't done anything that you you would like to see or check if you are in the list. But anyway, jokes apart, thank you, Isa, for that. And also, I have another question about this. The rule for visa interview waivers, which recently changed from 48 months to 12 months. So, how might this also impact H1B holders, especially when traveling internationally?
So what we expect is that it's going to be delays. So before, particularly for any renewals, I'm telling all my clients, if you have to renew, don't wait to apply quickly. Don't any renewals, don't wait. And basically that's the main concern. Renewals are going to take longer because now they're now waiving, and like I said last time, the prior Trump administration cases were going to be taking longer. Because they're going to take longer, that's what we're expecting. Their waivers being shorter, cases are going to take longer. So expect delays. Expect that your case might take longer. So if you were planning to apply when your case was going to expire on this day, maybe talk to your immigration attorney and see if you could apply earlier. I emphasize, see if you could apply, because sometimes applying too early might not be the best choice, or you might not be even be allowed to apply that early. But check it out. We do. That's what we expect. That's typically what happens when they take away the waiver and interviews. We notice embassies are also saturated. There have been significant layoffs in the Department of State, thanks to the Dutch program. So yeah, things are gonna get slower. Be patient. Be really patient, but don't give up. Keep applying. Keep applying. Just be patient and we expect things to be slower. Apply earlier, sooner, quicker, and be patient.
Yes. Thank you for that, Isa. Great tips, I would say. And I think we should just not expect too much, but also at the same time, not lose hope, but keep trying. So, also, when you talk about H1B, it's all about big tech companies mostly, especially, and they sponsor so many H1B visas also. So, do you think their employees also have been facing more issues at the border this year?
I think it's a balancing act. In a way, I think the involvement of Elon Musk and how vocal he was of H1B and his support during the campaign, I am hoping it will reflect in how H1Bs, particularly in the tech industry, will be processed. At the same time, as Nipa has mentioned regularly, I do think there will be higher scrutiny overall, not just in H1B, in all visas. So I expect higher scrutiny, particularly in startups. We've noticed many questions on companies, whether they're new, whether they're going to succeed, whether they are stable, whether they can afford it. And that's where we expect it's going to get a little bit tougher. But at the same time, like I said, Elon Musk was very vocal in saying that he was here in the US and Tesla is successful because of the H1B program. So that's where we're hoping it will balance out. So be ready to fully understand your company, fully understand your role. So I think interviews are going to get tougher, but at the same time, I do hope that either that the numbers will get higher, that will be the effect of Elon Musk. It hasn't been announced yet, but I'm hopeful that that will happen, or that in the alternative, that it will be more understanding of how we need the tech, because once again, that's how we got Elon into the country. So expect tougher interviews, but at the same time, um, that they said it was good for the economy. So hopefully they'll keep their word in that sense.
Yes, me too. And well, news has it, especially from India, that there has been a very huge drop, when it comes to H1B applications. So I don't know what's going to happen. Will there be enough applicants also registration? What do you say, Isa?
I think with India in particular, the issue has been not so much the tech industry, but the relation between the governments. And if Trump can work better with the Indian government, that hopefully would work will lead to an increase not only in applicants but also in approvals. That distance between the relationships in the government has also, not only in the H1B area, but it has affected other visas. The lack of reciprocity and treaties between the governments, I mean, in India and the US, has affected severely the applications, and it's something that we need. Once it starts affecting the economy, I hope that Trump will extend the arm until it starts affecting the economy. I think we'll see that this will continue. But there is an employee shortage at the moment. Once the numbers start coming down, we'll see the visas increase. That's my hope as well.
Right, right. I mean, so much is happening, and like you said, every day we wake up to new news, new changes, and new rules coming up. So a lot to grasp right now, and we'll just have to wait for things and all this dust to settle in. I think after that
Yeah.
we will be able to know.
Yeah, remember, I'm sure I've seen your videos, so I know you guys are very aware that the lottery is coming up. I think also once that lottery happens and we see the numbers, that we'll get new memorandum, which goes back to our prior points as to don't travel, stay still, see what happens. We'll get new memorandums, how we see how many people apply, how many people we get in the lottery. it will lead to new decisions that will severely affect the H1B, the scrutiny, how many visas may be affected by revocations. So we have a lot that may be happening in the next in the next couple of weeks. So we have to wait and see.
We will. We will. We have no other option right now but to just be patient and still keep trying. So, all right, then. Well, Isa, Neha says, thanks for the information given. This helps. So, I'm sure. Thank you so much also to Neha, for your questions. Very interesting and all the best. So, Isa, we also have more questions from our Facebook groups, and I would really want, Control to display some of them. And meanwhile, if you could also tell us, because if an H1B visa holder gets detained or denied at entry, what are their legal options? Can they really fight the decision? We already touched on this, but what should be their next step?
Entry is very complicated because in entry you're not giving many options, if any at all. At entry, individuals who are you're called an arriving alien. Horrible name, I hate it. But as an arriving alien, you have very minimal rights. You have the right to either withdraw your admission. If they're not allowing you in, you can withdraw your admission and they'll gladly send you back home. That might be best because sometimes when we withdraw our admission, we're simply sent back home without a deportation order. And we may want that if we want to reapply for your H1B visa or for any visa, tourist visa, student visa. For example, if they were to tell us we can't find your employer, so we're not going to let you in because we're revoking your H1 visa because we think your employer's fake, that might not be the time to start arguing, oh, it's real. Like I mentioned before, I encourage you to maybe travel with documents already if you know your employer's new or not as easy to find, to show them otherwise so that you can fight it there. But if you have already tried and you haven't had success, the only other remedy, if you can withdraw and you won't be able to fight the case, will be to seek asylum, which would be to request a credible fear interview, which will actually happen or might actually happen at the airport. Or you may get called back to something called deferred inspection, meaning they call you the next day to conduct this credible fear interview. They're incredibly uncomfortable. You have to show that you have suffered past persecution by the government or an agent that the government cannot control in your country. And that's why you cannot go back, because you will suffer future persecution if you go back. By the way, if you show this, then you'll have an asylum claim and you cannot go back home. So personally, I would not recommend it. If your visa is revoked and you know you can fight this, it would be best to simply withdraw your admission, go back home, and try to fix it there. And that way you avoid a deportation order. Sometimes when we fight this and we start saying, no, you're wrong, I can prove to you that my job is real, that I didn't commit that crime, that is not me, and we are fighting it, we end up with what is called an expulsion order. And that is an actual deportation order. And we're not allowed in the US for 5 years. So you could have fixed your visa, maybe applied again for the visa at the embassy, but we can't because now we're deported for 5 years. So knowing that those are the only two choices at the airport, choose wisely unless you're really afraid to go back home and then seek asylum. By the way, warning, arriving aliens do not qualify for bond. So if you are seeking asylum at the airport, you will be detained and placed in jail until your final trial date. So another one of the many reasons why I do not recommend it.
So I like the first option. It sounded better at least.
Yeah, yes, I always tell I get sadly during this current administration, I must warn you guys that I have been receiving phone calls of people that tell me they can't find. They're telling me I get many students who tell me they're accusing me of not going to school, and I don't have my school records. And I've told them it's best to withdraw your admission. I'll work on finding your school records. I will work with your school and will reapply for your student visa, for example. I would prefer for my client to go back home and for me to apply for their student visa again, as an example, instead of them having a deportation order. It's an uncomfortable conversation to have. I know my client doesn't want to go back home. They want to go back to school. They want to go back to work. They want to go on their vacation, but I would much rather not have the deportation order because that's just not a good option. And I really don't want them to not be able to ever go back home by seeking asylum.
There you go. Thank you so much, Isa. I mean, those were really helpful. And yes, I'm sure it is the same for folks out there. So I would say please do not forget to like, share, and also subscribe to our channel. Our handle is at Immigration Talk Show. So check us out, subscribe to us, and hit that bell icon. And it's been great so far with Isa. So, Isa, are you ready for more questions?
Always.
All right, so let's take this one. This is from our Facebook group, I guess. And yes, this is from Priyanka. Being an Indian citizen, if a person got stamped her first H1B visa in country other than India, will she be eligible for Dropbox in India, provided she has visa expired in the last 12 months?
Yes, that is part of the waiver, this the instructions that they're providing. Each embassy is not, it's providing their instructions online, but all the waiver instructions should be there. And yes, if it's less than the 12 months, you should be able to do it in the Dropbox. So yeah, take advantage of it. I am encouraging all my clients to do the waiver. I mean, before I would always tell them to do it 48, but now 12 months, do it now. And that goes back to the prior question as to what we can expect. There's going to be delays. So don't wait. Do it now. You're a month 10. You think you have time. Do it now. But yes, you should be able to do it in India under the Dropbox. Not an issue.
Okay.
Check the
The best
instructions, though. Check the embassy instructions online.
Right, right. Thank you, Isa, for taking that up, and all the best, Priyanka. Now, this next one is from an anonymous participant. This question was also put up 5 hours back. I work as a remote full time in a company as architect, and I'm planning for stamping next week where I have to go through interview. My company said I don't need client letters since I'm full time working as a consultant, and they gave a letter with all my details for counselor appointment. But I work as a consultant for a client where they have SOW with us, so I help them customize the product. In this case, do I need a client letter, or since I'm a full time in my company, is the company's recommendation letter enough?
The company's recommendation letter is enough because you're a full-time employee of your company. However, the client recommendation, the client letter would be excellent if you can get it. However, I know that it's not that easy to sometimes go to our boss or to the client. If you can get it, excellent. It would be an amazing benefit to have. However, the company's recommendation letter should be enough. You're a full-time employee. That's all that is required. The client letter would be like the icing on the cake to make sure that the officer fully understands what you do. Because as you said, you are the consultant for the client, but you're technically working for the company. If we just help put the full picture of what you do, help answer all their questions. So I understand why you want it. I would want it too. But I also understand that sometimes it's difficult to get clients to give us what we want. So know that what you have is enough. If you can get more, that will be better.
Okay. Thank you, Isa. And now let's go on to our next one. This is from Mushhak Musthak. I'm planning to go to India for visa stamping for first time since I moved to US. In the sorry, is this the right time? Am I
No.
eligible for interview? No. Okay. All right. Should I go on then or
Yes, yes, yes. Go. I'll answer everything. I'm sorry.
no, it's cool. Am I eligible for interviews? So my question is, my company says they will give all supporting documents for the interview, but they said I don't need client letter because we have SOW with client and I work in remote and not in client location. Does it seem justifiable for counselor? Is there any case like me?
I have many cases like yours. And what I've been telling my client is, why do we need to go? Like, why do we need the stamp? Is it something that you really need to go home? Is it somebody elderly that you need to visit? Are you feeling really homesick? Why do we need to leave? Because the reality is, to answer your first question, as you heard me abruptly say, no, right now, it's not the best time. It's just the embassy right now. And it's not just, it's everywhere. Embassies are being, they're not the most welcoming environment at this point. So if you can avoid it, if it's not really necessary, but I understand there's some things that may be out of our hands. There may be some family responsibilities that we need. So if you to answer the second part of your question, if you have to, it seems to me the documents you have, it seems related to the prior question, there may be sufficient, but the more you have, the better. The bigger picture, the full picture that we can show of what we do, that's best. Sometimes it's difficult to get documents from clients. I understand because, of course, the H1B may be your visa, but I have to work as your attorney directly with your employer to get records. And I understand how difficult it may be for employer to get records from clients, how uncomfortable it is to sometimes ask letter from clients. So the more you can get, the better it is. But it seems to me, to answer your question, that what you have is enough for the interview. Make sure you understand it. Make sure you're comfortable with it. Once again, if you have to, because if you don't have to, if you're okay here and you don't have to travel, now it's not the best time to travel if you don't have to. If your time is up and you have to, it's okay. But if not, stay here. We're good here. Spring break. Enjoy the time. I'll take another question. H1B. Okay, so H1B stamping in May. It's 160. Oh, submitted within 30 days to that appointment. How do I get? It's not able to retrieve since I didn't submit it within 30 days. But same 160 attached to that appointment. How did I get rid of this to go for same appointment? Oh, I'm not understanding this. Okay, this is what I recommend. If you are using the wrong DS-160 and that's the concern, go to your appointment with what you have. I know how difficult it is to get appointment. I wouldn't want to reschedule. The reality is rescheduling might be a lot more complicated. So I am failing to fully understand if the issue is that you have the wrong DS-160 and your concern is that you're processing the wrong DS-160 application. Take with you the correct application and explain it to the officer. Because once again, I understand how difficult it is to get these correct, to get an appointment. It may take a long time. Take the correct application with you because it may be difficult, if not impossible, to change it. Also, I understand there's an online system. I'm sure you've already emailed them and contacted them a million times to correct this. Keep doing so up until the day of your interview, but make sure you have the correct information and the correct form with you when you go to your interview.
Thank you so much, Isa, for taking that up as well. I was facing it.
It
I'm glad
happens.
to be
Don't
back.
worry.
So
I just hope I
thank you
answered
for
it
taking that
correctly
up.
because it seems like if he has the wrong application, but I think if you take the correct one, you should be okay, especially if it's just for stamping. If this is your first time, they'll keep your passport.
All right. Thank you, Isa. Thank you for being so awesome too. So patiently taking up all our questions. So next one is also from an anonymous participant asking, I started filing out my DS-160 a few days ago and have already booked a Dropbox appointment for my H1B stamping. I had a quick question. Does a DS-160 application expire if it remains unsubmitted for too long? I'm holding off on submitting mine because I'm waiting for my updated I-797 and I wanted to ensure that my DS-160 reflects the correct details.
So yes, it may expire, but at the same time, you're doing the right thing because you do want the DS-160 to be as fully complete and as accurate as possible. You don't want it to be wrong or to have any mistakes or to have any issues like the prior question where you have the wrong application, the wrong information. They may hold on to, especially now with embassies being so picky, they may hold on to something minor just to either delay your processing or to even deny. So it's annoying, but it's best to hold off to make sure the application is correct. Worst that could happen is that when you go back to try to submit it, it may tell you it's expired and you may have to do it again. And I know that's annoying. I know I'm minimizing it here, being like, oh, you have to do it again. But it would be best to make sure the application is as accurate as it possibly can be. Also, I know you guys know this because you watch this, but make sure you print it, have it with you, bring it with you. So I know it says don't bring it to the appointment, but review it, because that's what it will. That's what they will ask you. That's what they will go through during the 10 minutes you'll be there, and that's what they will use for all others. So make sure you're always consistent every time you renew it, because we just talked about how waiver time got shorter. So you want to make sure you're always consistent. So every time, every waiver, you never have any issue, and the process is always easy breezy every single time.
Yes, absolutely. Thank you so much, Isa, for doing that. And I think we will move on to our next question now, or have we covered? I think we have covered most of our viewer questions. But,
Good.
we were also talking about legal options, if an H1B visa gets detained or denied. So, what are the legal options? And we've already discussed this. So, what are some key H1B visa holders they should know before they're traveling internationally to avoid these issues when they return?
So the main thing when traveling, like we already mentioned, like checking before, checking your time you've been here, checking how much time you have left. That's the main issue I see with H1, that maybe that 6, 7 years, like you're already up and you didn't realize it. So check how much time you have left, check how much time you've been here. Be so that way the questions they'll ask you at the entry you can feel comfortable answering. The questions about your employer. Where is it located? It may seem, especially now with remote work, and CBP officers can be really sneaky, and they will ask you, "So where's your office?" And you're like, I don't know, it's over here." And that's where they tend to question whether you're really working and really doing the H1B. And you may say, "But I work remote and I only go to the office once." And so it's, keep that in mind and bring evidence with you. It's a brand new office, a brand new place. Here's my card. Here's my boss's information. That's to check. Now, here in the US, like I said, if you have that encounter, it's good for your employer to know not only your rights, but the rights of your employees, your coworkers. What we notice with ICE is, because of the desire to meet the numbers and the quotas that President Trump has promoted and has promised to the U.S., there may be not really ICE raids; it's more like ICE encounters, we may call it. And know that here in the U.S., like I said, you have greater rights. So if your encounter with ICE is at your place of employment, they need to have signed warrants by actual judges. So it's good for your employer to know that if they're coming and saying, "Oh, we need to check the H1Bs in this area," it's different from the Department of Labor going to see if employees here are rightly are actual employees, than to
Yep.
actually start arresting people. There are certain requirements, so it's good for your employer to know. And if you're for any reason detained or stopped or have any immigration encounter in the U.S., that's actually the place where you can fight the revocation of your visa. If their visa is revoked because they don't think your employer is real, you can fight that here before an immigration judge. If they're fighting because they don't think you work, you can fight that here before an immigration judge. You have that remedy here, but that's only if you're already, meaning you're not seeking, the legal term is not seeking admission. It's at the
Mhm.
airport where the remedies that you may have are very limited. So it's good, as we've been suggesting, to plan ahead to make sure that you have evidence of always being here legally, evidence of where you work, evidence of the time that you've been here, of what you're going to do, or of where your work is located. Minor details that we normally don't think about, and now might be a good time to keep in mind just in case.
Thank you so much, Isa. Thank you, really. It's been such a great discussion. I don't want this to end, but we've already covered an hour, so I might have to let you go for now. But if you still have a couple more minutes, I would still have more questions. What do you say?
I will take the minutes. I'll gladly answer any questions.
All right. So this next one is actually a case study where, I was reading more about it. So there was a software engineer working in Silicon Valley and went to India for a work trip. But when he came back, CBP detained him over an old traffic related misdemeanor. So his visa was revoked and he was placed in expedited removal. So how could he challenge this, and what options does he have to fix his status?
And that's where I mentioned the importance of checking your visa status before. And that's where you can check your email. the DS-160 that we've been mentioning continuously, that we put our email address there where they would communicate if our status, if our visa has been revoked for any reason. This individual maybe used their email address from 1998, and that's where they emailed us. Although the Department of State sometimes is notorious for not even emailing us, or simply thinking that we're going to know our visas revoked by magic. So we'll give him the benefit of the doubt that maybe he didn't get the email and that's why he didn't know. But if you have your DS-160, make sure you check the email address that you used in that form. So that's where you would know what's the status of your visa, number one. Number two, for him, it would be relevant to understand that anyone who is in the US for less than 2 years could be subject to, as Nipa mentioned, expedited removal. So if you are seeking admission, if you're coming into the US, you've obviously been in the US less than 2 years, you just got here. So they can kick you out right away. So in that particular case, if he would had emphasized, as we had a prior, somebody else previously asked, they have been working on an H1B for 3 years, it would have been helpful for him to argue, oh, I've been working on this visa for a certain amount of time. This was a very brief trip that I took. There are many circumstances that may have helped him fight his case at the airport. But remember that we have discussed that at the airport, your options are very limited. You can withdraw your admission and that way avoid the expedited removal, because expedited removal is a deportation. That's the deportation that I was mentioning that bars you from the US for 5 years from the airport. Or you can seek asylum, which will keep you in jail until you can prove that you can't go back to your country due to persecution from the government or an agent the government can't control. So in his case, it would have been best to, if it is a traffic charge, once again, sadly, the US can revoke your visa for any reason. And a traffic misdemeanor can include driving without a license, it can include a DUI, and these reasons are very difficult to fight. So while we can later on argue, if they were to revoke your visa because they argue your employer is not real, you can apply and prove that your employer is real. Or if they revoke your visa because they argue you're not working, and you can apply later on saying you are working indeed. When it's something criminal, like a traffic misdemeanor, because it is a decision from the Department of State, it is very difficult to have that visa reinstated later on, and even more difficult if you already have an expedited removal order because of the 5-year bar that I mentioned. So for him, he would have to either fight the traffic charge, either argue that it's not him, or it will have to be that it's not him, because if it is him, there's nothing he can do. He would have to wait the 5 years, and after 5 years, try to reapply for the visa. If he has any family in the US, it would have to be a qualifying relative, a spouse or a child, or maybe a parent. He can ask for a waiver. Sorry, long answer for a sad response.
No, but I mean, totally makes sense, and I think you'll just have to play safe with all your time out there under a visa. So, I mean, try not to fall into, even though they may look small to you, but it's not really small. It could be getting more
Yes.
complicated a little later. So, thank you so much, Isa, for taking that up. You wanted to add something?
Well, the main point I wanted to add is that right now, sadly, visas can be revoked being only based on the accusation. That's why the Lake and Riley Act is so controversial, because it is allowing people to be placed on removal proceedings, which was what we call deportation proceedings, and technically to be detained only by being accused. So that would also mean that even if, and that's also why I keep emphasizing to check your visa before coming, because you may have this traffic infraction that you think you paid and it's old, and because it spent so long that you didn't pay it, or I don't know, nothing happened with it, now it turns into a misdemeanor, and it just gives the government the authority to revoke it. So just check ahead of time, play it safe.
Absolutely. Thank you, Isa, for taking that up. And maybe before we leave, if you could, tell what should employers be doing to make sure their H1B workers don't run into legal trouble, especially with all the policy changes that are happening so fast and every day.
First, I'm going to answer whether traffic infractions affect the B1, B2 visa applicants as well. It affects everyone. Traffic infractions They sound silly, and I never thought before, during the Obama administration, for example, I've been practicing for a while. I'm rather old. I would tell no, no, no effect. But I've noticed, maybe because I live in Miami, where people drive very well, we they accumulate and they do have an effect. And they, because visas are issued, particularly B1, B2, which are tourist visas, are issued at the discretion of the consular officer. An officer might, at their discretion, and the Department of State, the Attorney General, who are the ones that monitor these visas, may, are at their discretion, determine that you have way too many traffic tickets, and they can withdraw, they can revoke your visa. So be careful. Don't drive like me. They may have an effect. These regulations, the decisions to revoke a visa, are fully discretionary. So because of that, there may not be written black and white in our laws and regulations. So keep that in mind. So yes, traffic infractions could affect even a B1, B2 tourist visa. As to employers, what we can do to protect our employees, I'll tell you my latest case. My employer, I don't know why, I don't know what they were thinking. They were a little bit too laid back with my employee and decided to, I guess, make them partner. I don't know, give them an interest in the company, which is great. But when you make somebody partner, when you include them in the company, you must continue payroll. H1B, one of the main requirements is continue payroll. So make sure your employers keep paying you. And by paying you, I mean that you remain a W-2 employee. Because you are now a partner, or because you are now an essential employee, because there maybe later on will petition for your green card or whatever, you're growing in the company, the tech startup is now a tech big boy, whatever, you're growing, great. It doesn't mean that now because you have the credit card on the company and you're taking the money directly from the bank account, that may happen, that's okay. But you must remember, you must remain a W-2 employee. You must remain in payroll. I've noticed many employers that as they grow, they feel comfortable with the employees, they give them more responsibilities, and by giving them access to the company, they I guess relax with the payroll and HR requirements. I don't know what's going on, but it has led to a lot of questions when now the waiver and the renewals. I also noticed, I think this had to do with, because of the waivers, people were a little bit more relaxed when it came to reapplying. And now that the waiver is the less time, I am preparing more applications, and I've noticed these mistakes from employers. And I am very worried about whether these visas will be renewed and many issues that may come up. So make sure your employers keep paying you W-2 always. Also, for ICE raids, which have been, I live in Miami, Florida. I practice all over the world, but I live in Miami, Florida. And here in Miami, Florida, there have been ICE raids. None of the ICE raids have occurred fully under the law, meaning that the warrants that the officers have used, none of them have been signed by actual judges. They have been administrative warrants. And so I mentioned this to all of you because it was not until after that employers realized, wait a minute, an administrative warrant, meaning a warrant that is signed by another officer. If I, as your friend, sign a warrant, has no effect. I don't have to let you in. So keep that in mind. It's something minor, but it's huge, because if I am working and I don't know if maybe your visa was revoked because you had a DUI yesterday and maybe you are now here illegally, I don't know. And somebody shows up saying they want to have a raid at my job, it's good for me to know, is this signed by a judge? I don't know this person. Maybe call an attorney, and I'm not going to let you in into my place of business because I don't know this warrant. And that way protect the person who maybe was accused of a crime and doesn't even know it from detention. So let your boss know that, just in case. They should know. I don't know how comfortable you may feel with your boss having this conversation, but if you know it, and if you are the boss, you can also let them know, hey, no, my boss has instructed me not to let you in because this is not signed by a judge. So those are the two main things I've been telling all my employers: pay your employees by W-2, and check that all warrants are signed by judges before you let anyone into your premises.
Absolutely. Play safe, but also play smart. So know everything well, do your research properly, and I'm sure of that. Nothing is going to scare you when that happens. Knowledge is
True.
power, at least in this matter. So do that. And thank you so much, Isa, for spending this time with us, full of energy, and, for patiently answering and taking up all of our questions from our viewers, not just on YouTube, but also from those who are watching on Twitter as well, and also from our Facebook groups. It was really lovely having you. And I wish this wouldn't end so soon, but yes, we'll have to at this point. Yes. So I'm really hoping already to see you again soon. Please tell me
Whenever
about
you
your.
want.
Yeah. Yeah. But before we go, do you have any end notes, anything more you want to add? And we can.
I know things are scary right now. Every day we wake up and we have different news and different memorandum and something different going on. But don't get overwhelmed. Just stay informed. I know that sometimes that might be overwhelming too, but it's good to stay informed and know that you guys are doing everything right. You're staying informed. You have your visas. You're applying correctly. As long as you keep doing everything right, you'll have the law on your side. And if I can help you in any way, I'm always here.
Thank you so much. And yes, you can contact Attorney Isa, and that you can do so by calling her on her number, and also by emailing her. You can call her on 305-938-0676, and you can email Attorney Isadora at isadora@isalawyers.com. Check out the spelling, it's there on the screen, and go visit www.isalawyers.com. Thank you, Isa, once again. It was lovely having you, and you have a great day ahead.
You too. Thank you guys.
Thank you. And folks, you can also email me or call me or WhatsApp me on my number. My number is 408-335-6444, and my email address is nipa@staffingly.com. And once again, do not forget to subscribe to our channel and also hit that bell icon so that whenever we have discussions like these, you are notified. And absolutely, it was so amazing having you, Isadora. I'm already looking forward to having you back again. So, yes, and friends, also follow us, not just on YouTube, but we are also there on LinkedIn, Facebook, X, and Instagram. So, check us out, follow us, and connect with us. So, bye, y'all. Have a wonderful day ahead and watch out our space. Stay tuned on Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Napasa, and I'm going to be with you for this session today. And it's going to be a short one today, shorter than usual. We'll keep it at half an hour. So, yes, before we head on with today's discussion and have our guest join us, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. use of information is at your own risk. So, once again, friends, welcome to Immigration Talk Show. Don't forget to subscribe to us, hit that bell icon so that whenever we have discussions like these, you're notified, and also that you stay updated with the latest on immigration news. So, yes, today's discussion is going to be on got an H1B RFE. What are the common reasons and best ways to respond? So, we are going to discuss this with none other than our guest for today, who is John Kostravi. He is the founder of the JQK law firm, president of the educational and media company Immigration Lawyers Toolbox, and also host of the Immigration Lawyers podcast and publisher of the Immigration Lawyers Toolbox magazine. So, as an immigration attorney, John and his team have really helped hundreds and so many out there, the clients, for over the last 12 years to fulfill their dream of living, working, and studying in the United States. So, yes, without further ado, please help me welcome him back to the show. Hi, John. How are you doing today?
Hi, Nico. Thank you so much for having me on. I'm doing good. How about yourself?
I'm doing good too, and
Wonderful.
it's always lovely to have you. So, yes, with the topic of discussion today, what can friends out there expect from this session?
Well, we're going to talk about the H1B process, and there's going to be a focus on like RFEs, requests for evidence, when someone has an issue with the case or the government has an issue with the case and they're asking for more documentation. But just a heads up, the H1B process is a lottery system for the most part. If you're going to work for a nonprofit organization or something like that, you don't need to join the lottery. But the lottery means that every year there's only a few amount of visas available, and you have to register first. Put your, buy a ticket to the lottery, which is right now. It opened up a week ago, and it's open for another week. So employer during this 15-day period or so registers online with USCIS. They increase the fee to be able to register for it to $215. And then in a month or so, they'll release the results. If you're chosen, then there's always a little bit nuances here that I'm just brushing over. But if you're chosen, then you can file the H-1B case, Form I-129. The employer does it. The employer does everything essentially in these cases, and they pay for it as well. They're supposed to. And if you're submit the paperwork, then you might get a request for evidence saying there's issues. And we're going to discuss that, but I'm happy to discuss the general process of H-1B as well, especially because it is the filing season right now.
Yes, absolutely. So, friends, the filing season is on and it'll be on till the 24th of March, 12 noon Eastern Time. So, keep in mind and don't leave anything to the 24th. I think you should finish much before that. So, yeah.
Yeah, we have
John,
people calling us even now for H-1B filing, and it's just a lot of fast moving stuff you got to do to make sure it's something we can do.
yes, absolutely. And I think it's always best to have an attorney guide you. So why not contact attorney John Kosravi as well? His details will be scrolling on the screen very soon. And friends, you can also join us on this conversation by dialing this number 425-436-6335, and the access code is 988-888. So, John, coming back to our topic of discussion, I also prepared a couple of questions. So, if you could, tell us some of the most common reasons, USCIS issues a request for evidence or an RFE for H-1B petitions.
Sure. So, the H-1B process is for specialty occupations. And a lot of times the immigration department makes these terms up, and then the definitions keep changing every day. And every officer reviews it has their own definition of what a specialty occupation is, though it's somewhat listed. But that becomes a major problem when they say, okay, this work that they're doing is too general. It's not specialty occupation. Now, if you're doing H-1B as a lawyer, okay, lawyer, they know what it is. But if it's some sort of analyst, it gets kind of vague. So having a detailed description becomes really important. And then another one is just the educational background. Do they have, qualifying bachelor's degree? One issue that pops up for India, which is 95% of the H-1B visas probably, is the bachelor's degree there could be a 3-year bachelor. So sometimes we have to show that there's an additional year of education. In addition to that, maybe a master's degree, as well as you could do a 3-in-1 rule. So if you have 3 years of experience in that area after graduating, you could use that as 1 year as well. So that degree background becomes really important. Sometimes you need to get expert letters for it and stuff. And then it really just about whether the job is too generic or it's not expressed right, or it's too entry level of the job. It's not really what the degree needs or a job that requires a degree per se. So a lot of it is questioning the job itself and whether it's a proper appropriate job. And then the other, a lot of times, is educational level. Then there's a million and one issues of person's background, the little, like, typo kind of stuff. Or, for example, they say we have such and such work experience, but in the past, the foreign applicant had applied for a tourist visa, never listed any of that employment. So now in H1B, they're saying, I worked for 4 years for this company, but they're like, well, in your B2 tourist visa application, you listed that you were a homemaker. So how did you work for that company? You lied somewhere. Are you lying here or lying there? Which one is it? And these stuff, especially with the technology getting better, where they can access old databases of evidence and information, is becoming more and more of an issue in these kind of in just all cases, but including these ones.
Absolutely, and there's going to be more scrutiny, more, I mean, much more than ever before. So, including your social handles
Yeah.
being watched, from what I hear, right, John? What do
Yeah,
you
so
want
I
to
mean,
say
this
about
year is going to
that?
be a completely anything we talked about. These might be the easy problems we're saying. It might be a whole new set of problems happening because there's the Trump administration's here. It's the first cap season that they're going to be under control of. One thing they're adding, it's probably in 45 days going to be added to the new applications, is all the social media stuff in the U.S. as well. They used to ask you for, they've been asking you for if you're getting a visa through the embassy, they're adding to the U.S. But additional stuff and extreme vetting is coming back and all sorts of different background stuff and delays. And so H1B is a very controversial visa too, so that's going to be a problem. Staffing issues. So you could submit your H1B case. It might take forever for them to even make a decision, or you might get approved. You go to the embassy interview, and they don't have any appointment times available, and they're backed up. They do an interview, but they can't approve you for a while. So everything is a unknown. Everything I pretty much all the experience I may have, it might not even matter for what's happening. It's everyone's making it up as they go along because everything's going to change. And so it's a fight day by day as this new situation, new regime is in charge of the H1B process.
True that. Thank you so much, John, for that. And now, I have this other question. And if you could tell us, how employers and employees proactively reduce the chances of receiving an RFE, especially while filing the H1B petition.
Sure. Whenever, depending on the job title, especially having really good job duties of what they're doing is going to be really
Mhm.
important. So again, if you're a lawyer or very unique jobs, that's like people expect there to be a degree for and stuff like that. But it's more open-ended. Marketing person, for example, really specifying how their degree relates to it and as much as possible. Having the educational credentials already looked at. Sometimes getting an educational evaluation beforehand, which costs extra money, which a lot of times employers don't want to do. But having that evaluation becomes really important to show that it's equivalent. Having all that paperwork ready. And another thing that employers run this operation, so they're really focused on the H1B portion of it. But they don't, and the lawyers are really focused on that as well. But they might not spend as much time looking at the background of the applicant to see, okay, did you ever file for a green card before? Did you ever do other kinds of applications before? Because we might get the H1B approved, but we don't know if your background's okay. You might have other issues. You might have been some part of some organization that the government doesn't like or doesn't want. Right now, it's a big controversy in America right now where a green card holder, too, not even a visa holder, a green card holder was showing sympathy to Hamas on college protests, and they want to take his green card away. So if you're on social media where you said I support Palestine, then and then you say I support Hamas or Palestine in this effort, that could be used against you and get your visa denied. This has never been happened before. I mean, it happened, I don't know, during communist times with Russia, if you're a communist sympathizer. These are old rules from way back when. But any recently, maybe 30 years ago, there was one random one. It's very rare to use these laws, but they're being used. A law that's rarely, if ever, been used in the last 100 years is being used again. So not only is it just watching out for the H1B stuff, that's a typical kind of thing here, but it's also just personal stuff.
Yes, so true. And that said, Mahmoud Khalil, an activist. So yes, it's happening, and there are problems arising where what we've seen situations like this have never risen before. So at least in the recent past. So yeah, let's see. Let's go on to our next question. Also, John, if you can also tell us, are RFEs becoming more common due to policy changes, and how has the trend evolved in the recent years?
Well, they went up dramatically during the Trump administration. They had a policy of no deference. So, like, if you had H1B approved and you're renewing it, they would start everything from scratch. The policy before was you got to approve before. We're not going to re-adjudicate the whole thing. Trump said everything, redo it from scratch. So that was a big hassle and delays. But then Biden administration went down. The expectation is going to go up. And there's been some changes. The Biden administration, before they left, they updated the policy where they said usually there has to be an employer-employee relationship. So if you own a company, it's almost very difficult to apply for your own H1B because they'll say, "Oh, you're just trying to hire yourself. That's not the real H1B." But they opened it up where you could be the majority owner of the company and still apply for an H1B, but you have to show that you are, a real employee. You get fired and all that kind of stuff. And this is a new policy that has been tested. You could have got away with this sometimes before, but it has to you. But as a formal policy, that was okayed as a new thing. But we'll see if this administration is going to get rid of it or just not really get into it or find problems with it. So that's like a big one that's probably going to happen a lot because a lot of people want to take advantage of this option. If they own a company, they want to file for their own H1B. So that's something that's going to be happening. But again, they're going to be picking out whether there's a specialty occupation, going through the degrees, and just delays could be really problematic.
Right. And from what we hear, there could be more RFEs also. So we'll just have to see what could happen this year. And it's really early to say because there just has been the policy shift. I mean, a change in administration and a lot of new things coming up every day. So let's just wait and watch for now. And now let's take up Yuri's comments. He has a lot to say or ask. Let's find out. So Yuri is saying, I am in my sixth year of H1B and my employer filed for an extension based on a pending perm. The RFE is asking for proof of 1 year pending labor certification. How do we prove this in a way that satisfies USCIS?
So it should relatively be easy. This is based on the AC21 extension. These are the rules they made about 25 years ago, updates to give this flexibility. So the H1B has a limitation on how many times you can renew. But if the employer starts a green card case, they file a perm, a labor certification, and the process going forward, then you get 1 year renewals until that process is done, which could take forever sometimes. You just keep renewing it every year. But if you have a labor certification filed or your I-140s pending, you kind of just have the receipt notice showing that it's been pending for a year. So usually you file that with the application as proof that that's happening. I got to see what unique issue may exist here, but usually it's pretty straightforward. This wouldn't be the issue that people have RFE on unless they just forgot to put, or the government didn't read it. It's in there, your application, your extension, but the government didn't just notice. That might be the situation. But Yuri has another question about whether he could stop working if he does a H1B transfer. So H1B transfer is if you're working for one H1B company and you go to another one that wants to sponsor you, you could do that. The main thing is it has to be timely filed within the grace period, the 60-day grace period. And one thing about that grace period is discretionary, even though they usually approve it, but they made it where they could say, oh, there's no grace period. So it's kind of annoying. The safest thing to be is like working for the first one, immediately request a transfer, and then once it's approved, shift. But having said that, it's usually not necessary. They usually abide by the grace period that they give. But whether you can work, the rule is that as soon as the file gets to the government, you can start working. You kind of wait for you get the receipt notice. But if you get the H1B transfer receipt notice, you're allowed to start working with the new employer. And so that's a pretty good situation there. I can hold you over. Now, if you have a perm pending, that creates all sorts of other issues where you could transfer the labor certificate to a new company. You probably can in this case because you have to have I-485 pending to be able to transfer I-485 pending for 6 months. Getting kind of technical here. I'm not sure if you'll be able to save your perm with the old employer if you move, but generally, yeah, if you just file it, upon filing, you can start working for a new employer.
Right. Thank you so much, for taking up Yuri's questions and comments, John. We
You
have
got it.
Kritika. Kritika's, yeah, sure.
It's the
Tell
same
me.
kind of question. I'm sorry, but it's the same question where you can start working. If it's a properly filed H1B, you could file. You could continue to do that transfer and work for them. But I must say I got to see what's going on. So this is general education only. Some stuff might not apply to your side. I'm not sure. I can't say whether you can work or not because I haven't reviewed your RFE or your case. But generally, you could work once the case is submitted for the transfer.
Okay. Thank you so much. I think it's the same person because they sound the same questions. But thank you so much, John, for taking that up. And now I have another question, and that is if you could tell us, one of the most frequent RFEs, which is related to specialty occupation requirement, and what key evidence should be included, to successfully respond to such an RFE.
Sure. I mean, it's a little bit of the person's background, their degree, maybe their transcripts too, to show what they studied. It goes into what the job is, and a really good description, a paragraph of like what the job entails, what is required, and sometimes you got to jump through more hoops for to explain it. There's government website, the OOH website, that breaks down what his job entails and whether it needs a degree and stuff. Using language from there is key, and sometimes having expert letters if the job is really kind of a vague job. Having an expert opinion, there's professors and stuff like that that'll write letters saying, yeah, this job based on this transcript and what your requirement is a specialty occupation. They describe it. That's something that could be obtained, but it just requires prep because you don't want to. If you think there's worries, you want to get started out soon because preparing all the paperwork for this could take weeks and weeks. And if you get an RFE, there's time limits on when you can respond to RFE. So you want to have a running start on this stuff. You want to know who you want to hire, who's acceptable to write this letter. So it's stuff that again, as it goes to be proactive to be able to prep for it. Sometimes, the law firms, there's cost to this because extra legal work, there's extra cost for this and that person, fees here, fees there. It's sometimes they might say, okay, we may be good as it is. Let's see if they push back, then we'll spend the time and money to try to develop a response. So sometimes you just do what basically will get it done 50% of the time or more, and you'll save the extra work needed for that. We don't like doing that in our office. We always require to do everything up front, even if it's like extra. But a lot of firms you work for, especially ones that we don't do a million cases of. Most of the H1B filers are companies that might do thousands of these, so you can't spend the time individually to review all these and do all the proactive kind of stuff. So a lot of their game plan strategy is, okay, we'll file it. If there's pushback, then we'll deal with it. We'll have time the RFE. But our office, we don't like to wait for pushback. We try to be more proactive because we intentionally keep our caseload lower to do that extra work. It's just one of those versus like about like one of those things that we could do, but bigger firms that usually handle a lot of H1Bs can't.
Well, thank you so much for taking that up, John. I have another question. If you could tell us, how should an employer handle an RFE which questions the beneficiary's qualifications, such as a degree of equivalency or relevance of education to the job role?
So, the lawyer should get a copy of the RFE, but if they don't, immediately talk with the lawyer to review what specifically was problematic in the request for evidence RFE. And then, go back to the employee about his qualifications, see how he can be bolstered to show what it is, and then just rework and re-explain the job requirement, get expert letters, go on the government websites to show what it is, show that in the history of this field and our other employees, they have the same situation. Other employees that are U.S. employees in the same, doing what this person is doing, they also have the same job requirements and background. So this is typical of what we do. You kind of just dig in to document and explain everything that's there. This is typical and is expected in the industry. And again, you get industry letters, expert letters as well. Sometimes there'll be websites that talk about this, trade publications that talk about this stuff too. You kind of got to dig in deep to see how you could answer those questions.
Right, right. Thank you so much. And Control, now if you could display some of our questions from our Facebook groups or YouTube, maybe. But thank you, John, for taking that up so far. Also, meanwhile, if you can also tell us if an RFE requests additional proof, regarding the employer-employee relationship. So, what kind of documentation should be submitted to strengthen the case?
Yeah, this is a tough one when they get you on this, but essentially they want to see that the person who's an employee is actually an employee, means they can be fired and if at will, So if they're not really an employee, they're really like the owner of the company, they can't be fired. That's problematic. So you want to have systems in place, HR documents that say one of the terms are a contract with this person that says you could be fired based on cause and everything. Maybe have a board of directors that have control over this person, their position. Because, for example, they might be the president of the company. They'll say, well, they're at the top of the company. Who's going to fire them? But there's a board of directors that exists that can make a decision as directors to do that. So there are ways to do that. And the new policy by USCIS that came by administration kind of opened it up to say, it's still doable too. This person gets payroll. It's a real job they're doing. They're not doing like the actual work, because they don't want people who are just rich and kind of like own a company to say, oh, I'm working here, but they're not really. They have to really show to like what is the job they're doing that day-to-day basis. It's not like being a secretary kind of work, but at the same time, it's not just hanging out collecting checks and making money. What work are you doing that's related to your education? So they're going to be looking deep into these, but my guess is a lot more people are going to be filing this because they opened it up last year. And then this issue is going to come up more and more in this season, this year.
Yes. more explaining to do, and yeah, there will be more scrutiny for sure. So
This one
yes,
was you want to
control.
if there's a
Yeah.
sense that there might be employer issue, you want to like proactively like prep everything ahead of time so that you're consistent from the beginning of what you're saying. You don't have to like clean that stuff up later. You want to make sure
Mhm.
everything is all your ducks in a row before you file that kind of case.
Interesting. Thank you so much, John. Now, control, if you could display some of our questions, please, from Facebook groups. So, this is from an anonymous participant asking, my first H1B stamping was outside India. I'm within 12 months of my last H1B visa expiry. I never had an H1B stamping done in India. Am I eligible for Dropbox in India?
So one thing about the Dropbox situation that I'll just say is like there's word that they're changing everything with regard to interview waivers and Dropbox and stuff like that. So anything I say right now within an hour might be different, or it already is different. So you kind of just leave it up to them. You file the case, and then you see whether they say they want an interview or not. But everything's changing so rapidly with visa processing that I'm hesitant to even give an answer to that one right now. We're seeing like all sorts of different changes, particularly interview waivers, not required to go in person. That's changing.
Mhm, mhm, mhm. Well, thank you. Thank you, John, for taking that. Now, this next one is from Mohit. Hi, all. I find myself in a strange situation. I got laid off today. The company refused to sponsor my visa in November. I have been trying to switch before the lottery deadline, but have been unsuccessful so far. I have 5 months to look for a new role. This would have been my last lottery attempt. My STEM OPT ends in January 2026. What are my options? And is enrolling for a day one CPT course worth it? Will employers whom I interview with willing to bring me on just on my day one CPT? Any guidance is appreciated.
Okay, so first off, on the STEM OPT, you have a limited amount of time where you can be unemployed, so you have to make sure you don't fill that up. How much is it? It's like I think on I can't remember the exact numbers. On regular OPT, you get 90 days plus extra 20 days for STEM OPT. I can't remember exactly, but make sure you don't use up that time. Now, the problem with STEM 1 OPT is it's not per se a problem, but first of all, you have to go back to school. So you have to start a new school program, and so that's new F1.
Mhm,
There's a lot of fraud and abuse that potentially happens in day one CPT. A lot of people use it, no problem, but especially the Trump administration, you got to be kind of cautious. Make sure it's a legitimate program. If you go to that course, that school, you go to school as required. There's tests, there's exams, whatever the school requires. You pay the fee. It's not just a front where they collect money, you don't show up and just give you work authorization this way. So there's that risk that exists with first day CPT. But with your question, will employers who interview with willing to bring me on? That's an employer. That's whatever the employer is. That's their decision. I don't have any power or knowledge of what they want to do. So if you could tell them that it's up to them. You got to explain that this is a job authorization. But it's really just it's kind of like, will they hire you? Let's put aside, let's say you're a U.S. citizen. I don't know if they're hiring you now. So it depends on how much they want you and how needed you are.
mhm. Well, thank you, Mohit, for your question, and also John for taking that up. So let's go on to our next question. This is from an anonymous member. I'm seeking assistance from anyone with experience in this matter. I'm currently in the process of changing my J1 visa to H1B status within the US without returning to my home country. I recently got married, and my home country may be on a travel ban list. My question is, if I obtain the H1B visa, will the ban impact my wife's ability to secure an H4 visa, considering I do not plan to travel back home? Can the ban affect her H4 visa status if I have an active H1B?
So this question about the ban is something I get all day, every day for the last several weeks. There is no at this time recording. There is no ban. There's just rumors and newspapers and stuff like that. So unable to give legal guidance on something that's not law. I'll just be making things up. So it's illegal for me to do that. And there's a lot of clickbait online of people talking about this because it gets a lot of attention. But there is nothing written down that's this. So I can't speak to hypothetical. Hopefully the ban is applied to you, but we don't know if there is a ban, what it would entail. If there's exceptions to it, there's loopholes to it, or what. Now, if you do change from J1 to H1B, your even if you don't leave, your spouse, generally speaking, let's say they're German, a country that's probably not going to get a ban. Your spouse, even though you didn't get an H1B visa yourself, just status in the U.S., your spouse could potentially apply for the H4 and come. You don't need to have the visa yourself; just the status is fine. But with regard to bans, it's impossible for me to answer. Potentially, if you're married, without returning to my wait, say I currently in the process of changing. I recently got married in my home country, maybe on travel. So, how did you get married? So, if you haven't left for your home country, or maybe you left the J visa, came back, but you can get the visa. I don't know. But if you're married lawfully, you saw each other, it wasn't like an absentee wedding kind of thing. Maybe if you haven't changed, if you get the J1 as soon as possible, maybe too late for them to come as soon as possible. That's the only other thing I could say. But there's no official ban yet. So I'm going to go do a Google search right now. Let's see a travel ban if the news popped up. But there's nothing I can answer that. Even if it did come out, just read it, so I can't answer that. But travel ban trends. Okay, so it's just rumors right now. There's no official travel ban this time.
All right. That's interesting. Thank you so much, John, for that clarification, because I think there are folks, who have been wondering what if a travel ban is imposed, and especially if it's their country on that list. So thank you, John. And now, if we can go on to our next question. This one is saying, hi everyone. I had my H1B visa interview in the US consulate in Toronto on January 7th, 2025 at 9 a.m. Okay. The officer approved my visa, took my passport, and gave me the Know Your Rights pamphlet. However, my CEAC status changed to refused on the same day. Since then, the status keeps getting updated every Monday, but it still says refused with only the date changing, no emails or additional document requests so far. Has anyone experienced this before? And how long did it take for your status to change to issued? Should I reach out to the consulate or is it just a normal delay?
So this is like the horrible situation people get involved. Refused doesn't mean denied. It means they're doing additional research, review, and the like. And it comes a black hole many times where it just gets stuck. It's hard contacting the embassy in Toronto. I don't know if there's even a way to email them or contact them, and if you do, they'll leave an answer. But it's just, if you've been pending for 2 months now, over 2 months, yeah, contact them. Say, is there any documents needed or stuff? It's best to consult with an attorney to review what happened. There may be confusion about one of your documents that we could notice and be like, okay, this is the issue. Let's proactively contact them or contact the senator, or the employer contacts the local senator to say, hey, this document didn't make sense, but we have clarification. Maybe that'll help do the homework for the embassy to solve it if that's the issue. But we don't know what country you're originally from, what background issues you have. There could be other things that we don't know about that are problematic here. So it could be just normal. It could be there's major problems. We just don't know anything about your background. But the fact that the date keeps changing on it means they're continuously working on it in some fashion. That every time they touch the case, they update it on the CEAC website. But there's no timeline for administrative processing when you get these refusals. It's called administrative processing refusal. So you just want to try to solve the issue. But if you're like from a country like from Iran or something like that, these things happen all the time, and there's like 6 months, 12 months, 2 years of waiting because it's national security review. Those are open-ended. Hopefully it's just a document issue.
All right. All right. So this is the last one from our Facebook group. My first
Actually, we
H1B
went over
stamp.
this one. Was there another one? This was
Yeah,
about
we
the
already did this.
yeah, John
Yeah.
Lexon. We did this one as well. So if
So
there are
we,
no other questions, yeah, the main thing is to prepare for the visa process. I mean, it's hard to prepare for anything because everything's going to be changing and delays are going to be happening. The main thing is have your documents ready and focusing on just filling out the paperwork correctly. So most people watching this are probably not the employer, they're the employee. When you fill out your form DS-160, which is your background, make sure it's full, proper. Don't have your travel agent do it. Don't have your cousin do it whose English is better, something like that, because they're not going to pay attention to answer questions properly. If you've been married before, list your spouse. If you have children, stepchildren, list all of them. Excuse me. You don't want to come back later and say, oh, you didn't list this child. You're lying to us in some fashion. Or you previously applied for his tourist visa. You're denied. You didn't tell us this time. Just make sure everything is properly done. And one thing about this Form DS-160 is once you submit it, you can't access it again. So before submitting, take screenshots of every page so you have records. So if a lawyer in the future needs to say, hey, what did you say in this application? You have copies of it. So A lot of times people come to us, they have no copies, almost every time, because when they don't have a lawyer, they don't save copies. So we have to make a request from the government for a copy of it, which they could not give, or it might take 6 months to get, but it's too much delay. We can't use that. So having the paperwork already ahead of time, it becomes really helpful for future attorneys to be able to see what's going on with your case.
Yes, absolutely. And I think it's always best to stay prepared and, avoid any sort of, misrepresentation. Say
Yeah.
all the information that is required. And thank you so much, John, for that, great session. Short, sweet, informative. And, well, maybe before we leave, if you would like to give out a couple of tips, maybe in the best way to respond to RFEs, maybe just
I
generally.
appreciate that. Yeah, one thing is just reading the RFE well. A lot of times people really get worked up, and then when we come to us, we read the RFE with them, and it's like, oh, it's an easy thing. They just want to copy your passport bio thing page. But like just the idea in RFE just got them so worried and heck that they didn't even read the whole thing properly. Mailing it to the right place, the right address, being mindful of the deadlines, and just keeping like addresses updated if needed. It's really more the basic stuff. The harder stuff, inevitably the lawyer sits and works on it and gets it done. But the mistakes that happen a lot of times are things you wouldn't expect. For example, people who change the status from a J1 or F1 to H1B, they realize they have some sort of document issues that even though the H1B is good, some of the background paperwork is missing that's problematic or is not timely filed. So, like having pay stubs to show they maintain status, for example, they want to show like, okay, you're working as an OPT, now you got H1B, did you maintain it? So they might say, give us pay stubs. So keep all your pay stubs when you're on F1 OPT, a student visa working, to show that you're consistently working. You didn't have gaps, for example. So the documentation is the key. Keep everything you can. Just keep a file on Google, a copy of everything, scan it, take a photo of it, clear photos. A lot of times people take photos. They just take a piece of it, their hands in the middle of the page. For foreigners, no shadows, something like a print, and an officer of USCIS can read it properly. Documentation is what we do. It's all about paperwork. So you got to just keep good records of everything. And whenever you get a lawyer, it's easier for them to get the job. And it comes cheaper too, because when people come to us and are missing documents, we got to do extra work and the price goes double. But if you have everything for us, we could read it. It's much faster and the price goes down. So it really saves you a lot.
Right. Right. Thank you so much, John, for those awesome tips, I would say. So
Thank you.
thank you for joining us today. It was wonderful having you, very informative, and it's always a pleasure having you on our show. So thank you
So
once
God
again.
bless you. I appreciate you having me on.
All right. So have a happy H1B season, I would say, and I hope to see you soon once again. So hopefully we can catch up soon.
I
Bye
would love it.
bye.
Thank you so much. Bye, everybody.
So, friends, you can also contact attorney John Q. Khosravi, and you can do so by calling him up on his number 818-934-1561, or mail him at info@jqqlaw.com, and go visit www.jqqlaw.com to get to know more about John Khosravi. And also, you can email me or call me or WhatsApp me on my number. And my phone number is 408-335-6444. And email me at nipa@staffingly.com. So thank you once again, friends. Don't forget to subscribe to our channel, hit that bell icon. And our handle is Immigration Talk Show. We are not only on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. So check us out, follow us, and connect with us. Thank you. And yes, stay tuned on Immigration Talk Show for more on immigration. Bye for now. Hello, everyone, and welcome to another episode on Immigration Talk Show. I'm your host, Napasa, and I'm going to be there with you for this next 1 hour on a very, very interesting discussion with our guest for today. And before we have our guest join us, I have this very important disclaimer to keep in mind. So, friends, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, welcome to Immigration Talk Show. It's really nice that you have joined us. We are streaming live right now on YouTube. And also, you can check us out on LinkedIn, Facebook, X, Instagram. And please feel free to connect with us, friends. And also, don't forget to subscribe to our channel at Immigration Talk Show. And you can also participate in this discussion by commenting wherever you're watching. And also, you can join us on call, maybe ask your questions directly to the attorney. And that you can do so by calling on this number 425-436-6335, and the access code is 988-888. So, yes, and without further ado, friends, today's guest is none other than a very familiar face, Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And it's always lovely to have you, Chand. I hope you're doing good today as well.
Thank you, Nipasa, and thank you very much. And then hopefully we'll have another very fruitful and very informative session today. We're going to talk about the perms, the relevance of perms, especially to the folks that are on H1B, working on H1B in United States, because there are term limits. There are limits on how long somebody can stay in US on a temporary non-immigrant visa, such as H1B. So we will talk about all the nuances and things concerning the time limits that will help them extend their stay on H1B in this country.
Right. And friends, it's going to be very interesting. Maybe you can join in with your questions because we're going to be here for the next hour. And yes, we'll be happy to answer to your questions as well. So join us in this discussion. Chand, I'm excited. So I think we should not wait too long. Start off with some of our questions, So I have one first question to you, and that is, if you could tell us about what happens when an H1B worker reaches the 6 year limit, since that is also our topic, and are there any immediate extensions available?
Sure. So one thing that anybody that's on H1B should realize and remember is the H1B can only be used for a maximum of 6 years. That's the general rule. And each time somebody applies for a H1B, they can typically get an approval that is for a max of 3 years. So somebody gets a H1B, they can get a 3 year H1B. They go for an extension, they can again get another 3 year H1B, and the limit for that is 6 years. So the general rule by regulation says somebody can be on H1B only for 6 years. And the reason for that rule is because H1B is supposed to be a temporary visa. It's a temporary non-immigrant visa where somebody utilizes H1B to come and work in United States, but on a temporary basis. So that's how this 6 year rule came about. And then eventually what happened was, what if you need to stay in the country and work for more than 6 years? And the Congress, so basically what happened was they went and the regulations got changed. And the rule is, yes, you can extend the H1B after being in the United States on H1B for 6 years if certain conditions are met. And so under certain conditions, they can extend it after 6 years. And the main condition is the green card process should have started. So somebody should have an intent to get a green card. Somebody should have an intent to stay as a long-term permanent resident in United States. Only then somebody is eligible for extensions after they cross 6 years on H1B. How is this possible? So the first thing is the perm application. So typically people are on H1B. They need to have a sponsor. They need to have a sponsor, and typically that sponsor is their employer. That employer should sponsor their green card, and they have to be at a certain stage of their green card in order to qualify extensions that cross 6 years. And the way that works is employers typically have to do something called a labor filing, labor uh, perm application. So if the labor certification is filed, it's filed by the employer. That is the very first step when a company tries to sponsor somebody's green card, labor. So if this company sponsors labor, they file the labor. And if that labor certification is pending for more than 12 months, technically, again, they are eligible for extensions. So if somebody's company has filed a labor application, it's called 9089 application. If it is pending for more than 365 days, USCIS will agree for an extension. Or there is something called an I-140. So I-140 is an immigrant petition for an alien worker. Typically, this is again applied by the employer. So if the employer applies for an I-140 and they get an approval, so that is another way where somebody can again get an extension after they cross their 6 years. And again, there are some ways where somebody can self sponsor their I-140. There is something called EB2NIW, National Interest Waiver. There is something called EB1A. So there is this process. So if somebody applies for their own I-140 using these categories where they can self-sponsor and they have an approval, that is another way where somebody can apply for an extension. And the general rule is, if you're not in the process of getting a green card, if you're not in a spot where you either have an I-140 approved or your labor certification is pending for more than 1 year, you will not be given extensions. So from a general perspective, people have to make sure that if they do want to stay in the country for a longer time and they want to stay and work on H1B, the only way is they have to get the green card process started, and they have to be at a certain stage to ensure that they can extend their H1B after 6 years. And if this is not done, the only way they can stay back in this country is by transitioning to another visa type. Maybe if they're eligible for O1, maybe if they're eligible for L1, something like that. They have to transition to another visa type. And if that is not possible, and if they want to stay on H1B, they have to make sure that either the I-140 is approved or the labor application is pending for more than 365 days.
Thank you so much, Attorney Chand, for highlighting how important is 6 year limit to keep in mind, and also extending at the right time if you are eligible for any extensions as well. So, thank you, and we will discuss further on this. So, stay with us, and also hi to Bhavini. Thank you for joining us on YouTube. We will take up your question, but in some time. So, stay with us. So also, Chand, my next question is about filing a perm. Can filing perm application before the H1B 6 year limit help extend an employee's stay in the US? I mean, you already discussed about it a bit, but if you can tell us further, and what are the key deadlines, to keep in mind?
Yes. So filing a perm application. So perm basically means program electronic review management. That is that is what the perm stands for. And from the form perspective, it is called the form 9089. So if this application is filed, and this is done before the 6 year limit is done, under certain circumstances, it can help extend an employee's stay in US. So that is like the first and foremost thing that typically everybody that is on H1B should aim for. Basically, convincing their employee that they're a valuable employee, and it it makes sense for the company to sponsor their perm process. And perm is a very complex process. It is also expensive for a lot of companies because there are mandatory advertisement that have to be placed. There is a recruitment process that the company has to follow. There is legal fees. So it's a pretty expensive process. Not only expensive, it is also a complex process. So for that reason, a lot of companies typically, unless they see a real good reason, they will not file the perm. And the reason for that is the money and the cost, and also uh, the long term need. So the company has to be convinced that they're hiring somebody, they want somebody to be their employee for a long time to actually sponsor their green card. And once the company is convinced, that is where the company will start filing the perm. And the key deadline is the company has to file the perm before the H1B workers 6 year limit is reached. And when we talk about 6 years, we're talking about 6 years overall. So it's not just with that particular employer, but the H1B throughout that employee's time in US. So it is time counting the prior employer's time period, any other employer that the employee might have worked under H1B, and so on. So the total time with all the employers, former employers together on H1B is 6 years. The max is 6 years. So before the 6 years limit is crossed, the employer should file for the perm process. And the big rule is, if uh, the perm should not only be filed before 6 years, but the perm also has to be pending for at least 1 year. So if the perm is not pending for at least 1 year, again, you cannot get extensions unless your I-140 is done. So what that means is, you cannot really wait until your sixth year to have the employer file for the perm. So the perm should already be pending for at least 1 year. So what that means is, before your fifth year ends, the company should have filed the perm for you. Because if the company files the perm for somebody before fifth year, then when during the sixth year, when they're ready for their extension, it is already pending for at least 365 days. So the rule is, on the day you want to get an extension filed, the perm should already be pending for 1 year. So the bottom line is, if the company does not file the perm application before fifth year, you are at high risk, because you're getting very close to your sixth year. And once the sixth year is done, unless the perm is pending for pending for 1 year, or the I-140 is complete, you pretty much have to leave the country or convert to another status. So that is like one of the main things with the deadlines. And the other option is I-140 approval. So if the I-140 is approved before your sixth year, you're good. And what that means is, to file the I-140, you require the perm if the employer is sponsoring you. So you have to account for that timeline. If not, what a lot of people are also considering nowadays is EB2 NIW. So EB2 NIW is something that a lot of people should explore. The reason is, if somebody's in the country for such a long time, they're contributing to US and they're working in a field that is of national interest, and you have a very high pay, you more than likely, depending on your credentials, you might qualify for a national interest waiver. And the way it works is, you will file an I-140 under EB2 NIW process, and you can do it in premium. And what that means is, you have to account for the time. So you probably will need about 6 months, because in case you have an RFE, you have to account for that timeline. So if you have about 6 months of time, you can at least explore EB2 NIW option in case you are qualified. So the bottom line is, at least by the end of your fifth year, either your EB2 NIW, or hopefully the perm process, if they start, more than likely you are in good shape. So in terms of the key deadlines, you always look at your 6 year limit. So everybody should keep in mind what their 6 year limit is. And based on that, always aim to have the perm filed at least 1 year before that deadline. So that is the crucial deadline that everybody should keep in mind. And if it is not done, you are at risk when the 6 years is done. Because I do know a lot of people who have completed their sixth year, they don't have their perm application pending for at least 1 year, their I-140 is not done, and unfortunately they had to leave the country, they have to go back to India, wait until this entire process is done, and then reapply and then come back to US.
So it's very important. Thank you so much, Chant, for highlighting the deadlines and dates to keep in mind, at least to keep how much buffer time. So 1 year, 365 days at least. So thank you, Chand. And also, hi to Nilanjana. Thank you for joining us with your question on YouTube. We will take them up very soon. So stay with us. Also, Chand, if you could tell us about this. What is the role of an I-140 petition in securing H1B extensions beyond the 6 year cap?
So, in the last few minutes, we talked about two ways that one can get an extension after 6 years. One is uh, by showing that the perm application is pending for at least 1 year. The
Yeah.
other option is I-140 being approved. So these are two ways where somebody can get an extension done, and there is a difference. So if perm is pending for at least 1 year, but your I-140 is not done, what typically happens is, yes, you're eligible for an extension, but you can only get a H1B for 1 year. So if I-140 is not approved, but perm is pending, one is still eligible to get an extension, but they can only get a 1 year approval. And say the I-140, so I-140 petition. So if the I-140 petition is approved, the beauty is that you are eligible for a 3 year extension. So if I-140 is approved, you're getting a 3 year extension. So the eventual goal is to see an I-140 petition that is approved. And doing so, you will be guaranteed to get an approval for 3 years when you apply for your H1B extension. And I-140 approval, again, it's two types. One, an I-140 where your employer is filing for you because they have sponsored the perm application. That is the most common way people get their I-140 done. The second uncommon way is you self-sponsor I-140. You can self-sponsor I-140 under EB1A category if you qualify, or you can self-sponsor under EB2 NIW, National Interest Waiver, if you qualify again. So the goal is either you self-sponsor your I-140 if you're qualified, get an approval, or have your employer file the I-140 following the perm process. And after the perm is certified, they file the I-140. And the goal is try to have an I-140 approval before the 6 years, because that will guarantee 3 years of approval. And that's always better than just showing the perm that the perm is pending for 1 year and getting an extension. Okay. And I-140 does impact the H1B workers stay, because technically without an approved 140, you either have to leave the country, or maybe the max you'll get is a 1 year extension if your I-140 is not approved. And I-140 being approved, you are eligible for 3 year extensions. And also the beauty is that if your I-140 is approved, and the I-140 is approved for at least 180 days, you can technically, you can even transfer your employment. So down the line, if you get a better offer, you get a better job offer from another employer, you can always change your employer. The I-140 stays with you. So the date, the priority date, and the approval copy stays with you. What that means is you can apply for your spouse's EAD card, H4 EAD, or you can apply for your transfer, even though that I-140 is with the previous employer. That I-140 can still be used to get your 3 year extensions. So even after your 6 year period is done, if your I-140 is approved, so theoretically you can use that approval to keep on extending your H1B until your dates are current. So the key point is try to get an I-140 approved uh, based on how you're qualified before your 6 year period is done. And doing so, you can guarantee that your H1B can be extended till the dates are current.
Okay. All right. Thank you so much, Chand. And well, also, what if a perm labor certification is still pending close to the 6 year H1B limit? So, what options does the applicant have in that case?
Sure. So if the perm labor certification is still pending, what that typically means is the I-140 cannot be filed. Only once the perm labor is certified, the company can sponsor the I-140, can file the I-140. And nowadays, unfortunately, what is happening is perm is taking a very, very, very long time. From the date somebody applies the perm, it is taking almost 15 to 16 months to get a perm labor certification. This was not this way about 2 years back. So what has happened was they changed the perm system. So previously, the perm used to go through a different system. The system used to be called a PLC, and now they changed the perm to a new system. Now we use something called flag. We use the flag system for perm labor certifications. And when they made the change, because things got changed a little bit, we are seeing extreme delays in perm labor certifications. So once the perm is filed, a couple of years back, it used to take 4 to 5 months to see the perm certified. Now it is taking almost 15 to 16 months. So, and what that means for everybody is until your perm is certified, your I-140 cannot even be filed. So you not have a I-140 approval. And what that means is tomorrow you can, I mean, tomorrow if you have a very, very good job offer from another company, you cannot even take that job, because if you are close to your 6 year limit, even if you get a job, even if you try to change your job, you might not even be eligible for 3 year extension. So you cannot, you're in a spot where you can't even take up a good job offer if you get a good job offer, because your perm labor is pending, you're getting close to your 6 year limit, and your I-140 cannot be filed. So, so in terms of options, what people typically can do is, if your perm labor is a, if your perm labor, even though it is pending, if at least 365 days have passed, if your perm is pending for more than 365 days, you can at least apply for an extension. The only challenge is you can only get 1 year. So even though technically you can apply for an extension, you're only getting 1 year. And 1 year extensions are always risky, because if you go for stamping, you'll only get a visa for 1 year. And again, after 1 year, again, you have to file your H1B. And again, we don't know what kind of rules will change in the next 1 year, and so on. So theoretically, the good news is, yes, you can get an extension, but that extension is only for 1 year. And that is only if your perm is pending for 365 days or more. So how do you tackle this? So the way you can tackle this is to get your perm application filed as early as possible. Don't even wait until it is fifth year or sixth year, your perm has to be filed as early as possible. And what we tell people is, try to work with your employer and try to get it done in the very first year of your employment. Convince your employer, show your work product, convince them that you're a good employee, convince them that you have the talent, and try to convince your employer to file the perm as quickly as possible. If the company is not filing your perm in the first or second year of your employment, it's probably too risky to stick to that employer, because tomorrow when it is time, when it is close to your 6 year time period and your perm is not done, right now we are talking about 15 to 16 months to get the perm application done. But to even file the perm, there is almost a 6 to 8 month of work that needs to be done before the perm is filed. There is something called prevailing wages. The company has to apply for prevailing wages take 6 to 7 months. After prevailing wages, the company has to do recruitment is another 2 month process. So by the time you add the prevailing wages, recruitment, applying for the perm labor, and then applying for the I-140, you're looking at almost 2 to 3 years nowadays. So if you are working for a company that is delaying your perm process, you are at risk. You are at risk for 6 year. Once you cross your 6 years, you are at risk for getting extensions done. In case something happens to the perm, you get a perm audit, and say the perm fails, tomorrow you are at huge risk. So for that reason, what I think everybody should do is file perm as early as possible to maximize that your extension will not have any issues. And again, if your employer doesn't look like they're filing the I-140 or perm pretty quickly, explore the EB2 NAW options, explore the EB1A options, and see if it is something that you might qualify. And another option is look at the O1 visa option. So the O1 visa does not have the 6 year limit, and a lot of people who are who do have extraordinary ability in their field might qualify for O1 visa, and a lot of people are exploring the O1 visa option. So O1 visa option is another option that people can explore if they feel that their perm is getting delayed. So if not, you are at risk. Uh, so so what it means is, uh, do apply for perm, do make your company apply for perm as early on as possible. And if you feel that the company is delaying your perm and it is dragging the process, you might have to explore finding a job with another company, because you don't want to work with a company where tomorrow they're not doing the perm processing on time. Because what that would mean is, by the time your 6 years is over, you might even have to step out of the country, you might have to leave the country because you're not getting an H1B extension done.
Thank you so much, Chand, for taking that up as well, and also, for highlighting how important it is. So, hi to Ganesh. Thank you so much for joining us. I think we should quickly address some of our viewers' questions. Let's start with Bhavini. I'm currently in my fifth year of H1B, and my employer just started my perm process. Given that perm can take months, what happens if I hit my 6 year limit before my I-140 is approved? Can I stay in the US while waiting?
So at least the good thing is, looks like your employer has actually started the perm. And so right before your 6 years expires, so your H1B approval copy, you can see when your current H1B expires. So before that date, your company will have to apply for an extension. So so when they are applying for your extension, if they've already crossed 365 days of filing the perm, you probably will not have any issue. Even if your I-140 is not approved, they can still ask for an extension. The only problem is, you only get a 1 year extension, not a 3 year extension, but at least you can get an extension. And if it is fifth year, the big challenge is the perm itself. After applying the perm, it is taking almost 15 to 16 months to see an approval. And then you have to file an I-140. The good news with I-140 is you can do it in premium processing. You cannot file the perm in premium processing, but you can file the I-140 in premium processing. So if luckily just before your extension is required, if your perm gets approved, you might be able to do your I-140 in premium. But worst case, if the perm on that day, the day your extension is required to be filed, if your perm has crossed 365 days, yes, you're good. If not, this is what you should do. There is something called recapture. So recapture means, say you travel out of the country, you stay in India for a month, or in the past you have traveled to India, you've taken a vacation, you've traveled to some other countries. You can count all those days, and you can recapture all that time and add it to your 6-year period. So what that means is 6 years is the time you're able to physically stay and work in this country on H1B. It is not the approval time period. So in the 6 years, whatever vacations you have taken and gone out of the country, you can count all those days and you can do something called recapture. And those days can be tagged on, can be added on to top of 6 years, and they can extend your H1B. So what you should do is check with your company and see how much of recapture time you have. That can be added. And then the next thing is see if your perm is going to be pending for at least 1 year by the time your extension is due. So doing so, you can add and get your extension done.
Very interesting. And thank you so much, Sean, for taking that up for Bhavini. And recapture is another very interesting, way, I think, to count your days. So, yes. And we have Nilanjana now. Nilanjana. My employer started my perm process late, and I only have 10 months left on my H1B. If the perm gets delayed or denied, am I out of options or can I still extend my stay?
So looks like you have 10 months stay left, and then you again you said the employer started the perm process late. Uh, at this point of time, if the perm is already filed, I think you're in good shape because you have 10 months of time and the perm is already filed. I think you'll be okay because you can always uh, look for recapture option because it's only 2 months. You might be able to recapture it pretty easily by working out of the country. But if the perm process has just started, but the perm is not actually filed, then I think you are at risk because when you say the perm process has started, they start off with the prevailing wage process. Then they do the advertisements and mandatory recruitment and so on. So that will take a long time. So the whole thing is if your perm is already filed, I think you're in good shape. If your perm is not filed yet, just check and see with your company how quickly are they going to be filing the actual perm with DOL, and then talk to them about recapture because people can always use recapture, stay out of the country, and all the time can be added on. So you definitely will have to talk and see the exact date your perm was filed. You do need to get that date, the date that perm was filed with DOL. Normally, what happens is when the perm is filed with DOL, your employer will get an email. So that email is good proof that the perm is filed. So try to get a copy of that email so you exactly know when the perm was filed. And then look at all your recapture options, how much time you have spent outside the country, because all that can be recaptured. So anytime you take a vacation, go out of the country, you can recapture and add it to the 6-year period.
All right. Thank you so much, Nilanjana, for participating with your question, and also Chan for being such a sport and answering so patiently. So we do have Ganesh's question. Sudhir, hi Sudhir, thank you for joining us on YouTube. Stay with us. So we'll just go for a short break quickly and be back here on Immigration Talk Show. And today, friends, we are discussing with attorney Chant Parvataneni from Dallas, Texas, about reaching the H1B 6-year limit and what are your options with firm. So yes, you can also have a one-on-one discussion with Attorney Chand himself, maybe about your case. You need some private time and a consultation. Why not call him up on his number 817-523-8247, or else yes, you can email him at law@spblawfirm.com and go visit www.spblawfirm.com. So now, friends, we'll just go for a short break. Don't go anywhere. It's me, Nipasa, with Attorney Chand Pravathaneni. Hello, everyone, and welcome back to Immigration Talk Show. And this will be the second part of this discussion we're having with Attorney Chan Parvathineni from SPB Law Firm, Dallas, Texas. And it's always wonderful to have you here, Chand. Always a pleasure to have you on our shows and discussing about so many various topics, including this one today. So, Chand, we have been answering some of our questions from the viewers. So let's continue and let's take up this next one from Ganesh. So Ganesh is asking,
Mhm.
I have an I-140 approval from my previous employer, but I never got a green card. I'm now working for a different company and my H1B is about to expire. So, hold
Yeah.
on. Can my new employer use my old I-140 to extend my H1B beyond 6 years?
Yeah. So again, that's a good question, and I think a lot of people, I think, will be in that situation. The reason is getting a green card when somebody is born in India or China, the countries that have a lot of retrogression. It takes a very, very long time. And for somebody who's born in India, even though you have an I-140 approved, green card is like a very lengthy process. It takes a couple of decades right now, based on the current priority dates. And people do get better job offers, like as they are progressing in their career, they get better job offers. And USCIS, I think, has made it easy for everybody. So the current rule is, if your I-140 is approved and more than 180 days have passed, so after the approval, uh, tomorrow that I-140 can be used for transfers, for 6-year extensions, for H4EADs, and so on. So what that means is, you can get a transfer done. Your new employer can use the old I-140 from the other company, and they can use it to get 3-year extensions. So that I-140 is still valid. The I-140 still will belong to you, and you should be able to get 3-year extensions. And the new employer can still use that old I-140 to do the transfer and get you the extensions.
There you go, Ganesh. All the best, and thank you for participating with your question. Now let's take up Sudhir's one, Chand. Sudhir is asking, if my perm is denied but I'm close to my 6 year limit, can I apply for another H1B under the cap exempt category, or is my only option to leave the US?
You- Um, so normally, if your perm is denied, the company should be able to file a motion or file an appeal, and then go back to DOL, and the doing so. So if your case, so if your company is appealing your denial, the good thing is your company should still be able to apply for 1-year extensions, because the perm is denied. But again, if the company is fighting it and company is filing a motion, filing an appeal, uh, while that thing is in process, your company should be able to file for extensions. So you don't really have to leave the country. And if the company is going to fight your denial, you might be able to get extensions. Uh, and the other question, can you apply for another H1B under cap exempt category? So if your 6 years is done, because a lot of people will be in this spot where the 6 years period is done, they don't have a perm or they don't have I-140. So to apply in the lottery, to apply in the new H1B cap as cap exempt, to apply in the lottery, you have to stay out of the country for 1 year. So if you stay out of United States for 1 year, then you can again come back in the lottery. If not, technically you have to argue under the cap exempt category and try for extension. Okay, so you can't go through the lottery if you have been in United States, if not left the country. If you left the country for at least 12 months, then you can go through the new lottery and again get fresh 6 years. But if not, I think in your case, your best bet is your employer will fight the denial, go back to DOL, fight the denial, and based on fighting the denial, based on filing the appeal, you might be able to get 1-year extensions.
All right, so you mean if it is a cap exempt category, it doesn't count within the 6 year limit, does it?
Yeah. So if cap exempt means they don't come under the
Mm.
lottery. So they're exempt from the cap. So what that means is you have to prove that you're exempt from the cap. And the way you'd show it is you'll show that you have been counted in the cap, which in this case it is very easy. He has a previous H1B approval. So he will show that H1B approval to show and argue that he's exempt from cap. But then again, the next challenge is, if you're exempt from cap, you can only use a max of 6 years. So if you cross 6 years, you need to have the perm. In this case, since the perm is denied, by appealing and by fighting the denial, he might be able to prove that he's still cap exempt.
All right. Thank you so much, Chand, for taking that up. And now, quickly saying hi to Srinivas. Thank you so much for joining us on YouTube. I wonder where you have joined us from. And he has a question, Chand. Hi. I completed my H1B 4 to 5 years out of 6 years back in 2017 and spent 7 years outside US and came back to US in 2024 on extension. Does it reset my 6 year period? I still have 7 months left.
No, it does not reset the 6 year period. So, if somebody has completed 4.5 years on their H1B, so when he went out of the country in 2017, spent some time and came back, he is only eligible for that balance period. So he has already used 4.5 years. So the balance period is 1.5 year. So that 1.5 year is what he can use when he's coming back. If he wants to get the entire 6 years back again, you will have to go through the cap lottery, and then by going through the cap lottery, only then you'll be able to get your 6 years back. If not, in your case, because you are using your prior H1B, so whatever is the balance out of that 6 years, in your case, it is a year and a half. That is all you can get, and what that means is you really have to get your perm either certified, or at least it should be pending for at least 1 year to qualify for your extensions.
Right. All the best, Srinivas, and I hope that you figure out soon. Thank you, Chand. And we have addressed some of our questions from the viewers. We will also address some questions from Facebook groups. So, Control, if you can also display them, please. And also, friends, I would like to tell you, you can join us on call, and all you have to do is dial this number 425-436-6335, and the access code is 988-888. And also, please feel free to comment wherever you're watching us right now. And if you haven't as yet subscribed to our channel, subscribe to Immigration Talk Show. That's our handle. And you can also find us on LinkedIn, Facebook, X, and also on Instagram. So this first question, let's take it up. It is from Bilawal. It's from LinkedIn asking, I want to apply for an H1B visa process. Okay, that is it. So what do you suggest this Bilawal should do?
So yeah. So the good thing is right now the H1B lottery, the H1B registration, it's in process. It just started on March 7th. It will end on March 24th. So the first and foremost thing that anybody wants a H1B should do is find a bona fide and a genuine employer. So that is the very first step. And that employer should be willing to sponsor and have a job offer. So if a company has a job offer, that company will have to enroll somebody, register somebody in the H1B registration process, the process that has just started. After that, more than likely we'll have a lottery. We have been having a lottery every year for the last decade. So assuming that the lottery is done, and if somebody is selected in the lottery, then the company will have to file the actual H1B with United US CIS, United States Citizenship and Immigration Services. And once that H1B is approved, you will have to go for stamping and then come into United States and then work on H1B. So the bottom line is you need to have an employer. You need to have an employer that has a job offer, and that employer should sponsor you, put you in the lottery, get that selection, and once that selection is done, file a formal H1B petition, and then get you into the country to start working on H1B.
Okay, okay. Thank you so much, Chand, for taking that up. And also, Srinivas from some time back is saying thank you. Thank you, Srinivas. And if you have any more further questions, keep commenting. And now let's go on to our next one. This next question is from an anonymous participant asking, hello everyone, I'm currently on H4 visa and I have 11 years plus experience in IT, 7 plus as clinical SaaS programmer, and the 4 years as a senior associate. I need, yeah, I
Senior
need to
associate.
know if someone can help me register for H1B 2025 lottery.
So again, I think it is very important that everybody works with an employer who is reliable, who is genuine. And I think what you should do is you should look at job postings on LinkedIn, Dice, the websites that a lot of technology companies use, more than anything, I think what you should do is you should do your own background research on the company, and Google is like the fastest way to start off research. See if that company has filed H1Bs in the past, if that company is big, and also try to get like some individual referrals. Don't go with, because H1B side, majority of the companies are good, but there is always fraud. And the H1B is something where you should always work with companies that are genuine, that are reliable. And what that means is try to do your own independent research, try to get referrals. I mean, like if your friends have worked with some companies, and it's first-hand information that the company is reliable, that is like always the best way to verify things. And then you always should look at like this reliable websites. And next and the foremost thing that I think I should warn everybody is H1B is something where the employer has to pay the fees. Employer cannot demand fees from you. Employer cannot ask you to pay any fees, whether it is legal fees, whether it is government fee, or whether it is an extra money for doing the H1B process. So my thing is, if a company is asking somebody to pay, they're asking you to pay some H1B fees, the company is definitely, I mean, you have to think twice before going with that company. It is very important that the company pays for the H1B fees. At the stamping nowadays, when somebody goes for stamping, these questions are asked: did you pay for the H1B fees? Has the employer charged you? At the port of entry, even if you get a H1B visa, entry is not guaranteed. At the port of entry, again, that question will be raised. At site visits, that question will be raised. So the bottom line is, if a company is sponsoring H1B, the company has to not only sponsor you, but also has to bear all the fees associated with H1B. And that is one way you know that the company is reliable. And always do your own background research, Google and all these places. And then you cannot pay the H1B fees. H1B fees is something which the company has to pay.
Right, right. And with especially the fee increase, I'm sure that many companies are going to think about who to spend for the $215. But yes, thank you so much, Chan, for taking that up.
Yeah.
And we have more questions. So, Control, if you can display that, please. Mohit is asking, hi all, I find myself in a strange situation. I got laid off today. The company refused to sponsor my visa in November. I have been trying to switch before the lottery deadline, but have been unsuccessful so far. I have 5 months to look for a new role. This could this would have been my last lottery attempt. My STEM OPT ends in January 2016. What are my options? And is enrolling for a day one CPT course worth it? Will employers whom I interview willing to bring me on just on my day one CPT? Sorry about my flumming. And any guidance is appreciated.
Sure. So if somebody is on STEM OPT and they got laid off, they can be unemployed for a maximum of 150 days, and that is where I think the 5 months is what the person mentioned in their post. So one can be unemployed for a max of 5 months, and anything more than 5 months will be treated as being uh, uh, failing to maintain their valid status. So up to 5 months, yes, one can be unemployed, but if they cross it, there is a problem, and before 5 months they have to find a job. That being said, uh, because his STEM OPT is expiring in January 2026. And what that means is, if he does not have an H1B sponsor, if he does not have an H1B employer file for him this year, uh, in January, his STEM OPT is going to expire, and he'll be out of status and he'll have to leave the country. So again, pretty much it is pretty important that he finds a sponsor before March 24th. And if he does not find a good employer, a bona fide employment before March 24th, what that means is more than likely he's losing his H1B chances this year. And come January, he will have to leave the country or change to another legal status. So I think he has a risk. But the good thing is there is another couple of days, and if you find an employer before that time, you get an H1B registration done, you get selected in the lottery, you'll be in good shape. If not, I think I do see a challenge. And day one CPT is always questioned by USCIS. Day one CPT has a lot of restrictions. It is legal. The only thing is you do have to make sure that you're following all the requirements, you're attending classes, you're progressing towards your degree. And not only that, the CPT should be integral to the curriculum, and then there should be a compelling reason why day one CPT is required by that particular university, by that particular program. So for this reason, we always see a lot of RFEs for day one CPTs. So it could be legal. The only thing is, because there is a lot of burden, you always have to think twice and make sure that you're following all the rules of CPT before getting enrolled in a CPT program.
Okay. Thank you so much, Chand, for highlighting some of the challenges of day one CPT as well, and yes, taking that up. So now let's go on to our next one, and this is from Angela. I'm Angela, currently pursuing my business administration degree and will graduate in May 2025. My EAD card is approved and I'll be ready to start work on July 14th, 2025. I'm looking for any job opportunities in business related fields and would love to connect. If you know of anything, okay, this is probably somebody looking for a job, but control if we can have another question and be. This is from Sagnik. My previous visa was F1. Have scheduled a Dropbox for H1B visa, first time stamping at Chennai for March 7th, 2025. Do I need to channel and schedule office and interview? My hometown is Kolkata. Can I schedule for both office and interview in my hometown? Can I reschedule the appointments now or do I need to wait till March 7th?
I'm not sure. I think the poster's prior visa was F1, and so I think the current visa, I think, is scheduling for a Dropbox H1B visa stamping. Um, so I think so. What has happened is recently they've changed rules, and now if it is first time H1B, uh, they still have to go for Dropbox, because in the new rules, what has happened is one is eligible for a Dropbox only if they already had a H1B in the past. And not only that, that H1B should currently be active or should have expired in the last 12 months, a very recent expiration of the H1B visa. If that is the case, now they're eligible for Dropbox. And because of that new rule that came out in February, what is happening is anybody that does not qualify for a Dropbox appointment, interview waiver, all those appointments are being cancelled by the consulates, and they're being rescheduled. So in this case, more than likely, it is better for you to reschedule it if the consulate has already not rescheduled it. If not, more than likely they will cancel your appointment, because in the old rules you're qualified for a Dropbox, but in the new rules, because this is first time H1B, your prior stamping was with F1B, sorry, with F1. You definitely will be called for an interview. You will not be eligible for an interview waiver. So definitely you will have to check with the consulate. Maybe they already rescheduled it. They already canceled your appointment. If not, it's better to reschedule it and go for an in-person interview.
Okay. All the best, Agnik, and thank you so much, Chand, for taking that up. And we have Srinivas actually back again, so I think we should take them up as well. So let's address Srinivas's first. I am in my sixth year of H1B, and my employer has not started the perm process. I still have 7 months to complete 6 years. Are there any options left for me to continue?
So if the company has not started, so basically when your company applied for your H1B, more than likely last time they only got 1.5 year. So they did not even probably have received a 3 year approval. So if you look at your approval, you more than likely see that it has been approved for a year and a half, because looks like you've used up 4.5 years previously, and you only have year and a half left. So at the time, you're close to getting your H1B done. In the current fashion, you more than likely will not be able to extend it. So the only way is your company will have to start the perm process. And if they at least start the perm process, some people, what they do is the company will start the perm process. You go to India, and you're probably working from India, and then that gets you to that 1 year deadline, and then your company will apply for an H1B extension and then bring you back in. So you definitely will have to talk to your employer and see where your case is, your perm cases, because you more than likely you would have a challenge when it gets to your extension time period, and looks like you don't really have a lot of time for your extension. So just check with your employer to see when your H1B is expiring. You probably have a copy of your approval, and try to get your perm processing at least started right away, because worst case you might be able to recapture, travel to India, work from India for a couple of months, add that timeline, and then apply for an extension.
Right. Thank you so much for taking that up for Srinivas. Thank you, Srinivas, once again. And we have Sakshi now asking another question. Hi, Sakshi. Thank you. Yes, we could definitely take up your question. And she's asking, can we able to change employer with I-797B consular approved copy while I'm on STEM OPT? What might be the complications involved?
Sure. Definitely, it can be done. We have done that a number of times, and it should not be a problem in general. So the only issue is you're assuming that your approval copy has not been revoked for fraud or misrepresentation. The prior copy, the prior counselor approval copy, if that has not been revoked for fraud or misrepresentation, you should not have a problem. You can either have the same company file for a change of status, you can change your employer, a new employer can file a H1B for you under change of status or as counselor process. And the way they would do it is they would argue that you're cap exempt, you've been counted in the cap previously, your approval copy is proof that you've been counted in cap, so you're cap exempt. And based on that reason, the new employer can transfer and can file a H1B for you. You should, I mean, unless there is a revocation, unless there is some fraud or misrepresentation in your prior approval, if that has not happened, I don't think you should have any problems at all.
Absolutely. Thank you so much for taking that up. And friends, I would like to tell you that you can also join us on call. Why don't you join us on this number 425-436-6335, and the access code is 988-888. So it'll be really nice if you could join us to ask the questions yourself to Attorney Cham. Sakshi, Sindhura, let's take up Sindhura's comment. I am an F1 visa student and would like to understand my path from F1 to H1B and eventually a green card. Could you please guide me through the steps through employer versus self employed? Both.
Sure. So the most common way is through employment. So what you would do is you're on F1 visa, and once your F1 program is done, normally what happens is you typically will be eligible for OPT, optional practical training. And when you get your optional practical training, what you do is that gives you an opportunity to find an employer, because the beauty of OPT is you don't need any sponsorship. So because of that, a lot of employers will be willing to sponsor. I mean, will be willing to hire you. So so a lot of people, they use this OPT, get employment, and while working with the employer, they impress the employer that they're a good employee, and then the employer will sponsor the H1B. So typically, the employer will register you in the H1B lottery, and then file the H1B, and then you start working with them on H1B. And then the employer eventually, what they will do is they will sponsor your green card. And sponsoring the green card is basically filing the perm, getting through the perm, then filing the I-140, getting through the I-140, and then you waiting until the date is current to get the green card. And the country of birth makes a lot of difference. So if you're born in India, for example, India is extremely slow because the dates are backlogged. So somebody born in India will take a very, very long time to get a green card. And if somebody is born in Pakistan or Nepal or Bangladesh, for example, because those dates, they come under the rest of the world category, there is not a lot of demand compared to India or China. India and China are countries that have a lot of demand, a lot of retrogression. So if you're not from one of these countries, typically your process is quick. You can get a green card a lot quicker than these two countries. So that is what is the normal process. The other way is self sponsorship. So USCIS, they passed some new regulations this December, and starting from January, they said that you can self sponsor your H1B. So if you start your own company and you show a business plan, a legitimate business plan, and you show what you will be doing for your own company, you can also self sponsor your own H1B. It can be done. The burden is very, very high because you do have to establish a company, and then you do have to show what your company is doing and all those things. But if you have a great idea and you are a startup, you can self sponsor your H1B. And that's another route. Self sponsorship is a little bit more difficult, which is why a lot of people don't go that route. But again, if you have a promising idea, you have a startup, you have probably good funding, that's another way to explore. But the most common way is you will get a OPT, you find employment, you find a good employer, that employer files H1B, eventually work towards the green card process.
There you go, Sindhura. You have it all there. Thank you so much, Chand, for patiently taking up all these questions and comments for us today in this session. It was very interesting. Well, we also got Sakshi again asking, what should be the minimum pay employer must pay on STEM OPT to employee? Can it be more than I-983 planning training plan? And what should be the minimum in I-983 training plan?
Sure. So the I-983 is a document that the employer has to follow and has to make sure that uh, work is being done as per that particular 983. And when you talk about minimum pay, H1B has a minimum wage. So if somebody's on H1B, you look at the LCA, and the LCA is the minimum that an employer can pay. And when it comes to STEM OPT, the minimum is so USCIS does not say a per se minimum. There is nothing like an LCA requirement, but there are state minimum wage laws. So every state has a minimum wage law. So for example, Texas, it is $7.25 per hour. That's the minimum. Anything lower than that, DOL will immediately step into the picture, and it is a violation of law. And again, some states, for example, some states have $15, some states have more than that. So every state has something called minimum wage, and you can just Google your state and say minimum wage, for example, state of New York, for example, you will see the minimum wage. So no employer, no company can pay anything less than the minimum wage. So pretty much every employer is required to pay at least the minimum wage. That is the general rule. And on top of it, normally what the companies are supposed to do is they're supposed to meet industry standards. So if company is like completely like paying very very low, suppose the industry standard is the range is like this to this, if the company is like depressing the wages, paying a very very low salary, tomorrow if there is an audit, that company will have to explain, because the goal of the OPT program is not to depress US wages. So the company should try to keep wages at a market level. So even though legally on a DOL side, the minimum requirement is meet the minimum wage, in general the good practice is the companies should not use the OPT program to depress the US wages. They should meet the market wages. And everybody's role is different. If somebody is working as a software engineer, it is different. If somebody is working as a pharmacy trainee, for example, things are different. If somebody is working as a validation engineer, again depending on what state you are working in Texas it is a different wage, New York City it's different, Bay Area it is different, if it is a small town it is different. So that is why what the company should do is they should make sure they meet the minimum wage on a bare minimum, and on top of it they should match whatever is the market standard in that particular city for that particular role. And if they pay more than that, it is always good. If they pay less than that, that is where there are problems from USCIS, DOL, sometimes even DOJ, because sometimes if things are not being followed and it is depressing US wages, or there's some kind of discrimination or something of that sort, sometimes we see even DOJ, Department of Justice, step in, because sometimes people try to hire people on a specific work visa because they feel that they can give low salary. So we have seen cases where DOJ will interfere and say you're discriminating and preferring people on this particular visa status to pay them a lower salary than the industry standard. So there are so many things. The general rule is if the company follows market standards, they will be in good shape.
Thank you so much, Chand, for taking that up for Sakshi. Sindhura says thank you. Thank you, Sindhura, as well for your question. And now, Geeta. We have I-140, and in the month of June, we have to renew our H1B. What challenges to renew?
So if you already have an I-140, at least you will not have any problems with the 3-year extensions. So the 3-year extensions part, it's not a problem at all. So the next challenge is the company making sure they have a bona fide job offer and proving to USCIS. Prior to January 18th, the rules were a little bit different. Starting from January 18th, they added some more additional burden. Now you have to, if you're working on a client project, you have to show the nature of their assignment. So maybe a purchase order, maybe client vendor letters, etc. So as long as the company is making sure they prove that the job offer is bona fide, they prove that the company is legitimate, I don't think you should have any surprises in your H1B. So at this point of time, in the last 1-2 months, yes, we are hearing a lot of rhetoric about immigration issues with immigration. But on the H1B side, I think the new government, I think they're still in favor of H1Bs. We are not seeing any bad RFEs. We are not seeing any approvals, short-term approvals. Prior to 2020, we used to see short-term approvals, 1 month approval, 2 month approval, 1 year approval, and so on. In the current administration, at least we are not seeing short-term approvals. As long as the company is legitimate, they're able to prove to USCIS, you should not have any problem. I think things are still smooth with the H1B
Okay.
approvals.
Okay. Well, thank you so much, Chand, Yeeta. Thank you so much for your question. And also, don't forget to like Immigration Talk Show. Also goes the same to all you folks out there. I'm sure that you resonated with Chand's response to your questions. Sakshi and also Sindhura, Yeeta, everyone actually. So thank you so much for your questions and for joining us with your questions here on this episode we had today with Attorney Chand Pravathaneni. And please feel free to also contact him, for your consultation, or maybe you really need attention. You need an attorney to guide you with your case, then why not contact Attorney Chand on his number? His number is 817-523-8247. And also you can email him, and his email address is law@spblawfirm.com, and go visit www.spblawfirm.com. Also, when you contact him, do let him know that you watched him here on Immigration Talk Show, and he'll be happy to help you and to even know that. So, thank you so much. Yita also says, thank you very much for your answer. Thank you, Yita. And Chance, before we leave, if you have any end note, to leave folks out there watching us right now. Um, yeah.
Sure. So one of the things that has been happening with the H1Bs and the perms and I-140s is the timelines are very, very bad. I mean, again, this is not nothing to do with the new Trump administration. This has started in Biden administration. The perm, what used to take, what used to be a very, very a fast process, now has become a very, very long process. They've not changed the rules. It is just that the adjudication timelines have increased. So perms are taking almost 15 to 16 months to be adjudicated. And because we have the 6 year limit on H1Bs, I think, and things are not like what they used to be a long time back. Uh, Long time back, we used to see perm approvals 4 to 5 months, used to be common. Definitely, I mean, what we're seeing now is kind of pretty rare. And moving forwards, I don't think the times will shorten. I think the times probably will stay the same. And for that reason, I think everybody that does not have an I-140 or perm filing done, you should always like work with your employer and see what they're doing. And if you feel that your employer is not a reliable employer who you think will file the perm process for you or go through the I-140 process for you, you should remember that there is a 6 year limit. So either you have to leave the country after 6 years, or you find another employer, a reliable and a genuine employer, who would be willing to sponsor your perm. Because if that is not done and it is sixth year, you'll be like going back and forth, and then you'll be in a very, very bad spot. So everybody be conscious of that 6 year limit and then the importance of perm, and do not wait until the last minute. So doing so, you'll have very less surprises when it is your sixth year on H1B.
Absolutely. Thank you so much, Chand, for joining us today and for sharing with us all these expertise and this knowledge that you imparted on today's webinar. Very important points, and I hope that friends out there took notes as well. And even if not, you can always rewatch this whole episode. Thank you for joining us. It's Immigration Talk Show. Do follow us, hit that bell icon so that whenever we have discussions like these, you are notified. And also, you can call me. You can leave a message on my WhatsApp as well. And my number is 408-335-6444. And you can email me at nipa@staffingly.com. And that's it. Thank you so much, Chant, once again. I'm really looking forward, to for you to join us maybe in the coming week. So yes, thank you everyone for joining us, and for those celebrating Holi, which is a festival also. Happy Holi ahead, and yeah, thank you for joining us today on Immigration Talk Show. It's Napasa saying bye for now. Hello, everyone, and welcome to another very insightful episode on immigration and jobs on Immigration Talk Show. And I'm really happy that you are able to join us and stay with us because a very insightful webinar is lined up for you. Of course, I'm your host Napasa, and today we will be diving into another very important topic and very timely, I would say. And before I tell you what the topic is, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, with that in mind, friends, thank you so much once again for joining us. Our topic of discussion for today is H1B season is here, and will rising deportations affect your chances? So, we are going to find out in today's webinar because, yes, there has been a lot of changes recently, and immigration policy shifts, stricter compliance measures, and so on and so forth. So, yes, H1B applicants also and current visa holders are asking, what does this mean for me, right? And will it affect their chances? And how can they prepare for this season with confidence? So to help us prepare and discuss and know further about how to prepare ourselves, well, I'm really honored to welcome a very special guest, none other than Charles Cook, a leading immigration attorney with over 35 years of experience and the author of In Pursuit of a Better Future, a comprehensive guide to navigating the US immigration system. And he has definitely helped countless individuals and businesses, to successfully manage their immigration process. And today he's here to share his expertise again, once again with us. So, yes. Hi, Charles. How are you doing? Thank you so much for joining us
It's great to be with you. I love being on with you.
today. We too. We love having you, and it's exciting that you made it here. In spite of your busy schedule, that you are here to speak
Yeah,
with us for an hour.
my travel schedule's been a little crazy recently, that's for sure. Just got back from Peru last weekend, but we are in the midst of the H1B season and the literal utter nuttiness that is the Trump administration. I don't know if nuttiness is a word they use in India, but you should learn it if you're coming to America.
Tell us more about nuttiness then.
So one thing that's important everybody to realize, today is the very first day that your company can register for the H1B visa lottery, but today's not the only day. Napas and I were talking earlier, is how's the day going? Well, today's easy because these are the cases we filed today that we've ready for, that we spent weeks getting ready and all our ducks in a row and we get our lottery entries in. But it's the ones that call us on the last day at 4 o'clock say, "Oh my gosh, I've got to get my lottery application in." Those are the ones that they're kind of always kind of a little iffy. But these are the easy ones. And honestly,
So,
Napasa, this is
yeah.
way better than preparing an entire H1B application. I mean, this is just so much better.
I'm glad. So, every year, 35 years of experience, do you, face a lot of last minute, like you just said, people on the last day who are going to call you and say, how many numbers was the highest maybe for you?
Well, we probably do. We are not an H1B shop. There's a lot of law firms that's literally all they do. That's not us. We're actually a full service law firm. We do everything from H1Bs to labor certs to EB1s to deportation defense, employer sanctions. We defend employers in H1B audits. We do the whole gamut of work at our firm. We've got 50 folks who do this stuff, and most of them have a lot of experience like I do. So for us, this is just another trip around the block. But I think this year might be a little different, honestly. First of all, it's more expensive. It's not $10 anymore. I think that will dissuade some people. I do. I think we will not get the number that I was surprised with last year, honestly. I thought it was going to be a little bit lower. I think, and especially with Trump basically about to start a recession, I think the numbers might be a little lower than last year, which is great for people that enter the lottery because it'll increase their chance of course, getting selected.
So, yes, folks, do join us in conversation. All you can do, what you can do is participate by commenting wherever you're watching. We are streaming live right now on YouTube, and our handle is at Immigration Talk Show. Well, you can also call us up. You can have a word with Attorney Charles here himself by calling us on this number 425-436-6335, and the access code is 988-888, displayed right on top of the screen. So call us. And so, Charles, what can we expect? I mean, of course, there's rising deportations every day. We have, especially before the season, I think all we were hearing is deportations, a lot of it. So, what do you have to say
You,
about that?
in a past question, would you be surprised if I told you that Trump has deported fewer people than Biden did during the same exact time 4 years ago? You'd probably be surprised by that because it's true, but it's true. See, here's the difference now versus Biden. Biden never talked about it. He never talked about it because I think he felt politically it wasn't a good thing. But the ICE machinery that Trump set up the first time, that kind of petered off during the first parts of COVID, that came roaring back. And Biden had his best year ever deporting people in 2024. He deported over 300,000 people. Trump will get to that number, but the difference now is you're hearing about it every single day in every newscast and every newspaper. And that's because Trump is a marketer, right? He's marketing it. He's selling it. He's trying to make it look like he's doing something more or better, when in fact, he's doing the exact same thing as the last guy. Now, one difference, of course, is the people running the immigration service are now tasked with not necessarily approving cases. If you go to the USCIS website, it says, keeping America secure. I didn't notice the word secure in the name of the USCIS. I thought there'd be service. That's what the S stands for, not security. But they literally got the head of Homeland Security riding a horse on their website. It's so take that for what it's worth. Take that to mean that applications will be denied at a higher rate. Remember, Trump last time, denial rates for H1Bs, 30%. During Biden, 3%. So we're going to see, again, a reapproachment to these adjudications, and not just at CIS. So this rising tide of deportation, this is going to carry over to the consulate as well. The consulates are going to get harder and make it more difficult to get visas to come to the United States. We're going to see a lot of decisions that don't make any sense. And of course, as we learned yesterday, you better not say anything about Palestine because you're not getting a visa if you do. I don't know if you saw that yesterday, but they will be revoking visas and denying student visas, and I imagine others, if your social media suggests that you're pro-Palestinian. How about that? That seems a little crazy, don't you? Don't you think?
It is, it is.
The country of free speech isn't so free anymore, is it?
And travel ban is what I also heard.
Oh, that travel ban is going to come either today or Monday. So I would suspect that it'll be the usual suspects. He'll ban travel from Afghanistan, Iran, Yemen, all the bad actors. But I suspect that we're going to see a broadening of those countries as well. One country that will not be on the list is India, because Modi's done a really great job of sucking up to Trump. And whether you like Modi or not, I mean, the reality is he plays Trump like a violin, and so that's good, and that's really good for Indian nationals. Very, very good.
Good negotiations, I would say. So yes, and deportations happening, and how directly or indirectly is it impacting H1B applicants this year?
That's a really great question. The systems that they're putting into place right now, like the registration system, for example, these things are designed to make ICE and USCIS, one, work closer together, and two, be more active as opposed to reactive. So if ICE, let's say somebody's H1B is terminated the employer sends a letter to the immigration service. That person has 60 days. That ICE is not going to come visit you on day 1. Will ICE come on day 61? Quite possible. At this stage, they're very focused on the undocumented. They're very focused on that. But they're in this for the long game. If my math is right, there's 201 more weeks while Trump is president. I would suspect by week 100, we will see a shift to really doing active enforcement against visa holders who violate their status or overstay their visas. Because the information they're gathering now and their incredibly active use of AI, very active use of AI at ICE and USCIS, is designed to let ICE have their job easier. So yeah, I think you got to be very careful. If you're in H status and you violate it and it comes to the government's attention, I think you got a problem. And if you're terminated, that's the piece of advice. Everybody wants to wait till day 60 to see if they can change to the H1B, get a new employer. I would suggest filing a visitor visa, change of status right away. And then, while you're doing the H1 search, and if you get the H1 new employer before the 60 days, just file it. And then you can withdraw the visitor visa. But this way, you're protected by the visitor visa for 6 months. So it's a much better protection. And it should avoid individuals being caught up in any ICE enforcement actions.
Well, great points. Thank you so much, Charles. And you're talking about, termination also. So, what about H1B holders, where are they at high risk of deportation if their employment is terminated by any chance? And maybe what legal options do they have?
Well, I think I kind of already answered that. And the answer is file a B1 change of status, B2 change of status, change to a visitor and protect yourself. And if you do that, you're fine. You're not at risk. If you don't do anything and 60 days lapse, I think you're at exceptionally high risk. Because remember, the government knows where you are, right? They know exactly where you live. They know who your employer was. And ICE is inherently lazy. They're not going to spend weeks looking for one person. But if they can take a drive down the street and pick up somebody in 30 minutes, they're going to do it because they all have quotas. And an H1B who's been terminated, who's out of status after 60 days, is just as good as somebody.
Mhm. Okay, so friends out there, you can also join us. Thank you so much, Neha, for joining us with your comments. We are going to take them up. Just stay with us. And also, Monali Thakur, thank you for joining us with your questions and comments. I would really suggest and appeal folks out there to join us on call as well. And our number is 425-436-6335, and the access code is 988-888. So I think, yes, we are here back again with Charles. So Charles, thank you for telling us about termination of employment under H1B, and there are consequences, of course. So now I would really like you to highlight what measures or what can applicants under H1B take to ensure compliance with immigration laws and avoid potential deportation risks.
Well, first, it's really important to remember you are hired for a very specific job. You need to be doing that specific job. You should have your H1B job description memorized. And if you're doing something different than that, you need to change employers because ICE is ramping up their audits from the FDNS, which is the Fraud Detection National Security folks. They're adding people to that. They're changing adjudicators to fraud people and visiting employers. And they'll show up out of the blue and they'll want to talk to you. And you should be conversant. You should know your H1B job back and forward. You should have your pay stubs in your desk so you can show them. You should, if you're not going to be there that day, leave a note with the receptionist at your building. Hey, if anybody comes and visits, here's where I am. Because if you're not there, they'll just think you're not working and they'll just move to revoke your H1B. So one, being in compliance with your job. Don't get an H1B as a software engineer and be working at a cashier at a 7-Eleven. That's not a good thing. It's really not a good thing. One, two, don't work outside your job. You have no legal right to work outside the H-1B employer. None. That includes remotely. You can't work remotely for a company outside the United States, in the United States, on an H-1B visa for U.S. employer. That is illegal. That will violate your status. And of course, one of the most common errors we see happen to people is they travel on their H-1B, they come back from vacation, and CBP, Customs and Border Protection, the friendly people at the airport in the black uniforms and the guns, they make a mistake on your I-94 card and they don't give you the full time. So every time you travel, you should be checking cbp.gov I-94 to make sure that your status dates are equal to the dates you believe they are, so you don't accidentally overstay. 3 or 4 times a year, we're trying to retroactively fix somebody who wasn't paying attention when they traveled and returned to the United States.
Okay. But, Charles, I also heard that it's going to be a little relaxed now that people who are probably under cap exempt, they can also work, say, for example, a professor for a university. They can also work part time or be a guest lecturer somewhere else or maybe take tuition. Does that
With
work?
another H-1B. You can have 2 H-1Bs at the same time. So you can have a
Okay.
cap exempt and work cap subject, but you can't work there without an H-1B. You have to file that H-1B. So really, really important. Don't be caught with your pants down on this. I can promise you it will not be a pleasant experience. And they will charge you with fraud, which will essentially bar you for life from coming to the United States.
That's going to be sad, really. But thank you so much for highlighting that. And yeah, now what about USCIS? How does USCIS verify the H-1B employers' compliance, especially with wage and work site requirements as well? And what really happens if violations are found?
Well, USAS sends out their FDNS folks. They are generally contractors. They don't show up with a badge, but they have a little permission from immigration, the USCIS, to do these audits. And as they do these audits, what they're doing is they're making sure that, one, you're doing the job that you said you were going to, immigration was told you were going to do. 2, you're getting paid the wage that you're supposed to be getting paid. Now, here's a great example. Let's say you hired as a software engineer, but after a year, you get promoted software engineer 2. Your employer needs to change your H-1B. They need to update that H-1B, because if FDNS shows up and say, well, you had a different job? Well, it's kind of the same job. No, it's different, and you're getting paid more. I think this is a violation. And then they send out a notice of intent to revoke your H-1B. Now you've got to deal with that problem. And if they end up revoking it, then you're out of status, possibly with a fraud finding. So again, you are now in a day and age in which exact, strict compliance is 100% necessary. There is no room for errors in the immigration sphere.
That's very interesting, Charles. And what if it was all written in the job description that maybe after 6 months you're going to be getting an increment, or after a year you're getting an increment? Even then, you'll have to file a new H-1B, like when your job role gets upgraded.
If you're getting a change in your job duties and your job requirements, you should be updating your H-1B. It was, if we go back 10 years, I would say, don't worry about it. You're fine. In 2025, 100% you should be doing this. 100%. You cannot play games with this. You cannot, more importantly, you cannot trust anybody else with your immigration status other than you. You need to take ownership of this. So that means you need to be a pain in the butt to HR. Hey, you changed my job. The lawyer started this. I haven't heard from them yet. What do they need from me to file the update? I mean, you need to be proactive in dealing with your employers on this.
Very interesting. Thank you so much, Charles. Very important update, folks. I hope you're taking notes. And now let's quickly take up a couple of comments from our audience. Let's take up Neha. Neha is saying, I'm currently on an H-1B and I heard that deportations are increasing. If my visa expires while waiting for an extension, am I at risk of removal, even
No.
if my employer has filed for an extension on time?
No, your status is automatically extended for 8 months once you file an extension. That's the law. Your lawyer should give you a copy of the law so you can take it with you wherever you go. Do make sure to carry that extension receipt notice with you. Ask your employer for it, because that's one way. Most states you get a driver's license extended, but it's your status. And in the United States, I hope people are aware of this. You're required to carry with you evidence of your status at all times. That means the I-94 card, not necessarily the passport. So you should have a copy of the I-94 card in your wallet at all times, or the receipt notice in your purse, so that if especially if you live within 100 miles of the border, you can be stopped at any time by an ICE or CBP officer with no warrant. And if you don't produce the documents, they can arrest you and put you in removal proceedings. It is actually a deportable offense to not have evidence of your status with you.
Well, yes, I hope that you are all doing that, folks out there here in the United States who are migrants. And Charles, now we'll take up Monali's comment. And Monali is saying, I was laid off currently, and I'm struggling to find a new employer within the 60 days grace period. If I fail to secure a new job in time, do I automatically get deported, or are there any legal options to stay and transition to another status?
So if you are in the 60 days, obviously you're fine. As I said earlier, you should be filing a change of status to visitor. This extends your status automatically for those 180 days, and you're automatically in status while that's pending. And it also gives you an opportunity to extend your job search. So it's worth filing that extension, that change of status with legal counsel for you and your family. That will protect you during that time frame.
Okay. All the best, Monali.
Now I will tell you, if you don't, then yes, you can be deported. You can be picked up and arrested, put into deportation proceedings. You can't be physically deported without going through a court hearing, which means you could be in jail for months waiting for a court hearing.
And that's going to be ugly.
Not a pleasant experience.
Now let's thank you so much, Charles, for taking that up. And now let's go to Kiran. Kiran is asking, how will the recent changes to the H4 visa policy impact the lives of young Indians in the United States who mitigated as minors?
Well, we know, for example, first of all, if people are not aware of this,
Sorry, migrated.
If your child came into the country before they were 14 years of age, you are required to register them on their 14th birthday as an adult. And you are in violation of the law if you don't register them. That registration requirement is not active yet, but will be active, I think, in the next few weeks. So really important to remember that. As far as the kids that are going to age out, there is been no other than that. There's been no real change in the immigration laws, because first of all, only Congress can change the immigration laws. The president can't change immigration laws. So what you're seeing here, I think, is a situation where you have thousands of Indian H4 kids who are aging out and either have to leave the country or change to a student visa and begin their own terrible H1B journey in the United States. That's why they need to keep fighting for a change in the law. I will tell you that there will not be a positive change in immigration law, at least for the next 2 years. There is zero chance that's going to happen politically because of who's in charge of Congress.
Right. Okay, thank you so much, Kiran, for participating with your question. And I really hope folks can also join us on call. So the number is 425-436-6335, and the access code is 988-888 to join us on call. And now let's take up RK. Hi, RK. Thank you so much for joining us with your question. And RK is asking, Charles, do you see scrutiny on level 1 and 2 wages for H1B?
It really depends on the job. We actually had this debate in our office a couple of days ago. We were hired to get a H1B visa for a lawyer, a new lawyer, brand new lawyer. And obviously the company wants to use level 1 wages because level 2 wages are significantly higher for a lawyer, significantly higher for a lawyer. And we concluded that they're going to be okay with a level 1 wage because they are literally, everything about the job is entry level. So the key here is really looking at and making sure that the job itself is one that allows for level one wage. If you put in a detailed job description that is clearly indicative of a non-entry level, that is somebody just out of college to do that job, then you're probably going to get investigated and dinged on that. Level two wages, I'm not so, if you have a job that's generally speaking a level two wage, I don't see a lot of scrutiny on that. But level one wages, 100%. 100% there's going to be a massive amount of scrutiny.
Thank you. Thank you for taking that up. And RK, thank you for your question. Very interesting. So now let's take up Jitendra. Hi, Jitendra. Thank you for joining us on YouTube. And Jitendra is asking, how do the immigration policies of countries like Canada and the United Kingdom compare to those of the United States, and what makes them more attractive to Indian immigrants?
Well, I am neither a Canadian nor a UK immigration lawyer, so I'm not an expert on them, although I am informed. Canada has recently had a massive change in their immigration policies. They have basically kind of shut the door on a lot of work visas because Canada immigrated about 1 million people a year for several years. There's only 35 million people in Canada. It was an enormous number of people that came in. And Trudeau has now lost his position as prime minister. He was kind of the leading force behind that. So I would suspect that Canadian immigration, while probably more flexible and slightly easier than the United States, is not as easy as what once was. The UK, on the other hand, is a terrible immigration system. Their system is very difficult. It is very hard to use. It requires a great deal of oversight by an employer, and it is designed to not have immigrants. I have a very dear friend who's a UK immigration lawyer, Nick Rollison, and I think he would tell you the same thing. England right now is as tough to immigrate to as any country in the world. Probably more so than most.
Thank you, Jitendra, once again, and thank you, Charles, for taking that up. Now, coming back to my questions, Charles, suppose an H1B employee is laid off and cannot secure a new job within the grace period. So, what can they do, if they want to remain in the United States legally?
Well, I think I kind of answered this 4 times already. File a visitor visa or file a student visa. Go get a master's degree. Go get a PhD. File that change of status. But do not wait to day 59. Really, file that early on in the process so that you can find out what's going on.
How long does it take to shift to maybe another status?
How long is a change of status taking? It's funny, Napasa, you put my phone number up here and people are calling my phone number and that's what's ringing right now. Let me just take a look at USCIS and the great thing about immigration, very few great things, but one of them is you can find the processing times from the Immigration Service. I'm going to go on their website right now and hopefully, if it ever lets me in, tell you how long a visitor visa change of status is taking from an H1B, for example. So right now, immigration is telling me the processing time is 3 months, which is about normal. That's about, sometimes it gets longer, but it gets less, but it's about 3 months. And during that time, you're fine. Now, when you file for a change of status to a visitor, that means you're going to be visiting. You have to explain, I've been working for all these years in the United States. I want to take a few months and drive around the country. I want to go to Yellowstone. I want to go to Disney World. I want to eat lobster in Maine. Here's my bank account that shows I have the money to do this. Here's my return ticket for 5.5 months from now. If you do that, you'll be approved. You don't do that, you're not going to be approved.
Okay. So thank you so much, Charles. And there you go, friends. Before you even hit your 60 days grace period, you have to be filing for your other option. And 90 days, that's what, 3 months is what, you have in hand. So I think you should not wait that long for sure. Thank you, Charles, once again. And yeah. So suppose a tech company sponsoring multiple H1B employees faces a compliance audit. now that audits are a real deal. A lot of it is happening and resulting in revocation for some visas as well. So what legal remedies do affected employees have, and how do they really safeguard their status?
Well, the first thing an employee who is affected by this to do is hire a lawyer, your own lawyer, not the lawyer representing the company. You need to go find your own lawyer, someone who's experienced in these issues. Two, you need to try to figure out what happened. Why is the company facing a problem with the compliance audit? What is going on there? Two, was your job affected? Was it you? Were you one of the people who were affected by this? If you were, frankly, immigration believes that you are complicit in it, that you know about it, and that you allowed it. And if that's the case, it's going to be really hard to get an H-1B visa in the future, which is why you don't work with tech companies that suck. You don't work with these marginal companies that are kind of skirting the law, that are just becoming job shops. You got to stay away from these companies. They are not there to help you. They're there to make money for their owners. So again, go see a lawyer right away. Maybe you can become a witness. If there really was abuse, you may be eligible for a T visa. These are visas for people that are victims of human trafficking. And we've done a couple of these for software engineers who basically were treated like human traffic persons. So again, talk to someone who knows what they're doing, who has experience with this, and from there move forward. But I would say every case is different. So there isn't really a general guideline other than get a lawyer.
Absolutely. It's always best to consult with an expert, and an immigration lawyer would be best. And folks, you can always contact Attorney Charles, and that you can do so. I think it's best to email Charles. So mail him at charles@immigration.net, and go visit www.immigration.net to get to know more about Attorney Charles
I
Cutt.
answer all my emails. Yeah, email me. I answer all my emails. So
Yes,
there
he
you go.
does. And he's really prompt, very quick. So I'm sure you'll never be, disheartened with that. But if it is an emergency, definitely call him also on his number, and that is 404-949-8154. So, Charles, I also got a couple of case studies, or scenarios rather, and this first one is, about a visa denied after administrative processing. So, Ravi, who is a software developer from India, has his H-1B petition approved under consular processing. However, after months of administrative processing, 221G, his visa was ultimately denied with no clear reason. So, what are the possible reasons an H1B could be denied after administrative processing? First off.
Well, it depends. Has Ravi ever been in the country before? Does he have this student visa OPT issue? That's something we've seen come up a lot recently, and our good friend John Wasden has been litigating that like crazy, very successfully. First of all, the consulate's required to give you the ground, not the reason itself, but the ground. So within Section 212A of the Immigration Act are the grounds, 1 through 10, for which you should be denied. Now, so you're gonna know a general category. Then once we know the general category, then we can figure out what the deal is. What is it? A 212A2, that is a criminal charge. Is it 212A3, which is a security ground? So it really, again, very factually specific case. Usually after a consult with somebody, I can figure out what the problem was. Then we have to determine whether or not that's fixable. Sometimes it's fixable. Sometimes it's not fixable. Did that person apply for a visa before? Did they overstay a prior visa? Again, a lot depends. Maybe it's the employer. Maybe there's something with the employer there, and they're sending the H-1B for revocation. Again, very specifically, we talk about the facts to our clients to see what if anything we can do.
Okay. And, maybe employers could support their employees also in such cases, extended administrative processing delays. What can employers do maybe for them?
Well, same thing. I mean, it's the same approach for a foreign national or the employer. Find out what happens going on. You can always appeal a visa denial to the visa office. If we believe there was an error, we can send an email to the visa office. These are the people that oversee the consulates and give legal advice to them. So if it's a legal issue and the consulate's wrong, we can get that corrected. It might take several months. We can get it corrected. If it's a factual issue, that's it. You're probably toast. It just depends. Again, facts.
Okay. And that is very important. A lot of it, right? So, okay, about 221Gs, delays, how can applicants minimize the risk? Maybe you can give out a few tips to those watching.
That's a great question. If I had to answer that, I wouldn't be an immigration lawyer. I would be God, because nobody seems to know. Uh, there's a lot of speculation that your religion makes a difference. If you're Muslim, you're almost always going to get a 221G, almost always, anywhere in the world. It could be you had a prior legal incident. It could be you had a prior visa application. There's an endless number of reasons. None of them appear to be legitimate. Virtually all 221Gs are resolved in favor of the applicant. But here's a lesson that we learned from 9/11. Nobody gets fired for saying no. You only get fired for saying yes. And here's what I mean. Everybody knows about 9/11 and the hijackers. People don't know about is March 11th, 2002. On March 11th, 2002, the Immigration Service approved Muhammad Atta's F1 visa extension.
Okay.
6 months after he murdered 2,000 people. People got fired over that. The lesson learned was deny, deny, deny. Only approve when you have clear belief and understanding that you should be approved. Thus, nobody gets fired for saying no. So there's never a downside to saying no. There's never a downside of you waiting.
Thank you so much. I mean, that is very important information. And thank you, Charles, once again.
You're
So
welcome.
I got another, yeah, I got another case study which I was just reading through, and this is about an H1B worker who was facing deportation due to late extension. So Sophia, another H1B worker, was relying on her employer to file her visa, but due to negligence of delay, the petition wasn't filed on time, causing Sophia to fall out of status,
All
and
right.
she's now at risk of remotation. So, what legal options does Sophia have if her visa extension is not filed on time?
I will tell
And
you how
if you
we've
could,
handled that when we've been hired in this situation. We file a retroactive extension, well, the nunc-pro-tunc extension, if the employer was at fault. Now, sometimes it could be something as simple as the FedEx didn't get delivered. I mean, that happens, which is why you never wait to the last week to file. You always file long before that. So you ask for nunc-pro-tunc relief. The simplest thing to do, honestly, is just to leave. Get on a plane, go, wait for the approval, come back. You've solved the problem. Overstaying by a day because there was an error, or a week or a month, is not going to get your visa denied. You're going to get the visa. Now, the other thing you can do is, if it's nunc-pro-tunc, you got to pay premium processing. So you premium process a late filed nunc-pro-tunc relief. And if it's the employer's fault or the lawyer's fault, maybe it's the lawyer's fault, and that's the case, we usually get involved when a lawyer has screwed up. And then we just we file a bar complaint against the lawyer, and we throw the lawyer under the bus. We win almost all of those, getting reinstatement. We actually, last year, we reinstated somebody who had out of status for 2 years. We reinstated them because the lawyer had screwed up massively and just kept screwing up, like a series of screw ups. And we got them reinstated. So, yeah, it's possible to fix, but again, very fact specific.
it's always safe to leave, that means. And what about, if removal proceedings begin, what legal defenses or appeals are available, maybe?
Well, something depend in removal proceedings. If you've been inside the United States for less than 10 years, you essentially have no defense other than, I'm afraid to go back home, which you're not really going to win from India almost all the time, or you can take voluntary departure. That's it. Because the immigration courts have no jurisdiction over visa adjudication. So the immigration judge can't fix a visa error.
Okay. Very interesting. I'm enjoying this conversation, Charles. Thank you so much. And I'll quickly say hi back again to RK, who's back with another question. We'll quickly take that up and, also address some other questions from our Facebook groups after that. So, RK, if the start if the start issuing more NTA for denied COS from F1 to H1B or H1B extension, what happens with the individual authorization while in immigration court?
Well, this is not an if. This is going to happen. It happened during the first Trump administration. It will happen now. The way it works, though, if a change of status is denied, it does not come with a notice to appear or an NTA. You have 30 days to appeal that, or to ask for reconsideration. So it's not automatic. If after a period of time you've lost the decision, you lost the H, you've lost the extension, and you are in removal proceedings, your defenses are limited because the judge can't really do anything about your visa status. So most of the time, for people like this, you're going to be taking voluntary departure and just leaving the United States. My suggestion, however, is that if you are at risk of being served with a notice to appear because you're out of status, then you probably should leave first. There is no work authorization that comes. There is no work authorization just for being in deportation proceedings. The work authorization in deportation proceedings comes from eligibility for cancellation of removal, that is more than 10 years in the United States, and a U.S. citizen, spouse, or child, or if you're applying for asylum. Those are the only two times you're going to get a work authorization in immigration court.
Okay. Thank you, Charles, for taking that up. And thank you, RK, once again for joining us. So now, Charles, we are going to take up a few questions from our Facebook group. So um, there we go. We have our first one. This is from Anand asking, my visa stamped for company A till 2028, but I left company and went back to India. In India, company B filed my H1B in the year 2026 while me being in India. Then do I need to go for stamping for company B? I heard if our H1B processing happens while being in India, then it has to be consular processing, only for which we have to go for interview. Is that true?
No. You have a valid H-1B stamp in your passport, and you have a valid I-797 for a different employer. You just travel on the old stamp and the new approval notice. You do not need a new visa.
Okay.
You're welcome to get one if you want to. You want to waste the money, but you're not required to.
Okay. That's good news for Anand then. All right. So next question is again on the screen. This is from Sagnik asking, my previous visa was F1. Have scheduled a Dropbox for H1B visa, first time stamping at Chennai for March 7th, that is today. Do I need to cancel and schedule OFC and interview? My hometown is in Kolkata. Can I schedule both OFC and interview in my hometown? And can I reschedule the appointments now, or do I need to wait till March 7th?
Today is March 7th.
Today is March
That
7th.
question is from 2 weeks ago, or we're in a time warp. I haven't figured out which one it is. I'm curious to know what he ended up doing, because clearly I would have just waited till the interview came and seen. But well, I guess we'll see.
Yes, we will. All right. So this is from Navya. Navya, this is also a couple of weeks back and saying, hi, I have a question related to document form Dropbox for H1B stamping. I'm working with consulting company. Can anyone please tell me if I should take EVL, that is employment verification letter from the consulting company with whom my H1B is filed, or the client that I'm working with? Thanks in advance.
We ask our clients to carry both.
Okay. Navya,
Because
that's both.
they're going to ask for it, so you might as well have it.
Okay. All right. Thank you, Charles. Now, this next one is please advise me on this situation. So, I entered USA on H1B, and my employer didn't run payroll for nearly 3 months since I didn't have any job from the client side. Then, when I got job from the fourth month onwards, my payroll started running. Will I have any problem because of this during my H1B renewal or stamping? Thank you.
Yes. First of all, you're out of status. You're out of status if you don't get paid within 30 days. That's the law. So either ask your employer to reimburse you for that money, or I would file a complaint with the Department of Labor, Wage and Hour Division, and they will force that employer to pay you back. So yeah, that's a big problem. We see this all the time, Napasa. It is against the law to do this. And
It's
until
illegal,
people
right? I mean, you
it's
can't
very illegal.
make somebody
Very
work
illegal.
for free. Yeah.
Very illegal. It doesn't
Thank
matter.
you.
You don't have a job. That's irrelevant. You were hired to come in. They let you come in. They are required to pay you within 30 days of your entry.
And America is so expensive. I don't know how did he even survive for the 3 months without pay. Goodness
I
me.
don't understand that.
Yeah. Anyway, so thank you so much, anonymous member. I really hope that you have figured out.
Yeah, me
And
too.
now let's go on to our next one, please. This is also another anonymous member asking for those on H1B who have purchased a home and car are planning a vacation to India. Given the current situation, how are you preparing for potential challenges if, God forbid, anything unexpected happens? Okay.
I would suggest that people fill out and have a power of attorney with somebody that's in the United States, so that you have it notarized in the United States that gives somebody else a power of attorney over your things. We also have a power of attorney over children if you leave them here, and you don't give it to the person. But if you can't come back, at least somebody can dispose of your house and your property while you're gone in your name. So, I mean, you might want to consider power of attorney. We have those on our website. And you're welcome to use those for the state of Georgia. Every state's different. Make sure you have one for the state that you live in.
Okay. And once again, that's www.immigration.net. Go check it out. So, yes, let's go on to our next one. Control, if we can display
Same
the
question.
next one.
Same question. But there are some in
I
our
think it's
live
done.
here. There's a couple of great questions here in our live. One from Empire. Maybe you could put that up.
Yes, we should. So Empire is asking, do you expect an increase or decrease selection rate for this year's H1B for both regular and master's cap? And also, do you expect any change to the H1B or next year's fiscal year 2027?
Two great questions. I was wrong last year. I thought there would be a decrease last year in numbers. I think there's going to be a decrease this year. The Trump session is starting. That's the Trump recession is clearly starting. Job gains are rapidly shrinking. Hundreds of thousands of people have been laid off in the government, which means private sector will also follow. So I suspect that we will, and many contracts have been canceled. Many contracts have been canceled by Musk and his minions and Doge. So I would suspect there's going to be a decrease in the number of applicants and thus an increase in the selection rate for both regular and masters. As to the second question, we're going to see massive changes. We already know that they're going to publish a regulation here in the spring, maybe the summer, where they're going to change how the lottery is run, and they want to run the lottery based on salary. Really. The higher you get paid, the greater chance you have of getting picked. Now, is that legal? Does that follow the law? Probably not, but they're probably going to do it. I would also suspect that they mandate a minimum level 2 wage on H1Bs. This administration, there are a lot of people in the administration, not all of them, that hate H1Bs. Musk loves H1Bs because he's using hundreds of them at his companies, and he himself had one at one point. But a lot of people hate it, like Stephen Miller, who's really in charge of this stuff. So yes, we will see massive changes. And I also suspect that the lottery fee will go up dramatically next year, maybe several $1,000s.
Wow. I mean, already there is an increase this year, and again, more increase. I think it's going to get crazy. So, but all the
Yep.
funds that they're going to be accumulating with this. So great. All right, let's take up Nena's questions. This is what are the
That's a good
specific
question.
implications of turning 21 for children of H1B visa holders, particularly if their parent has not yet secured a green card? And what options are available to these young adults to maintain their legal status in the United States?
Well, they need to change their status as student. They can change the visitor too, but that's so temporary. Many of them probably going to be in university anyway. So I wouldn't wait till they were 21 to change their status, because they have to have one full year in their degree program to obtain OPT when they graduate. So if they wait till 21, they may already be in their fourth year. So I'd probably change them when they were 19 or 20 to a student visa. And again, if you become current, they're still going to get a green card through you. But this way they're protected and not waiting to the last minute to change to an F1. And then at that point, they're on the H1B hamster wheel as well, going through the process. Now, of course, depending on, how old they were when you filed the I-140 and how long it was pending, they may be able to recapture some time. That's why you never pay premium processing for I-140s, because you want it pending as long as possible, because it extends the age of your child past 21. So student visa holder is probably the only real option for most people, or to leave the United States.
Okay. Thank you so much, Charles, for taking that up. And Nana, I hope that you have gotten your answers. And if you have more questions, anyone out there, you can keep commenting. Also, I would say if you're resonating with whatever Charles has been giving us, very insightful, really so far, so great. So do not forget to also subscribe to our channel. It is Immigration Talk Show in YouTube, and also check us out on LinkedIn, Facebook, X, Instagram. And yes, you can call us on this number, which is up there on the screen, 425-436-6335, and the access code is 988888. All right, so Charles, I got more questions actually, and this is another case study which I was reading. So, this H1B worker at risk due to employer fraud. So, Aman and Priya were working for a tech company and which is an IT firm, and later found to have misrepresented visa filings. So, USCIS launched an investigation, blacklisted the company, and now all employees are at risk of losing their status. So, what legal protections exist for H1B employees if their sponsoring employer is flagged for fraud?
None. There are no legal protections for H1B employees. Obviously, if they're terminated for any reason, it's 60 days. If they quit, it's a 60 days. So maybe you immediately begin looking for a job, looking for a school to go to, or change it to a visitor. Those are, and maybe you're experienced enough to be an O1 instead of an H1B. Maybe you're extraordinary, and we've been pretty successful in changing people from H1Bs to O1s. But as far as legal protections, not many. And if you are a witness, perhaps to the employer's abuse, there also may be a T visa. So again, it very fact specific. You want to get your own lawyer right away so you can figure out exactly how to navigate this problem.
Okay. Okay. And, what about this H1B worker? Can they transfer their visa to another employer if the company is under investigation, or they'll just have to be gone from the country?
Well, again, if you transfer, you should be fine unless the investigation involves you or your job. Now, if they're investigating the company for not having real jobs, yeah, they're going to question you on your new employer application because it's all in a database. Now, AI is tracking all this stuff. So, you change the employer. Oh, you were with company X. We were investigating company X for not paying its employees. So they might send you a request for evidence on your new employer's application and say, hey, show us you actually got paid the whole entirety with your company. Don't ever throw your pay stubs away.
Okay. Okay. And, what about employees? What can they do to verify an employer's, or maybe how do they report this fraud? Maybe to protect themselves from this in this process.
So there's an agency in the government called the Department of Labor. And if you Google H1B Department of Labor, you will go right to their website and you can report worksite abuse. This includes not getting paid overtime. This includes not getting paid the salary required to be paid, or not getting paid at all. And they can get your money. They are your lawyers. They will get your money back for you.
Okay.
But
All
you will
right,
not get visa protection.
Okay.
The Empire had a great follow-up question that I really, really want to answer.
Sure. Let's take it up. So how would that do you expect an increase or decrease? We've taken that. So how would that work? You can't compare a teacher's wage with a software engineer's wage, of course. And will it be top wage based on occupation, which makes a top paid teacher on the same level at a top paid engineer?
Well, Empire, you have hit the nail on the head. This is when you use you, it's not me making this up, right? This is Trump and his minions. They don't care. They literally are looking at the highest paid people, period, not by occupation, because there is no occupation within the H1B. So if there are 65,000 people getting paid over $150,000 a year, then nobody making less than that in any job will get an H1B. This is disastrous for nurses, doctors, accountants, teachers, every kind of profession has entry level people. And yet this, because they keep saying, well, H1B is for the best and the brightest, and it's not. It's never been for the best and the brightest. It's been for the most available worker. And this is the H1B, unfortunately, has been abused by a lot of employers, and as a result, whenever you abuse something like this, you're going to get a slap upside the head that will shake you to your shoes, and it's not going to be pretty. It's not, and it's
Right.
not just going to be IT. There's a lot of IT jobs that are not going to qualify. There's a lot of other jobs out there. Doctors. There's like 5,000 doctors on H1Bs. They all make more than IT guys. So that's 5,000 IT guys not getting it. There you go.
But I mean, great questions, Empire. Thank you so much. Very interesting questions. I'm glad folks out there can join us with their questions. They make this whole session more interesting. So I think with that, we've covered most of our questions, Charles. But before we leave, do you have anything more to add and wrap up and maybe give out tips to whoever is maybe getting into this fiscal year 2026 H1B lottery?
Remember, employer can only enter, one person at a time. You can have multiple employers enter you, but it doesn't make any difference because you're only going to get one shot at the lottery. So pray. I mean, it's truly a lottery. There's no way to enhance your odds. It's just the lottery. It's like going to the store and buying a lottery ticket. May the odds be ever in your favor, as the saying goes. Napas, it's been great being with you this week. Thank you for having me.
Thank you, Charles, for really joining us. I enjoyed this whole conversation and what a session. So I'm really looking forward to having you back. Maybe tell us whenever you get some time again, and it'll be great to have you back.
Love to have you. Have a good day.
You too, Charles. Thank you. Folks, don't forget to maybe contact Attorney Charles, and that you can do so by, email him. His email address is chuck@immigration.net, and go visit www.immigration.net. And also, you can call him up in case it's an emergency. You really need to have a word with him. 404 949 8154. But yes, his email address once again, ckuck, CKUCK, @immigration.net. Sorry earlier. So yes, thank you so much, folks, for joining us, and I'm sure you loved today's session. So do not forget to subscribe to our channel, hit that bell icon if you haven't already subscribed to us. Our handle is @immigration talk show. We are on YouTube, and you can also check us out. We are on LinkedIn, Facebook, X, Instagram, everywhere. Check us out and connect with us. You can also email me. My email address is nipa@staffingly.com, and call me or WhatsApp me on this number, 408 335 6444. Thank you once again for joining, and stay tuned on Immigration Talk Show because we got more awesome webinars lined up. So stay with us.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, we are also live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So do follow us from these many platforms and let us know if you guys have any problem or any concern regarding immigration topic and put them on the comment section and we will definitely take them up. All right, with that, today we are here with another, I would say, a very demanding topic, a topic that is on everybody's mind and is on top search list on Google as well. That is how to prepare your H1B application process in 2025. So I know it's H1B season, friends, and you guys are really exhausted, really concerned, really anxious. But with right guidance, I'm sure you will definitely get your visa approved. And in today's webinar, we are going to explore a lot of things. Like firstly, we'll understand these strategies, tips, and tricks. Then we will also understand some common mistakes that most of the applicants do, and they don't even realize that. Also, we'll understand what in case if you get your H1B visa rejected, then what are the alternative options or what are the other paths that you can also take away. And to help me out, I have a very special guest with me who is joining us for the second time on Immigration Talk Show, who is, I would say, a great speaker, great personality, and lots of energy. None other than attorney Jessica Weiss, who's a top immigration attorney, also known for helping entrepreneurs, investors, and professional athletes with visas like E1, E2, and O1A. She is also awarded the 2019 Global Chamber Award for Immigration Legal Services. So, hi, Jessica, and thank you so much for being here. I was really excited for this webinar. So, again, lots of, I would say, we are really appreciating your time and thank you so much for joining us.
Thank you for having me. I'm looking forward to this discussion today. It's a pretty tense time. H1B's opened up on Friday, the registry, and there's still so much interest and so much that people don't know, like how to get in line, how to do it the right way, how to, increase your chances of getting the lottery. So I'm looking forward to our talk today.
Absolutely. And after all, there's a lot of different changes also we are seeing right now, Jessica, especially in 2025. And there's a lots of, I would say, questions that we got right now from our audience. So without any further ado, I think let's begin our session with the very first question that is very important. That what's the most important thing that applicants should know about the 2025 H1B visa process?
Okay, it's a process. Just like what you said, H1B is a process. The process has started. It started on Friday. What people need to know is you probably, at least last year, you had 1 out of 7 chance of getting it. Like it says, it's a lottery. So people need to know they want to get in line, they want to file. If you want to win the lottery, you got to take a shot at it. So you have to file. But to file, you have to have certain things in order. So one of the things you have to have in order is you have to be able to have a proper case. So you need a proper sponsor. You need to know that the filing fee now is $215. It used to be a lot smaller when we first started doing these. Is around $10 or so. And also something very interesting to know is, let's say you have several possible job opportunities. So if you do, each sponsor can try to file an H1B from you. So it's not. So the beneficiary, the applicant, whatever, could put in one case with one sponsor, another case with another sponsor, and you could have several shots at the H1B lottery if you have different sponsors. So that's really exciting. That increases your chances. Not everyone has that, but it's good to know that.
That's right. That's right. All right. And also, Jessica, as you said about the registration fees that has been increased from $10 to $15. So if this is the increase, then can we expect that this could lead to a fewer applicants in 2025 H1B season?
Well, it is a significant increase from the original whatever $10, but the filing fees, if you get approved for the H1B, are very large. That would probably, if someone wants to do an H1B, the sponsor may be hesitant because the filing fees are so large. The filing fees are several $1,000s for an H1B. And so besides the attorney fee, you've got the filing fees. You don't even know if you're going to win the lottery. Some of the potential employers don't even want to give it a shot. So I don't think the $215 registration fee is going to discourage people. I think that the big picture is if they do make the lottery, will that sponsor want to really kick in all that money for the filing fees, attorney fees, and all that? I think that's the bigger issue.
All right, that's interesting. And with that, also, Jessica, I would like to know, is there any change regarding the eligibility requirement in 2025 application process?
So we always every year look at it and see what are the criteria, any changes in any of the criteria. So what they're doing this year, they've come out with some new regulations that they want the degree for the position to closely align with the actual job duties. Meaning, let's say you have a bachelor's degree in business administration. That's a general degree. And you're trying for a position, some kind of business development position. They want to understand how closely they're going to look at that transcript and see what classes you took, how closely that aligns with what you're going to be, will you be using those skills when you go for your H1B? They want to see that that's closely aligned. If it's too broad, too general, it could be a problem. So they've emphasized the degree better match the job requirements. And the other thing is, another thing that happened recently was they clarified self-sponsors and startup entities. This is very interesting stuff. So what they said was, if you're starting a company and you're going to be the owner of the company, you're also going to be the employee, that they want to make sure you have a bona fide entity and you're not required to have an official board that you report to, but they're going to only give you possibly an 18-month H1B instead of the typical, you get a 3-year H1B. But they're opening up a little bit now to if you want to start a company, be self-employed, startup entities like, tech companies, whatever. So they're opening up a little to some of the realities of today, which is a lot of times people do start their own businesses and they need a proper visa to come here. And H1B could be a possible way now if you set it up correctly. So it could be for entrepreneurs now, other kind of startup companies like that. So yeah, those are two critical things that are coming up with the degree. Has to really get closely with the actual job description. And also now they're getting more accepting of some startup companies, more self-employment for H1B. There are more ways to start doing it now. That's changing.
That's
So
right.
those two.
Mm-hmm. Absolutely. And I think that's a very good way that you explain, Jessica, with also the example. But Jessica, now as I would say the H1B changes also we are seeing in the policies, most of the startup companies or most of the companies, those are not that good or not that, I would say, financially in a good condition. They are having this complaint that due to this increase in the registration fees or due to this also changes in the policies, maybe they are not able to provide more applicants because they are not able to file the applications, right? So is it going to be a challenge for these startup companies more as compared to the companies those who are already in a greater position?
So it's interesting. The criteria to the financial part of the H1B case is that you have to show that you have ability to pay that worker once they start working. So we usually show tax returns, financial statements. So if you're a startup company, how are you going to do that? So this is how we do it. First of all, they're investors. Sometimes they invest in these startup companies. So we get a commitment from them. We'll have a letter signed that they're going to invest a certain amount of money or, in the business. And then also their potential contracts. Maybe it's the type of business that they have all these lucrative contracts that they're going to be connecting and, working on whatever. And so we show the potential for money to come in, plus a commitment from the investor that there are ways for this new company to show that it's going to be financially viable. And then if they feel comfortable, the owner of, bringing an H1B worker under this environment, then they can do it. But it's not a straightforward, like solid H1B when you don't have a tax return and financial statements and those kind of things. But this gives opportunity for companies that are young, just starting up, there are other ways to show that they are going to have strong financial ability in the near future. So that's what I would tell them.
All right. All right. Okay. And with that, Jessica, here's another very important question that mostly our viewers were really awaiting for this. That what strategies can employers use to improve their chances of getting an H1B application approved?
Okay, so number one strategy is you got to have a good case. When we take these cases, we want to understand before we file for the lottery, what's the job title, what's the job description, what's the approximate salary they're going to make. We need to understand this because it's not like you file. If you get accepted, we want to make sure we can file that case. So
Mhm.
one thing is to make sure you really understand, is this strong enough for an H1B? Another thing is they have to be very accurate. We have to be very accurate when we file for the registration. Even we have to have the company's legal name correctly. We have to look at the certificate of incorporation, make sure we have the correct name, or if there's a DBA, make sure that's correct. Make sure the tax ID number matches the company name that we're filing for the H1B registration. There are problems. People put the wrong company name in, the wrong tax ID number. You could be a mess. And so even if you make the H1B lottery, what if you can't get a successful case out of it? People file what's called the LCA, the labor condition application. And if they put the wrong things in the wrong boxes, the wrong names of company, check off things that aren't appropriate, the wrong job titles, etc., then they're going to get a kickback. It's going to either be approved LCA, you file with it, and the H1B gets filed, and the immigration says, sorry, this doesn't match nothing matches your LCA, your H1B case, it doesn't match, then you have a problem. So you really have to look at that LCA and make sure you file it correctly. Also, if you file the LCA and then sometimes you can have an audit that the Department of Labor says we don't recognize this company, send us all sorts of documents to prove it's really a legit company, and that can delay also. And then once that's corrected, you have to make sure you file within the correct time frame. So once you have a 90-day window, usually once that H1B is accepted for the lottery, you have 90 days to file. The LCA takes about 7 days, usually 7 to 10 days to get approved. So you want to file that timely. Some of my peers kind of set up the LCAs before they even get approved for the registry, but I don't. I usually just wait. And once the case is approved for the registry, then we complete the LCA, we submit it, and then hopefully once it gets approved, then even once it gets approved, sometimes people forget. The employer has to sign the LCA. If you submit the H1B and it's not signed, or the forms are not signed correctly, or certain boxes are not checked off correctly, then you have a mess. Then you have a client coming back and saying, I made the lottery, but you messed up my whole case, so I didn't get the H1B. And that is a disaster. That is absolute worst disaster. So you have to make sure that's correct. The other thing is sometimes, this is what we do right from the beginning of the case, is we take the case, but we ask for all the documentation. We want to see the degrees, the transcripts. We want the work experience if it's required. We want reference letters. We want to make sure we have all the things we need to make sure this is going to be a successful case right before we file the lottery. Because when it comes time to filing for the H1B, if they can't get the degree, or they told us the degree, let's say I had a client years ago, they told me, for sure my bachelor's degree is in this particular field. And guess what? When we saw the diploma, it wasn't. And we were like, he's like, I was convinced it was. It was a big mess. Don't ask. It was a big mess. And in the end, we were able to get it approved, but it's a long story. But we kind of explained that the degree no longer exists anymore. That was issued by the school. It's this particular degree. It's the equivalent. It was a little complicated, but it's very important that the documentation all be there if you're filing for an H1B. And also, you don't want to miss deadlines. It's very important. You have this 90-day window. Once you get accepted for the lottery, you've got to file within that 90-day window. And if you miss a deadline, that client's going to come back and be like, how could you miss it? You can't miss it. If you're an immigration lawyer, you've got to make all the deadlines. And these are some of the key things I would say to make a successful case is, job description clear, documentation accurate, LCA filed properly, meet all your deadlines, and make sure you really review the file before you submit anything. So everything is correct and consistent with H1B. And that's how you do a winning case if you get the lottery.
All right. I think that's really important. And thank you so much, Jessica, for explaining these things in a very detailed manner. But, with this explanation, I also have some questions in my mind that when you're talking about case, so we would like to like deep dive into case term. Can you explain us what type of case makes a strong, gives a static reason that yes, this person got approved? If you can give examples regarding the cases, that would be more helpful.
So you want me to give you an example of a case that I worked on H1B and how it fit exactly job title, job description, and everything. And it was like a beautiful case. Is that what you're asking?
I mean, of course, that will be too long, but cases are different genres that you can just give us the case related to something so that our viewers can understand, understand in a better way. So, just for that.
Okay, so let's see. So if my client, well, we're doing right now, we're working on different H1Bs, whatever right now. So one we're working on is project manager. Okay, so first we got to come up with the title. So then you hear the word manager in the title. So you have to understand when it's manager, it's going to be a higher wage that they're going to want. The client has to be paid above the minimum wage for where they're going to do their position. So we have to look up what degrees do you need for project management. So he has a management degree, a bachelor's level. It's from an American college. So we don't have to get a degree evaluation for that degree because it's from an American college. If it's a foreign college, we also need an evaluation to determine it's the equivalent of a U.S. Bachelor's degree. So we have the degree. The job description, we talk to the employer about the job description. We ask him what he's going to be doing and is he going to be supervising workers and who's underneath him. If he's not supervising staff, we have to be careful how we use the management title, because when you call someone a manager or an executive, then they're going to be paid a higher wage. So how do you know what wage? So we have a system that there's 4 levels. It's called OES. It's our wage system. And the levels are based on who they're going to manage and how much supervision they get. Level 1 is basically entry level, like someone straight out of college. So this gentleman, he's already out of college. He has a few years of experience. He is going to be supervising people. So he's probably going to be between level 2 and 3. Why does that matter? Because we need to understand, is he going to be making above the minimum wage that he has to make? So we need to make sure the employer is willing to pay that, and also that there's enough money to pay that. So we go through all of these issues, and if we have that in place, then we're like, okay, he's got the right degree, he's got the right education. Sometimes the job can require work experience. Make sure he has that. His salary is the minimum level that he has to be paid, and the employer is willing to pay that salary and has enough money to pay it. All those pieces need to come together, and then we have a good H1B. Now we just have to produce the documentation. That's H1B.
Right. All right, that's fantastic. Thank you so much, Jessica, for giving us the example. And I'm sure our viewers are really understanding each and everything, because, some of our viewers are watching our session for the first time. And they may develop these types of questions, which are very basic, because generally, if we talk about job description or job title, if someone is hiring for the business analyst, then automatically they are going to write down. But still, due to some reason, their application gets rejected. So,
Well, if you keep it too vague, if it's too vague and you can't tie it enough in, because I mentioned earlier in our discussion that it has to be, we look at the transcript and we see what courses they took. Can we tie that in? Did you need these classes? Because H1B requires specialized knowledge and skill gained at the bachelor's level or higher. So they have to have those skills. So we look at that bachelor's transcript, we see the job title, we talk to the employer, what does the job entail? Also, is this something typical that the job would require in your workplace and also in the industry? And when all that comes together, then we have a good case. But if it's just too general and it's not something you really need a bachelor's degree for, it becomes a problem. It's not such a good case. Yeah.
all right. I think that's pretty much clear now what's actually a good case means. So that's really great. And with that, Jessica, we already got a lot of tips and also understood the strategies also. So now I would also shed light on the common mistakes that mostly applicants do. So could you please let us know some common mistakes that applicants do and they didn't even realize that? Please go ahead.
Okay. Some of the common mistakes are there are so many changes in our filing fees. You need to know the filing fees for H1B. It's very confusing. We have this special fee now that's been thrown in for processing asylum cases, even though our cases, H1B, is not an asylum case. If the sponsor has more than 25 workers, you're going to pay a $600 additional filing fee. If it's less than 25 workers, it's $300. So you have this special asylum fee in there. You also have, if they want to expedite their case, there's a filing fee for that. You have the basic filing fee. Then you have let's see, you have other filing fees as well. I don't have them memorized, but let me see if I have them here. But the point is there's a lot of filing fees. That's the big picture. There are thousands of dollars in filing fees. And by the way, there's something very helpful online. There's on the immigration website, there's a checklist here. And it'll go through with you all the things you need to put into the case. I have it right here. And also all the forms to make sure you checked everything off right. And online, there's also called filing fee calculator, on the immigration website. So you can just plug in the form and it tells you all the fees that are applicable to your case. So that's one thing, is that the filing fees are not the correct amount and you had to file by a certain time. If they throw your case back because you didn't have the right filing fees, you don't get another chance if you missed a deadline. So the filing fees have to be correct. Also, you want to ensure that your LCA, your labor condition application, is certified. People sometimes think, I'm in a rush, I got to get this thing filed, but I don't have a certification, so I'll just file without it. You can't. You have to have it certified by the Department of Labor. It's very important.
Yeah.
Another thing also is a weak job description. We talked about a little bit earlier. I'll give you an example of a project management person, and we want to make sure that job description tied in really nicely with their work experience. If you can't tie it in too tightly, that also can create a failure if you don't have the right degrees to match what the job required. And that's very important. And another thing is missed deadlines. And I think I mentioned this a little bit earlier as well, but there are certain deadlines on these cases and you can't miss them. And I know that this is something, I don't know if it's going to come up in our conversation, but students, it's very important with students. F1, if you have a student visa or a student status and they're running out of time, there's something called cap gap. And so there's a way for them to extend their ability to work in the United States or their F1 as long as that H1B is in the system and processing, and then they can extend it till, it used to be October 1st when the start date is for the H1B. Now they gave them a little longer extension until I believe it's April 1st. So if you have a request for evidence and your case is delayed and you can't start it October 1st, and you still need to be in America, they've given you more time even till April 1st to try to get an answer on your case so you can get your case started. So that's something very important. Students, really, it's very tough for students because they spend 4 years in college and then they think, okay, I'm just going to go to H1B, but H1B is a lottery. So if they don't get the lottery, if they're STEM students, then they're going to go back in and get additional time, OPT. And if they're not, usually a regular student gets a year of OPT after they finish their schooling. And if they get that, then they get another shot probably the following year of trying for the H1B. So it's hard, but STEM students get several shots because they can keep staying in OPT, and then each year they can keep trying for H1B while they're in STEM OPT. So it's very important not to miss deadlines because it really affects, do you have a shot at the H1B to activate it properly?
That's right. And I think, Jessica, now in this H1B modernization rule, also the I would say specialty occupation definition has also modified by not just including the STEM degree people, but also those who are actually having a directly related course. So I would also like to know more about it. That do you think that this is actually going to make the process fairer one by keeping away the STEM degree holders and focusing more on directly related, or do you think that previously how the system used to work that was better? What do you think about it?
I think as an immigration lawyer practicing 27 years now, that we will always fight for our clients. We don't care. They can modify the regulations in different ways, whatever, but we start a case. We want to make sure it's strong. We look at the job title, we look at the job description, we tell them if you've got a weakness to it, you might want to try a different job title. It'll fit better with your degree or whatever. But it doesn't matter. We will continue to make the best case possible. And because an employer will contact us and say, we need this worker. They have a bachelor's degree. Why is it not an H1B? We try our best to make sure we can make it work for an H1B. So I'm not discouraged by, even if they're trying to tighten up the definitions and stuff, we still will fight as strong as we can for them.
Wow, that's great. And as we also say, where there's a way, where there's a will, there's a way.
Exactly.
So I think that's completely applicable. And thank you so much, Jessica, for putting up these great pointers. And I would also like to know more about the wages and the salary. So what role do wages and salary plays in the H1B approval process?
It actually plays a lot of a role because the whole point of the LCA, labor condition application, is they want to make sure that these foreign workers are being paid a comparable rate to American workers. They don't want to bring in all these foreign workers and then they drive the wage down. They want these workers to make a similar wage to what American workers or legal workers are making. So we have a prevailing wage. First, we see comparable whatever wages for where they're working and the job title. And then once we have something, we look that up, then we file the LCA. The LCA has different levels, as I mentioned, 1, 2, 3, and 4. So we have an idea what it's going to come back, the LCA. So it's not a shock when the LCA comes back and someone's like, I can't believe it's not approved. The wage is so different than what we thought. It never happens that way because we first check it with the Department of Labor and the OES wage survey online. So we're in the ballpark for what wage we think is appropriate. If it does come back that there's a problem, then you have to do it again. And that's, we've got to get moving on these H1Bs. So we don't want that to happen. And the other thing is, it also puts a check on the employer, because once the H1B is approved, the employer has to pay that salary. So if they're in America, they have 60 days to start paying that salary. If they're not in America and they're coming in, they got their H1B visa at the consulate and they enter, the employer has to start paying that within 30 days. So there's certain attestations on the LCA that the employer has to commit to paying that wage, to keeping them employed, as they said in their H1B agreements. So it's a protective feature for everyone, for U.S. for the foreign worker, and then the employer sees what their responsibilities are. So, yeah.
Absolutely, that's very well said. And with that, another question I would like to know regarding the documentation, because most of our viewers are really confused regarding the documents, and that too in 2025. So, what documentation is absolutely essential when submitting an H1B application?
Well, first of all, I would say don't try it yourself. Because I'm saying, I don't think in my 27 years of practicing, I've had anyone come back and say, I did the whole thing and filed it myself. It's complicated. Okay. So what kind of documentation? You need the form, the I-129. You need to make sure it's the correct form version. Immigration's always changing the form versions. You need that notice that you were selected for the lottery. You have to submit that. You need the LCA. The LCA is a little complicated. It's not something the average person can just fill it out and I got this. It's not just biographic information. You also need their transcripts and their official transcripts. So if they give you your unofficial transcripts or the school's like taking forever to give them, you need them and you need the diploma. So it can't be that the school just writes a letter and says, trust me that they got their degree. That does not work. We do a very detailed support letter explaining how they qualify, the H1B requirements, and also their job description. We also put together, like, if they're in the United States and they're doing what's called a change of status, we need to show that they're maintaining their current status. If they're not here and they do it as consulate processing, where they're out of the country, the H1B gets approved, and then they're going to go to their interview around October 1st, shortly around that time period, and then enter with the H1B visa. We need to show that they have complied with everything, they never violated their status, and they're entitled to the benefit of the H1B visa. So this is the basics of some of the documentation gets put together, and we work together. We work together, the employer, the future employee. I work with them until we get all the documentation in order, and then we submit it. And then everybody gets a copy for their records. The financial, confidential stuff of the employer, we eliminate that from the employee's packet they get. But it's important that let's say when they go to the H1B visa interview, that they're prepared for it. So we prep them for it. We help them. There's no interview in the United States. Once the case is filed, it comes back. You either get an approval or you get a request for additional evidence. If you get a request for additional evidence, yes, we're all disappointed because we wanted to work the first time, but you just deal with it. You just, everything that they ask for, you just, submit it, and then hopefully you get an approval. So that's it. That's some of the typical documentation for an H1B.
That's right. And I think, the people, those who get the applicants who get RFEs, they think that it's a rejection. But it's not a rejection, right? It's just that the officials just want more information. So this
It
is
could
another.
be a rejection. You have to be really careful because sometimes you think, oh, they sent me 10 pages. They hate my case, request for evidence. But if you respond to everything that they ask for, you could get an approval. They just don't understand certain things. Sometimes they send stuff back, they click buttons, and you think, like, did they read my case? But it doesn't matter. Obviously, whoever sent that and clicked the button, they want to know more information. So you just have to give them what they want. But it would have been nice if it got approved the first time around, but RFEs still give you a chance. It's not over. And a lot of times most of the time, we're able to turn them around and get an approval. So yeah, don't give up.
Absolutely. And with that, Jessica, I have another very interesting, or I would say important question, that, if the H1B applicant is doing everything good and they are following a proper process, then can we say that they have a proper chance to get the visa approved? Or we would also like to know, like, what are the chances of an H1B applicant being denied in this year, in 2025?
Okay, so you're talking about the lottery first. What are your chances of getting the lottery, or you're just talking in general to get the H-1B approved?
Okay, I think let's be a little specific. Let's talk about the lottery one.
Okay, so the lottery is like over 700,000 applications last year. So I always tell people it's 1 out of 7 chance. But they start the drawings at the end of March. But I wouldn't be fully discouraged because sometimes in the summer, like in June, there's another drawing. But people have to move on with their lives, so they have to start making their plans. So I tell them, yes, it's unfortunate if you don't make the first round, you better have plan B just in case, because we don't know if we'll have a second round. Okay, so once you're accepted for the lottery, then the chances of your H1B working are very strong. Because I mean, I could just say from my perspective, when I take an H1B, I want to make sure from the front end that we have a very good case. So if an immigration lawyer doesn't get the documentation to prove what they need for the H1B when they have to file from the front end, then that's the problem. Because that's where it fails sometimes, that they didn't realize they didn't have the right documentation. So we do that on the front end, so we prevent that issue. And then it's just the proper, certain immigration attorneys doing this, they have to have certain skill. They know what to look for. They know how to package the case. They know, if the employer, how to deal with the employer, any questions, concerns they have. And then, yes, you have a good chance of it working. Yeah, I would say. I can't give you a percentage of it, but you have a very strong chance of it working if it's presented properly. Yeah.
I was just about to ask the percentage, and you said that.
No, there's no lottery on that. So now your chances really increase. Right? It's not 1 out of 7. It's way better.
Hope
Yeah.
so. And because this is a question, that everybody has when they apply for this application, what are the chances? Will it going to happen or not? And some people actually wait for decades. And then after 10 years, they get the approval. So a lot of things are there, but I think having these sessions are really going to brainstorm them. And I think, Jessica, it's the first segment of this show. And after a break, we'll continue with the second part. So, friends, don't go anywhere because we are really having a great discussion. The session is lots of information over here, and I'm sure you don't want to miss it. So, keep watching Immigration Talk Show. It's me, Sam, with I would say one of the top immigration attorney, Jessica Ways. You can also contact her on the given contact details. That is 888 and you can also email her on jessicaw@waysIPlaw.com, and you can also visit her website, that is www.attorneyjessicaways.com. So don't go anywhere, we'll be right back. Till then, keep watching Immigration Talk Show, and we'll be right back. Yeah. All right, welcome back everyone to Immigration Talk Show. I'm your host Sam, and today we are having a great discussion with attorney Jessica Ways on the topic how to prepare your H1B application process in 2025. So, till now, friends, we have covered the first part where we understood some strategies, some tips, then also common mistakes. Also, what are the roles of wages and salaries? And with that, what are the chances of an H1B visa applicant to get approved? So I think Jessica, till now you are completely, detailing everything and explaining each and everything in a very great way. I would also like you to know that like to know from you that is there any case study that you would like to share with our viewers so that they can also get more connected with that case study and understand this H1B application process in a better way.
Sure. So this case was a woman from China, and she was an accountant, but she didn't have a license. So for H1B, you have to have a license to work in your field. And so I had checked with my peers, looked up the laws, and it said that if you're doing in-house accounting in this particular state, you did not need a license because it's state-based whether you need a license or not. So she got an H1B. She had a bachelor's degree, the foreign equivalent. We had to get it evaluated in accounting. And she worked 3 years in H1B. Then she did another 3. In the meantime, we filed for her green card. But because China's so backlogged in green card cases that she had to do, you can get extensions after the 6 years of your H1B. And so she was able to get that. And she just kept getting H1B extensions till her what's called priority date was current for her green card case. And then eventually she got a green card. And boy, was she happy because she had so many years in H1B extending it just because she came from China. Some countries process way quicker, but like India, China, Vietnam, Mexico, these countries have a lot of backlog. So even if you get the H1B, it could take way longer to get the green card. But there is a way for you to just keep extending your H1B if you either have to have an LCA, sorry, not a perm application pending for a year, or the I-140 if it's approved. Part of the green card process, if it's approved, then you can get 3-year extensions. So it just depends where you are in the process for the green card, how long H1B extensions you can get. But yeah, it was a whole process. And it's important to know, and it's important for your viewers to know, that sometimes you'll have a degree, but you need that license. So to do the H1B, so you have to have that in place too. You can't just file for the lottery if you don't have your degree. You say, oh, I'm finishing up in June, or you don't have your license. You can't file. You have to have things in place. So that's important to know.
All right, that's great. And that too, an applicant coming from China is really a difficult one. But I think
Yes.
absolutely India, China, they're having a lot of backlog and also the limitation. I mean, cap is also, 65,000, 85,000. So that's a very difficult process for them to get the approval. But I think,
Unless they went to, oh, sorry, Sam, I just mentioned, because it's an important point you just made, that you increase your chances by, you can try for the bachelor's 65,000 lottery and then the master's one if your master's degree is from a US college or university. So I would say to some of these people, try to get to America, do your master's degree here if you can. Then you get a better shot at the H1B. It's not a great shot, but it's 20,000 more for the master's one.
yeah, but I think, Jessica, that will another be a difficult process because to also get graduation, is it easy or is the process simple or that has some more challenge?
The process to get a master's degree in the US?
Yeah, yeah.
Yeah, you have to apply to your college. You have to apply to different universities, get accepted into their programs. There's probably different fees if you're a foreigner. You have to make sure you get your student visa on time so you can start the school year. But now they have an expedite track for F1 processing. If you're doing a change of status in the US, you can request an expedite. And the consulates are also been told that the F1 is a priority. If someone has to get to school, we need to put these F1 visa applications in the front because these applications are important. They can't make it to school on time. So,
That's great.
yeah.
All right. Okay, so I think, Jessica, we have covered some of the questions that I prepared from my end. And now I would like to take up our viewers' questions also because they have been waiting from quite a long time. So Kavya is here, and thank you, Kavya, for your question. And she's asking that I am getting a master's degree from a university that recently lost accreditation. Will I still qualify for the master's cap, or do I need to go through the regular lottery?
Wow, great question. You're going to go through the lottery, okay? And you're going to definitely go through bachelor's because you need to cover yourself. in case you've got a problem that you're not going to make the master's. But I would try for both if you could try, because the thing is, at the time you had your degree, got your degree, it was accredited. So I don't know. That could be interesting to see what they do with it. But definitely don't limit yourself to master's. Do the bachelor's too.
All right. Thank you, Kavya. In case if you have any follow-up question or would like to know more about this topic, then please go ahead and we will definitely take them up. Ashwarya is here and Ashwarya is asking that what are the key changes in the H1B application process for 2025 and what specific documents and information I need to gather to support my application and ensure compliance with the new regulation. So this we have already been talking, but if you
Yeah.
could just brief it out. So
Yeah, sure. I mean, what are the key changes? So we talked a little bit about that they want to really make sure that job description and the job duties, that they really tie in closely together, and it's a specialty occupation. I mean, what if you have an occupation that, some kind of administrative assistant doesn't require a bachelor's degree? Maybe the employer thinks it's bachelor's level, but if it's not standard in the industry, it's not going to work. It has to be that the industry requires a bachelor's level education for the position. So that's important. You want to have that in place. You also want to make sure specific documents and information that you need to gather to support your application. We talked about the LCA, the labor condition application, has to be filled out correctly. We talked about the wage needs to be the correct wage for the job title. The documentation, the degree, you have to have the correct degree that you put on the case. You have reference letters for work experience that's required. Those need to be in place, and any other supporting documentation from the employer. So all this documentation, it's critical that all this is in place and that it's reviewed properly, and an immigration lawyer that has experience doing H-1Bs, they can put it all together for you. So it's not like I hear the question almost like you feel like, do I have to put this all together myself? So I always tell my clients that you can do as much as you can on your own, and then I can just charge you to finish it. But H-1Bs don't work that way so well, because you have to have experience doing these. You really need a reliable, talented immigration lawyer who knows what they're doing. So
absolutely. That's very well put up, and thank you so much, Jessica, for clearing up that part as well. Most of our viewers think that they just have to fill up the application or just have to follow what the employer says, but it's not that way. That's why the reasons are so many that why the applications get rejected. So it's very important to talk to an immigration attorney and to consult with them, and that too, because they are going to provide the right guidance. They are going to guide you from like every process, and that's why I would like to also share the contact detail of our attorney also. So friends, you can please go ahead and dial the number that is 888-689-1862, and you can also email Jessica on jessicaw@waysIPlaw.com and visit our website that is www.attorneyjessicaways.com. So I'm sure, Jessica, our viewers are definitely going to reach out to you because they have lots of questions and they are really looking to have a personal guidance. So of course, you are definitely going to help them, and they are really looking forward to it.
thank you. I also would say that I offer a free brief consult to everybody, because I feel like even 15 minutes or so, just to give them a little bit of direction. A lot of immigration lawyers don't do that, but I'm giving them a little bit of direction because I feel like it's a very overwhelming process. And sometimes people will come to me and they're planning a year or two from now. They could be a sophomore in college and they're thinking about what are my plans in 2 years. Or I have a parent that knows their kid's going to age out when they're 21 of their current non-immigrant status, and they're trying to strategize for the future for their kid. So they just want to talk about it. Let's just talk about H1B. What are we going to have to do? And also it gives them a lot of time to look for a sponsor, because you H1B usually need a sponsor. We talked about self-employment, but usually you need a sponsor for H1Bs, especially when they're young out of college. They're usually not starting their own business, but you never know.
That's right. That's absolutely right. And I think now we already took Ashwarya's comment. Now let me take Siddhartha's comment. And Siddharth is asking that how might the concept of specialty occupation under the H1B visa program be impacted by emerging technologies like artificial intelligence and automation? And what strategies can petitioners use to demonstrate that their occupation requires specialized knowledge and qualifications, even in the face of rapidly changing job requirements and industry standards?
Okay, so I would like to see, what degree they have, because remember, H-1B requires a bachelor's degree or the foreign equivalent. You can also have it with work experience. You could have 3 years of experience equals 1 year of degree. But remember, that experience can't just be, like going to a restaurant and flipping, pancakes or something. Like it really has to be specialty occupation. You have to have skills that you would need a bachelor's degree for. So if one thing I would ask is if this person got a bachelor's degree and was in technology, some field, and they were taking some courses in these areas, then that could explain, okay, it's bachelor's level. If it's just work experience, they have 12 years of work experience and they're going to get the equivalent of a bachelor's degree, then we're going to have to show through, for example, you can use an expert opinion letter. Somebody in the industry can say that these skills are gained at a bachelor's level. You need them. They're very specialized knowledge skills. So an expert opinion letter from like a professor, there are companies you can hire and they'll do a special letter for you. You can also have other professionals in the field. You can have a professor even that gives a course on it. So you might have to back it up since it's still new. They're fairly new industries. You may have to back it up with some more evidence that it's really specialized knowledge that is needed, and not just anyone can go online and just learn it very quickly, like within 6 months or something, so it's going to need more to back it up.
All right. Okay, and now let me take Raghav's question quickly. Raghav is asking that what are the implications of having a job title or job description that is too broad or generic versus one that is too narrow or specialized on my H1B visa application? And how can I balance the need for specificity with the need for flexibility in my job responsibility? Yeah.
So I'm just thinking as you're reading the question that market research analyst used to be a very popular category for H1Bs. So what was your degree? Your degree was in marketing. So now it's very general, right? Very general, and market research analyst could be any business market research analyst. So you really have to, if you're going to go with some kind of marketing degree, again, I want to look at the transcript. I want to see what courses they really took. What if it was international marketing? What if it was a specific area marketing? And what if this company really requires that specific area? I want to get it closer to what they really need, because otherwise it's too broad. It's too broad, and you're going to get a request for evidence to narrow it down. And if you can't defend it, then you're going to lose. That's how H1B fails. It's a perfect question of how does an H1B fail? If it's too, but at the same time, he says, we need flexibility in my job. Well, you know what? There's what you put on paper and there's what you do at your job. So on paper, it has to work for an H1B. It has to be very specific, connected to the job title and what your educational experience is. And at the job, maybe there's a little more flexibility at the job of how you do your job duties, but it has to fit the requirements for H1B. If it's too broad, it doesn't work.
That's right. And there's a continuation of Kavya's question. Okay, so Kavya has a different question. That is it something different that is to be done for masters and bachelor lottery?
Well, there's a registration that the employer has to do. So once they go into the system and they have to check off different boxes in the lottery. So when you check off the boxes, you're indicating the master's, the bachelor's lottery, so they know which lottery. But yeah, people go for both lotteries also. So you have to, it's important. Yeah. So it's important that when the employer goes into the system, and then we check it as well before it's submitted, because we want to make sure, what if they made a mistake? So we have to do our part, they do their part as well, and then we usually wind up submitting it. Yeah.
All right. Okay. And okay, so these were the questions, Jessica, that we got from our viewers. And now we would also like
Great.
to take questions from our Facebook also. So I think, Control, if you could just share the screen and let the Facebook questions. All right. Okay, so this is the question that we got, I think, in a comment section on our YouTube channel. That viewer is asking, hello, good day. Inquiry is that how is the lottery for H1B visa conducted? Then how can I apply as an employee from Ghana? Okay, so I think let's take the first one.
Okay. So the lottery takes place so March 7th to the 24th. That is when we are doing the registration of H1B candidates. Then in late March, I think March 31st, the lottery starts. So then what happens is you're notified usually end of March, early April, And then between April and June is when you put your applications in. You have a 90-day window. October 1st is when you can actually start working with, if you have your visa or you did your change of status. So that's how it's done. They have, and if they have more that they can issue, like let's say people don't accept it after the 90-day window, then they may do another round in June. Like one year they did it in June. Yeah, get another round. Do you want me to answer the other questions?
Yeah, please. He's
Okay.
asking how can I apply as employee from Ghana?
So you don't need to be in this country to apply for the H1B lottery. So there's two ways to do that. If you do get accepted for the lottery and you're in this country, you can do a change of status if you qualify. But if you're not in this country, you just set it up as it's called consulate processing. So you file your H1B, even if you're not here, you can file your application. And then when it's approved, you'll need to make an appointment and do the visa application at your US consulate in Ghana. And then they'll interview you and then you enter with your H1B visa. It's a sticker in your passport and you enter with that to activate it. And then you asked if I provide any assistance in obtaining employment. So we can't. Ethically, we cannot do that. We can't help you find any jobs. Yeah.
Mm-hmm. All right. Okay. And he's also saying that I have a master's degree in industrial finance and investment. Do you help students who want to pursue PhD or MBA program on scholarship? Okay. All right.
Students 100%. Yeah, I can't do that either. No, I just do the immigration part of it.
Yeah, of course, that's right. Okay, so let's move ahead with the next comment. Okay, so Ketan has asked a question that, hi everyone, my H1B interview is scheduled coming next week. That's okay, 6 March, already been done. I'll be working at client location. It's an insurance domain. I do have LCA copy. So is client letter mandatory? Client did not provided any such letter. If VO ask about client letter, then how we can tackle such questions? Any help is greatly appreciated. Yeah.
Okay, so I don't understand. When they filed their H1B, did they list the locations where they were going to work? I mean,
Okay.
working at client locations, it says insurance domain. I do have the LCA copy, but so I don't know what is listed on the LCA copy. So that's my question. Is client letter mandatory? Well, they're supposed to list where they're going to work unless they put in general that there's a general vicinity, like in a certain county or whatever. So I'm not clear on that one to answer it.
All right. Okay. Okay. Let's take up the next question. And Ketan, if you could provide more clarity, then it will be easier for us to answer. Okay. So this is another question that is, hi, I have filed for an I-290B appeal case for my STEM OPT denial with USCIS Texas Service Center. So what is the average timeline for the case to be solved? And anyone who has filed for an appeal for STEM OPT got denial? Yeah.
I don't have the exact timeframes, but appeals usually take a year. These are a long time. I don't know, I don't know the strength of the appeal also. Is it worth it, the appeal? So that's what I don't understand either. But what do they have right now? Right? So if they're appealing a STEM OPT, are they still in OPT, regular OPT? Are they in F1? Because that doesn't stop the clock because you filed an appeal.
All right.
So that's, yeah,
But
they're welcome to reach out to me if they
Mhm.
want, give me more information.
Absolutely. But overall, we can say it may be like a year
Yeah, it could be.
approx. Okay,
Yeah.
that's a pretty long period, but that's okay. Let's go with the next one. Okay, Green is here, and Green is saying that I am new to this group. All right. I did masters. I am working on H1B as a software developer since last 8 years in USA, and totally 14 years experience, and applied EB2 on 2021 priority year. I'm learning AI development now. So will it be helpful? Useful for EB1A processing? What are the prerequisites and what are the things can help me to get it? I want to know the complete process for EB1A. Okay.
Wow. So they switched completely. They were EB2 and they were applied for EB2, but because the priority date is not current EB2, people are thinking EB1A, let's move into EB1A. So EB1A has 9 criteria. You have to hit 3 of them. So this is a whole discussion. This person's welcome to reach out to me privately as well, but just so the viewers understand that it's not just you have a certain amount of skill. EB1A is you have to be nationally or internationally recognized in your field. So that's something I need to understand better. And usually, it's not just that you've worked for a company in a leadership role or played a critical role, that if you've received awards, articles have been written about you, you've written articles in large papers with large circulation, you received a high salary compared to others, memberships in key organizations. There's a lot of different criteria. You have to hit 3 of them, 3 of the 9. So I don't know exactly how many he's hit. But definitely people are thinking, okay, EB2 is taking too long. Let's try EB1A. So I don't know if he qualifies. I don't know. He'd have to reach out to me.
All right, absolutely. And that's what Green has also said. Please ping me or comment here. I think I would suggest Green to look out for you. All right. So I think, Jessica, these were the Facebook questions that we got from our viewers. And, as we are already coming across with 1 hour, there are some 1 or 2 questions that I would like to ask from you. Okay, this we have already asked. So, yeah, what advice do you have for applicants who have been previously denied, and especially when applying in 2025? And also, what alternative options, if not H1B, and what other options are available for them?
Okay, so if they've previously been denied, the question is why were they denied? Was it at the lottery? They just got rejected from the lottery, so they'll just try again if they want. If
Mhm.
it's because they filed their H1B and there were real serious flaws in it, the question is what were the flaws and can they be fixed? Because sometimes people just are not H1B candidates, so we have to move on to other categories. So some other categories that people move on to if they're from Canada or Mexico, it's TN. TN is a popular one if they have a bachelor's degree in a particular field and they're going to be coming to the United States to work in that field. Sometimes they do TNs. Sometimes like O1A, extraordinary ability, we just talked about for green card, but sometimes they're extraordinary ability business developers. They have really talents, extraordinary talent in their field. They have a bachelor's, a master's, a PhD. Sometimes we move them on to O1A, but you do need a sponsor for O1A. Another one is L1A. Sometimes we say, okay, you work for a company abroad, you're coming to the United States to work for a company in a manager, executive, or a specialized knowledge position. And sometimes they might qualify for that. Maybe they have to go back for a year and work for the company and then try for the L1A, work for the company abroad. So these are some of the things we think. Also, now that there's a possibility of some self-employment H1Bs, maybe they're going to think, maybe I want to build up my own company and find a way to sponsor myself for an H1B. And that's coming up more frequently. I'm seeing people thinking, I can't find a sponsor, maybe I'm just going to make my own company. So these are some of the ways if someone has a degree and they're thinking, bachelor's degree, master's, how can they come here? What are other ways to come here? Some of them just go back into student status. They get another F1, get another OPT, and then they try again. So these are some of the ways that they do try and give them another opportunity to stay here. And if all else fails, I always tell them married American, but make sure it's a bona fide marriage. That's another way to stay here.
Absolutely. That's a pretty easy as compared to the other process going.
Well, Sam,
Yeah.
honestly, it used to be pretty easy, but the interviews are coming back. So the marriage case interviews, all employment-based green card interviews, these are all coming back now. So everybody's going to be scrutinized in green card applications. Yep.
A lot,
So,
I think.
yeah.
All right, that's great. I think that's all, Jessica. You have explained wonderfully. We got to know a lot of things, the alternative options, O1, L1, and that too about marriage thing also. That can also be a good option. So,
Right.
yeah, that's all. And it's always so joyful, so insightful, to have a conversation with you. I feel so happy. And our viewers are really, I would say, they are happy too with your information. So, any last message before wrapping up this session that you would like to share with our viewers?
I would just say that if you really are interested in H1B, it's not too late. March 24th is the 24th is the last day we can file. So you're welcome to reach out to me, reach out to an immigration lawyer and see if you really have a shot at it, because this is it. If you don't play, then you can't win, right? So this is a lottery. So if you don't try, you're not going to get it. So I'm happy to help anybody who's interested.
Of course, that's wonderful. And with that, I think thank you so much, Jessica, for bringing up so much on the table. And we are really appreciating your time, your support as well. And we are really looking forward to more and more shows with you. So again, humble and very thankful. I would say thank you to so much.
Thank you so much.
Right, that's great. Okay, friends. So those who have joined here and asked a lot of questions, I'm sure you got your answer. In case if you still have any follow-up question or would like to know more about the topic, please go ahead and put them on the comment section, or you can also directly reach out to the attorney Jessica Ways on the given number. You can also email her, and you can also visit her website. And with that's all, friends. It was a 1 hour session. It was a wonderful one. And thank you so much, everyone, for being here. It was great. Don't forget to like, share, and subscribe to Immigration Talk Show. And also, don't forget to press the bell icon so that you always get updates regarding our latest videos. We are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. Follow us on these many platforms. And keep watching Immigration Talk Show. Meanwhile, I'm Sam, signing off for now. Goodbye, everyone, and thank you so much for joining us. Hello, everyone, and welcome back to Immigration Talk Show. Thank you so much, everyone, for joining us. And before moving ahead, I would like to read out this very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, once again, welcome back to Immigration Talk Show. I'm your host, Sam, and today we are here with another very exciting and a very lively topic that is lined up for you. And the topic is, can you increase your chance of H1B selection in 2025 in the lottery? So this is really interesting. This is so exciting. And whenever we talk about H1B lottery, we have this notion that it's all about luck. But is it actually? Or with some steps, with some strategies, you can actually increase your chance of being selected in the lottery. Well, we don't know the answer yet, but I'm sure after watching this webinar, you will definitely get your answer. Because in this webinar, we really have a great attorney who is expert in guidance and who has years of experience in immigration, who loves helping people with their green card and immigration goals as well. The driving force behind Gondam Law Corp, based in Los Angeles, none other than attorney Marcelo Gondam. So, hi, Marcelo, and thank you so much for being here. I'm really excited for the session. And again, welcome to Immigration Talk Show.
Thank you. Good to be here.
All right. So, Marcelo, I'm sure that these days you might be busy with so many things because it's 2025 H1B lottery season. So, how's your experience going? Are you really being exhausted or excited with the clients and the complications that's been happening?
Yes, it's more exciting than concerning right now. We have a new program, our new program, like I would say a revised program, the H1B program for this year. It was implemented by the outgoing administration, the Biden administration, where certain rules were they made more flexible, more reachable the H-1B visa for many people and for many employers to be able to hire those skilled workers. So those rules are into place right now, and we are seeing that emotion at the moment, and they are very exciting.
That's right. Absolutely. So, Marcelo, do you think that H1B is all lottery system is all about luck, or with some strategies or with some steps, someone actually improved the chance for their selection?
Well, nowadays it's all about luck. That's the short answer to your question. In the past, companies used to apply some kind of trick. I
Yeah.
would say sometimes register the person more than one time, create several registrations for the same individual, the same candidates, or
Mhm.
through different companies for the same beneficiary. Um, and then they would if the person is selected for one company but not selected for the other, they will just start working for the new company and do the portability. So they used to do this kind of trickery before, but since 2000, since the fiscal year, the program for the fiscal year 2025, and now we are working with the fiscal year 2026, the Biden administration removed the ability of people to kind of trick the system by doing this. So now it's one registration per individual. It's actually being, we have to use the person's passport information to, so if you give your passport information, you have your number, your passport number there, then obviously another duplicate registration cannot be created. That makes it more fair for everybody who only registers once, and
Mhm.
everybody will have the same chance, which is about 20-25% chance of being selected
Yeah,
for this year's H1B lottery.
that's right. Absolutely. So, Marcelo, absolutely, the changes are there and multiple registration is no more. That's right. But, just talking in general terms, do you think the H1B lottery is fair enough because it doesn't go with skills or doesn't go with any qualification? As you said, starting of the show, it completely upon luck. So, do you think it's fair, or do you just your personal opinion? What do you think about the lottery system?
Well, the lottery system is actually, I think, the I cannot think of a better way to handle this. So you have an H-1B visa category,
Mm-hmm.
which only allows for 65,000 new entrants per year, per
Yeah.
fiscal year. There is another 20,000 for people who graduated from high
Mm-hmm.
education, uh, they obtain high education degrees in the United States. So they will go for another 20,000 additional visas. But the regular is 65,000 visas for a country with the economy of the United States. So the needs are very, the demand is very high for these skilled workers,
Mm-hmm.
professional workers, and there's not enough visas for them. So what can you do to make sure that everybody has the same chance? So they created a lottery system. The lottery system, though, does not take into evaluation at this moment the qualification of the person. So even if the person is not even qualified for the H1B, they can still apply for the register for the lottery. But then if they get selected and eventually they don't apply or they don't qualify for the H1B visa, then a new lottery will be ran down the road before, of course, the end of the fiscal year that we are now, 2025. And so
Mm-hmm.
they're going to run additional lotteries, and then more people will be considered again for this lottery. So it's not really a matter of, because if you have to verify if everybody qualifies or if everybody has good standing, good qualifications for the H1B visa, then this process is going to be too difficult. So it's better to just let everybody register, and then once people get selected, they will have a chance to apply. And then USCIS will verify the credentials, the education, the experience, and the occupation, and then approve or not the H-1B visa for that person. So that at that time, if many cases are denied or some cases are denied, and you have numbers that were not used by the people who were selected for whatever reason, then they're going to conduct a different lottery and call more people so they can use all the 65,000 visas for the current fiscal year.
Wow, that's amazing. I think that's very well explained, Marcelo, and that's absolutely perfectly mentioned because it's not possible to just check with just having 3 minutes or 5 minutes interview with any person, and giving them the right that yes, you are highly skilled as compared to the other person. Because for some people, skilled worker also has a different definitions, right? It's not only about medals, it's not only about qualifications, it's also about how much you're contributing to the society, to the economy. So I think to make the system fair enough, this lottery system is there so that nobody has any control and everybody has equal chance. And that's very well put up. But still, Marcelo, I'm still curious to know that is there nothing to do with any strategy, or is there nothing that any applicant can try to increase the chance by having some strategies, even a small strategies, if you could let us know with that thing?
To increase the chances to get selected on the lottery? No, because the lottery is electronic. So basically, they have all the registrations, and the people register. They have the registration, and the computer is going to run this lottery, this random selection, in
Mhm.
the end of the month. So I don't, unless there is something inside the system that
Mhm.
some insiders might point out to. There's no really a way to increase your chances, since you can have only one registration per beneficiary.
All right. Okay. That's fair enough. And also, Marcelo, there's another thing that some of the applications also got rejected before even entering the lottery system. So I would also like to talk about that. That what are some of the most common mistakes that get applications rejected before they even enter the lottery system?
Well, that's probably failure to properly register. So you have the guidelines to register. You have to have a passport. You have to have the information. You don't have to disclose the position yet that you're going to be applying for, but at least the name of the person, the name of the employer, passport number. It's the registration is actually very simple. So basically, you cannot screw this up. But once you register and you are selected, then many things can go wrong when the petition is actually filed.
That's right. That's right. And is it also true, Marcelo, that if we say that, okay, let's file early in the H1B process, then can that not guarantee, of course, but at least make a better chance or increase the chance for the selection?
A chance for selection, no. Chance to qualify for the H1B visa, yes, after you selected. But to
You know.
increase the chance for the selection, no.
All right. And also, I would like to know that what role, if any, does premium processing play in increasing the chances of the selection? So, does it speed up the process or improve the outcomes?
Well, the premium processing is something that happens after the selection. So after you are selected, when you file the petition or when your employer files the petition, then the premium processing service will be an option if they want the case to be adjudicated in 15 days. If not, they can just go run the regular course, which would take about probably 3 months or so. So it's not really even necessary to use the premium processing service when you apply for H1B, because even if you say you're selected in the lottery, so now
Mhm.
you're going to be applying in the beginning of April, and then why do you need to have the case approved in 15 days if you're only going to be allowed to start working for that employer on October 1st of the same year? So you get the case approved, but it's just for psychological relief, let's put it this way, because now you know that you've been approved. So now you can make your plans. You can have better planning because you know now that on October 1st you have that job. So that's the only benefit of using the premium processing service at this point. But it does not increase or decrease your chances of being selected.
That's right. That's right. Okay, and also, Marcelo, I would like to know that, for example, if someone gets selected in the lottery, but later on they want to switch the employers, because some cases also takes place in this way. So, is it going to affect the lottery outcome or visa approval of that candidate who got selected in the lottery and after that they want to switch? Or and if yes, then how can they handle such a transition legally?
No, it's not a problem there. Actually, there is a portability rule on the H1B. It means that if you have an H1B through an employer and you want to switch to a different employer, you can switch. The rules are very flexible, but you need to make sure that it's a comparable position that is actually also covered under the H1B. So you cannot go from an H1B position to a non H1B compliant position.
Mm-hmm.
You can switch, and then once you file the new petition, you can start already working for your new employer. So the portability is very simple, although we still have a problem with USCIS making mistakes in cases like this.
Oh, okay, that's strange. Also, Marcelo, if you could let us know about the transition process, how one can switch from different employer. What is the process for that?
So you have your H1B, your valid H1B status. If your new employer files a new form I-129, then you're allowed to start working for the new employer, or you can stay with the previous employer until the petition is approved. This is actually the best practice, if possible. But sometimes the new employer wants that person so desperately they don't want to wait.
Yeah.
The problem with this is if that petition is not approved, then that person lost their status. So now you don't have legal status anymore because you've been denied. So you have to reapply and possibly have to go back to your country or go out of the United States to pick up the visa when the new petition is approved. So there are certain things that need to be considered before making the decision to start working for your employer right away. But the regulations allow you, as soon as the petition is filed, the filing date is the date you can start working for your new employer.
Yeah, that's right. Okay, and with that, Marcelo, I would also like to know that if we see the 2025 time, then of course there are lots of changes, lots of scrutiny regarding the immigration process. So, if we compare the lottery system of 2025 with the previous lottery system, then is it that registration fees is also increased, right? It's from $10 to $15. So, what changes should we expect this lottery system? Are we going to see less forms, or are we see more forms? I mean, what do you think? What your I would say intuition feels like?
Well, I think the fees are probably used to probably, sort of, I would say, reject those curious applicants who actually don't have a real stake on the H1B, but they register anyways. And only more serious candidates will be registering because the fee is significantly higher. It's about 20 times higher than the fee that we had before.
Yeah.
But that's not going to be an issue for the person who actually wants the H1B because $215 is not a lot of money when you talk about what you can get with the H1B visa. So we don't think that's gonna be any kind of reduction in in the number of applicants. But USCIS believes that some of the curious applicants will be uh, discouraged to register for this.
All right, interesting. And Marcelo, I would like to know more about this topic. That, for example, if applicants they have the higher salary as compared to the other person, then is it somewhere is it going to make a difference in the selection process, or again the wages or the salary doesn't matter in the lottery system?
It doesn't matter because you won't be even the position is not going to be disclosed yet at that point. So the lottery is just the name of the company, the name of the beneficiary, and the beneficiary's passport. Basically, that's all they have to conduct the lottery. So everything that we're talking about is going to come after once the person has the petition filed with USCIS and USCIS promptly adjudicates that petition.
All right. So it means that only the company's name and the beneficiary name has been shown up. Nothing else, no other details is shown for the lottery, right?
Yeah, the lottery is it's just a ticket that you get to see if you're selected, and then you can apply. And then by the time you apply, then you have to disclose everything because everything will be taken into consideration for approval. So then it's going to be the professional resume, the educational credentials, everything that has importance to the petition.
Absolutely, that's right. And also, for example, if we say that, what are of course, we talked about the common mistakes. Then, is it possible for anyone, who is looking forward to the application, then if two employers who are working from the same company apply for the H1B lottery, so is there some role for the employer who can influence their application and can try to increase the chance? Is there the role of the employer that they can try to increase the chance for the lottery?
Well, right now that will not be possible because they can only apply for one. They cannot register one person. The company can apply multiple applicants, but that beneficiary has only one registration. So some companies, I can say, for example, the tech companies, they're probably going to file thousands of registrations, hundreds of thousands of registrations, but maybe 20% of their registrants are going to be selected and the
Mm-hmm.
others won't. So, but the company can have multiple registration. The beneficiary cannot. So it's every registration is beneficiary specific.
That's right. That's absolutely right. And what if, Marcelo, as we have been talking about, that selection doesn't depend on any qualification or any skill, it completely depends upon your luck. But still, I would like to ask that what else our viewers, what else they can keep themselves motivated by the H1B lottery, because it's really disheartening for them. There are so many people who applied for twice, thrice, or even more than that, and they are becoming, little demotivated and depressed and losing the hope for the selection. So, what message would you like to give to them?
Well, it's hard. That's a hard. I would say have some hope, or more hope than you're already having. So, which is something probably too big to ask, but that's all you have to do. You have to have hope that you're going to be selected eventually. There are ways that you can not be subject to the lottery. So you can go right away to apply any time of the year, and you don't have to go. That's the application that are considered CAP exempt. So those are when you're going to work in a specialty occupation for a company that is a non-profit organization, for example, that deals with research. So in
Yeah.
that case, those jobs are not subject to the cap, so they don't go to the lottery. So if you're tired of getting not selected at the lottery year after year, then probably look for a job in a non-profit organization that conducts research. So it is very important to understand the difference between the previous year and then this current year of H1B
Mhm.
process. So the Biden administration came out with a rule that was published on January 17th, and this rule has some changes.
Yeah.
The most important change for the CAP exempt is that now the nonprofit organization does not have to be primarily engaged in research. Research has to be one of the things that that company does, the organization does, not the primary one. So that's more that makes the H1B CAP exempt more flexible. So more employers will be able to qualify. So those are not going to be counting against the numbers on the lottery. They can go freely any time of the year. They can apply. This in this case, it's good to have the premium processing because in 15 days you have the notification that your case got approved or denied, depending on the case. But that's for the cap exempt. Since we're talking about this, another big change that the Biden administration implemented on the H-1B program for this year is, and I've seen a question about this already here, it's about the people who are applying through their own companies. So you can have even a majority, a controlling interest in the business that is your employer. So this made clear some rule because in the past, in the H-1B, you can apply, you can petition H-1B through your own company. But now it makes clear that even if you're a controlling partner, you can still have the H-1B file through that company. Another big change.
Absolutely, that's a very big change. Also, I think now if you have mentioned the cap exempt thing, then let's also dive into it. I would also like to know, Marcelo, that if we talk about the normal lottery system, then of course highly skilled workers and professionals are just trying to have a selection in the lottery system. But why, I would like to know the reason behind that, why the cap exempt are free from the lottery system. What is the reason that US CIS hasn't kept the same rule for the cap exempt people? What makes them different from the other people, other workers?
It's not really them, it's about the position. So if you're going to work for a nonprofit organization and your work involves research, or their business or their nonprofit organization conducts research, so the system wants to encourage more research. So research is somehow, in the eyes of the legislature, it's more important than just regular jobs. I don't necessarily agree with that, but research can open so many doors and can provide so much growth on the economy and society and everything, welfare of the society. So it's really important to have research not being barred by a lottery system. Uh, on the other hand, when you apply to just work as an employee for a company, then you have only 65,000 visas available per year. There was a time that the visas were 195,000 per year. And I believe that, if I'm not mistaken, I could be wrong now, but if I'm not mistaken, this extended cap expired in 2007. And you know how the economy was 2007, how the economy is nowadays. So the demand for H1B workers is much higher today than it was 2007. But Congress has to act upon it. Congress has to pass legislation to increase the number, if not permanently, at least temporarily, like they did back in the days. So Congress has to do something about it. But to your question, what makes it special that to allow those people to apply without being subject to the cap is the fact that they're going to work in an area that involves research. So research has to be encouraged by any country, any industrialized nation on the planet likes to attract research talent to their countries, and the United States is not different than that.
But you said, Marcelo, you don't agree with the thing that research is very important and they shouldn't come under the lottery system category. I would like to know more about your opinion. Why do you think like that way?
Well, research is important, but I don't think should be so much important than regular work, because those companies actually need those workers. They cannot expand their business sometimes because they don't have enough personnel in the United States. So that's why I don't think that should be different than I believe the H1B shouldn't have a cap, or if there was a cap, the cap should be much higher than just 65,000. But for example, they have another 20,000 for people who graduated, who got like a master's degree in the United States from a United States university. They run a separate cap, which is 20,000 additional to the 65,000. So they have a much better chance of being approved. So I believe the system is putting people in three different categories for the H1B based on what they think is more important. The first one is the regular employer who has a employee who has a bachelor's degree. The second group that's much higher and better chances are the ones who graduated from a master's degree in the United States. And the third group is the ones that want to work in companies that conduct research. Nonprofit organizations conducting research. Also, nonprofit organization also is a very good appeal because they are not for profit. So one of the criticisms about the H1B is that some companies explore or exploit the foreign workers on the H1B, even in detriment of American workers. So they prefer to pay less to a foreigner who's going to work H1B in the same occupation rather than pay higher wages to Americans. It's not always the truth that this happens, but this is that's something to consider when there is criticism about the H1B program. But now, when you talk about non-profit organization, they are viewed differently than for-profit businesses. For-profit business, they actually do this kind of stuff. The non-profit organizations normally don't do this. So that's probably another reason why they are cap exempt.
Yeah. All right, that's great. And I think that's perfectly put up that, of course, there should be three categories. The third one should also come the researchers and the people who are like cap exempt. Of course, and that's very well understandable. You know, it feels little different that what does make them so special that they don't come under the lottery, and that too, the cap is also just 65,000. So it feels so, I would say, bad for most of the applicants because they have been keep on trying for years and years, right? And for cap exam they have to be a researcher or somewhere like professor in Harvard University, so that again builds up another challenge. So I think that's very well put up, and it's more about Marcelo, to make our audiences aware about the different perspective and different ideologies that these all things can also may happen in the system, and they can also be aware regarding the information. They shouldn't be just stick to what the rules are actually, but they should also start asking questions. So I think that's very well put up. And now I would like to also take up our viewers' question. I can see a lot of viewers here. Patricia is here, and she is. Hi, Patricia. Thank you so much for this clapping emoji. And Sneha is here. Then Bruno is here. All right. Dipti is also here. Vishnu is here. So, hi, guys, and thank you so much for participating in this session. And don't forget also that we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So, follow us on these many platforms and put as many questions as possible because this session is completely for our audience. And whatever questions guys you are having in your mind, please feel free. We are here for another half an hour, and after a quick break we will cover the questions that we are getting from our viewers. So don't go anywhere. And Marcelo, I think you have already informed us a lot of things, so let's have a short break. You take a glass of water so that you can relax a bit, and after that we will definitely take our viewers questions. So friends, don't go anywhere. It's me, Sam. We are having a great discussion on the topic that can you increase your chance of being selected in the H1B lottery. Stay tuned, and we'll be right back, so don't go anywhere. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are having a great discussion on the topic that can you increase your chances of being selected in the H1B lottery? Until now, I'm sure that most of our viewers got the answer that, friends, it's all about luck. That's what attorney Marcelo Gondim has said. But still, you don't have to lose your hope because that's how the process goes. And it's actually to make the whole system fair enough so that each one of you have the equal chance and there shouldn't be any discrimination going on. So, with that, I would also like to welcome back to Marcelo to second part of this webinar. So, Marcelo, I think now it's time to take up our viewers' comments because they have been posting a lot of comments and questions. Okay, so let me take Sneha firstly. Sneha is asking that I missed last year's H1B cap. If I register multiple times through different employers, does that improve my odds or is that risky?
Well, it's not risky. It's just impossible because now, like we said before, it has to be through your passport. Your passport number will be provided, so there's no. You can only have one registration per person.
That's right. And I think now it's illegal also. You can't apply for the multiple registration. So yeah, that's a sad chance. And Bruno is here, and Bruno is asking that how about the self petitioners? What are your perspectives? Yeah.
I think the self petitioners. I don't like to call self petitioners because self petitions mean that you're petitioning yourself. And there's a separation in the United States law. There's a separation between what's a company and what's the individual. Even if the individual is the 100% owner of that company, it is still separation of entities. So when you say self-petition, is you are petitioning yourself, but because you are the owner of the company, doesn't mean that you're being a self-petitioner. There's still a petitioner, which is your company, and the beneficiary, which is you. So in that case, the chances of being approved or denied are the same as if it's another, because the regulations actually clarify in the from the proposed rule and the published rules from the Biden administration that even if you are a controlling partner, that company, that business can still petition your H1B, and there should be no difference on that. I am sure that USCIS adjudicators might feel a little skeptical of some cases when companies were created just for the purpose of applying for the H1B, so that once they get approved, they
Yeah.
can switch to a different employer. So that's going to be in the minds of the adjudicators as well. So, which is not actually illegal to do that, but if you don't plan on having that company actually operating, then it might be considered immigration fraud. So you should be careful with this. But normally, if you have your own business and your business is in the best position to decide who they want to apply for, which is in this case you. So you should go ahead and file. It's not going to be self-petition. It's going to be a petitioner and a beneficiary, like I said, but that can be your own company.
All right. Okay, so thank you so much, Marcelo, for explaining that in a very detailed form, and that too clearing up this very common, misconception that most of the people have. And Bruno, in case if you have any follow-up question or would like to know more about the topic, then please go ahead and put up more comments as possible, and we will definitely take them up. And let's take Dipti's comment now. Dipti is here, and she is saying that I work for a small startup and they are willing to sponsor me. Do smaller companies have a harder time getting their applicants selected in the lottery? If my employer files my H1B under both the regular cap and the master's cap, does that really double my chances? Okay.
I wouldn't say double your chance. You already have a much better chance because you're gonna run from on a separate cap, which is the additional 20,000 because you have a master's degree. So you already have a better chances there, a better chance there. But that doesn't mean that you have smaller companies have less chance of getting their cases selected in the lottery than bigger companies. I wouldn't. I have no indication that this is the case.
Okay. And Marcelo, I ask regarding in the terms of percentage, then could you just let us know that in terms of percentage, how much chances are for the 20,000 applicants have chances for the lottery if they are graduated from the US universities?
But the percentage of chance, I have to see how many of them are going to apply and how many of them are not going to be pre-selected on the regular 65. So that's very hard to it's very hard to calculate this because it depends on how many are going to apply. We're expecting for the regular cap 300,000 applications for 65,000 visas, which is roughly 20-25% of chance. So
Yeah.
I believe the chances on the master degree cap should be much higher than that because there's less people that qualify for this, and
Mm-hmm.
about a third of the 65,000, a third equivalent to a third of those visas will be selected just for this small group, or I would say smaller group of candidates. So the
Yeah.
chances should be much bigger if you have a master's degree from a U.S. university and you apply under the additional 20,000 visas.
All right. So we can also say that, if someone has a US university degree, then they have at least a better chance of being selected in the lottery as compared to the 65,000 people, right?
Oh, absolutely.
So
Because
they,
there's less people in that category that have this master's degree from a U.S. university, and
Mhm.
also they have 20,000 visas dedicated to that group. So the chances are much, much higher.
That's right. So I think, friends, now you can go ahead and look for that option too. I won't say that's simple, but at least that will increase your chance for the lottery, and that will definitely, get your dream come true to live in US and work in US. But thank you so much, Dipti, for your comment. And let's take up Bishnu's comment here. And Bishnu is asking that I'm a STEM graduate on OPT. If my H1B doesn't get picked, should I consider a day one CPT program, or could that cause issues later?
No, the STEM OPT or the OPT in general is a very good solution for people who completed their degrees, and you should really make good use of this program because it's really good. That is actually when you do the H1B and, for example, your OPT ends before the period of time that you're gonna be starting working for your H1B employer. There is something called the cap gap, which is a bridge on your OPT so that you can continue in the United States waiting for October 1st when you can start working through the H1B.
Hmm. That's right. Okay. And thank you so much, Vishnu, for your comment. And let me take Gautam's comment now. Gautam is saying, I completed my master's in December 2024, and I'm applying for the H1B lottery in March 2025. So, do I need to have my degree officially conferred before applying?
Yes, you have to have that degree. So in order for you to qualify, you need to have the degree, but you don't have to have that yet to do the
Mhm.
registration for the lottery. But once you apply in April, if you are selected, you need to have that degree because if you file the petition with your SCIS and you don't have that degree at the moment, they are not going to consider that your petition, even if you get your degree later. And also remember that if you don't apply right away in April, let's say you get selected, but you don't have your degree, there's some kind of delay with the university, and then you keep going, 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 and then it comes like April, and it comes May, and you still were not able to file. If the 65,000 visas are exhausted, then
Mhm.
you won't be able to apply later. It's not like in May or June that this happens. Normally, it happens more towards the end of the fiscal year, like around maybe August or September. But you still have to file your petition as soon as possible. So you need to really expedite this with the school because if you don't have that degree conferred by the time you apply, your petition will be denied.
All right. So I hope, Gautam, you got to know what you have to do and make sure that you follow the steps very carefully so that, you don't face the another problem. And right now, Marcelo, we have covered all the questions that we got from our viewers. Now, I would also like to take up our YouTube comments as well because, as we do shows, our viewers also post questions over there. So, with your permission, I would like to go with those also.
Let's go.
Okay, that's great. Control, if you could show or share the screen. Okay, that's great. So we have Shri Harsha, and he's asking that thank you for detailed information. I'm in a similar situation. I'm an Indian citizen by birth and moved to Canada as a permanent resident. Got my H1B approved recently in January 2025. So I was an Indian citizen when my H1B got approved. After this, on March 6th, my Canadian citizenship application got approved, and I'm gonna get my Canadian passport. So, do I need to go for stamping with my Canadian passport? My wife's inland PR is still in process in the last stage. How do I schedule for H4 visa appointment, and is there a way for US to travel together to the United States?
Well, about the registration with the new citizenship, this is only if in your previous country you lose your citizenship by naturalizing in a different country. So in that case, you will have to do that. But if India, for example, allows for dual citizenship, then you shouldn't have a problem with that.
All right. Okay. Let's move ahead with our next comment. And the TDVP is here and saying that thank you for the valuable info. I'm a teacher not funded by the government on culture exchange teacher visa. I understood that Indian J1 visa holders don't have to go back for 2 year rule. Can I apply for the H1B after my 5 years of program, or is there any process or permissions to be taken like waivers before apply for the H1B?
No, in that case, you won't have that problem. There was actually a regulation, that a new rule that came out a couple of months ago, and about 30 countries were listed in this list of countries that do not require to people from those countries don't require to have a J1 waiver before they can switch to a different category.
Mhm.
So, and I believe that India was one of them.
That's right. Okay. Let's move ahead with our next question, please. Suchit is here, and Suchit is saying that thank you so much for discussing the scenario. Would the timeline for EB2 and IW as a physician still depend on the country? I am an IMG from India, currently in residency training, serving the underserved population on an H1B. Yeah.
Yes, the problem with the EB2 national interest waiver or any EB employment based case is that India and so China, they have separate lines for on the visa bulletin because those countries have already surpassed the 7% maximum of the diversity program. So because of the number of people from India and China being significantly higher than the other countries, way more than 7%, they
Mhm.
have this extended lines waiting period. So the EB2 national interest waiver for someone from India will take probably several years before this person will be able to obtain the green card. The good news, if there's some good news about this, that's not really good news, but if there is some good about this, is that if you are on your EB2 and your case is approved, your I-140 has been approved, and you have your H1B, you can stay under the H1B more than the 6 year limit. So you can stay doing 1 year increments until the visa bulletin becomes current for India.
That's actually a good news.
That's such good news because they won't have to, and that's why some a little a little off-topic comment here. This is why some companies like to have Indians and Chinese employees for the H1B because they cannot really go anywhere. Once they file the petition gets approved easily. But then that petition is on the visa bulletin backlog, and the person has to be renewing year after year, and they can stay with the company. They don't have the flexibility of leaving the company for a better job, so
Mhm.
they get subject to whatever the company wants to do with them. And that's really sad, but it's actually good for some people who have a legitimate interest in working for the employer, and the employer wants them, and they can extend the visa past the 6 year. But there is also some kind of abuse on this on
Yeah.
Indians and Chinese people, and I'd like to mention that here.
Of course, and thank you so much, Marcelo, for mentioning that. Because if we are knowing about the advantages, disadvantages should also be known. It's not only the positive thing or the shiny things that we should know. It's also about the other side of the story that's really important to know. So again, I would say that's really important. And let's move ahead with our next comment that we got from Johnny. And Johnny is saying, thank you for your useful video. I have one question. Can you help me? That my wife and I both got the green card 25 years ago after her father became a citizen. My wife became a US citizen 20 plus years ago. We live here in US after we got the green card. Now I want to apply for US citizen. So which category I should choose? General provision or spouse of a US citizen? I have meet all the requirements of both category. Your advice and response is highly appreciated. Yeah.
Yeah, if you can do either one because it's more than 3 or 5 years. So the spouse of U.S. citizen can naturalize with 3 years of permanent resident status, and everybody else is with 5 years. So whatever you do, it's going to be okay. You're going to be approved. If you still live with your wife, then you don't have to worry about doing the 3 years. You can just do the 5 years, but you have to show that you've been living in the U.S. for more than half of the statutory period. So that means if you are in the past 5 years, you have been here for more than 913 days, then you should go with the 5 year. There's no problem. But if using the 3 year will make you have more time in the US than outside the US in those 3 years, which you wouldn't have if you count the 5 years, then you should go for the 3 years.
All right. Okay, that's great. Thank you, Johnny, for your comment, and we will definitely let you know more about the topic. Anand is here, and Anand is saying that when a L1B gets converted to L1A before expiry of 5 years in US, will the total tenure clock gets reset for the L1A? Will the tenure can be another 7 years for L1A, and also while converting, do the candidates should be outside US for 1 year? Please advise.
No, in this case, you can have the tenure change to the L1A, which is 7 years maximum. So you can have 2 additional years.
Okay, all right. Thank you, Anand, for your comment. And let's move ahead with the next one. And Jose is here. Jose is asking, do we need to wait for I-140 before filing EAD?
You don't, but sometimes you have to. So the I-140 is the underlying petition. So the EAD is only applied when you have the I-485, which is the application for adjustment of status. But sometimes you cannot file simultaneously because the preference is not current on the visa bulletin. So if it's an EB1, you can file I-140, I-485, and the request for EAD. You can file everything together, even if that 140 has not been approved yet. But if you're filing, for example, for an EB2 national interest waiver or an EB3, or if you have an EB1 but you are from India or China and it's not current for your countries, then you cannot request the EAD yet. You have to get the I-140 filed, but it's not the I-140 being approved. The date that you have to look for is the date the visa bulletin is calling up your priority date based on your country of chargeability.
That's right. Okay. Thank you, Jose, for your comment and for your question. Let's move ahead with our next comment. Okay, Akash is here. Akash is asking that I'm holding a valid H1B visa with me, and the stamping was completed back in November 2024. Now, if I plan to switch to a new employer, then will my current visa be revoked by my existing employer, or can I utilize my existing H1B visa to find a new employer from India? I have not traveled to US yet. I'm still in India and I'm exploring the opportunities to utilize my visa and make it work.
So that can be a little tricky. So you have the stamp from the company, but now you want to work for a different company. So we have to see how they place this visa on your passport. But normally you can come to the United States for that visa, or you can get a notation on your visa that now you're going to work for a different employer. But that petition has to be already approved. If you come with that visa and then decide to change employment here through the portability, then you wouldn't change your visa, but you would change your status. actually you're going to have the same status, but change the employer that's giving you that status. So that's something that has to be uh, synchronized perfectly so you don't have problems in the future.
That's right. That's absolutely correct. All right, now let's move ahead with the next question. Okay, so I think Akash one was the last one that we got from YouTube. So I think with that, Marcelo, we have completed all the questions from. Okay, Vishwanathan is here. All right, let's take Vishwanathan's comment. And he's asking that I have L1A interview next week. All right. Genuine, what difficulties I have for clearing with new vetting? Told that 90% is done with PI-129 approved, so 10% on interview.
Yes, well, the Department of State has been making several mistakes regarding these petitions like H and L. So L is a dual intent visa, but even though it's a dual intent visa, sometimes they apply the 214B rule, which is a complete mistake, an
Mm-hmm.
absolute mistake. It cannot be done this way, but the Department of State is feeling very above the law at this moment. So you have to be just concerned about 214B, which is the um, demonstration that you're not coming here permanently. You still have intention to go back to your
Mm-hmm.
country after finishing your program. That shouldn't be an issue on L1A or H1B, but today it is an issue, and they have some petitions denied at the consulate, some applications denied at the consulate after the petition has already been approved by USCIS. The good news is this might be one of the exceptions that you can actually sue the Department of State in federal court in the United States if they deny under 214B. I've seen precedent decisions about this, and it can be done. It's not easy, but it can be done. Hopefully, you won't have any problems with the consulate when you go for your interview. Good luck.
Absolutely. Good luck, Vishwanathan, and thank you so much for your comment. Also, you can put up more questions or more comments. We will definitely take that up. And this we have already taken I-129 approved. Okay, but also it's not, I would say, not just Vishwanathan or Patricia or Bruno or anyone, guys, you can directly reach out to our attorney, Marcelo Gondim. And that is one of the best thing because you can personally take the expert advice. It's through show that we are taking up these questions, but I'm sure that there are more questions, there are more doubts that you guys are having in your mind, especially during this time. So why don't you go ahead and directly get in touch with our attorney Marcelo Gondim on the given detail. That is the number is 323-282-7770, and the email ID is frontdesk@gondim-law.com, and the website is www.gondimlaw.com. So yeah, I think, and Vishwanathan is here, and he's saying that that's thanks, that helps. Of course, thank you, Vishwanathan, and I have shared the contact details of attorney, so you can also directly ask any question to him, and he will definitely give you the expert advice. So with that, Marcelo, it. I really didn't, and I would say, realize that it's just 1 hour past, and we have come across with lots of questions. So it was really great having you on the show, and always a pleasure to have a show with you. So thank you so much for joining us. And how was your experience? How did you feel? Anything that you would like to share with our viewers? Please go ahead.
Yeah, thanks for having me. It's a pleasure to be here. And I like the experience of talking to people from other countries, from everywhere about visas. This is what we do every day, and we enjoy talking about it.
Absolutely. And knowing information from you is like cherry on top, because you always, fill the show with lots of insights, and that too in a very simple way. So, again, a big thank you to you for your time and for your support. It's really appreciating, and we are really honored to have a show with you. So, again, thank you so much, Marcelo, and have a great day.
Thank you, you too.
All right. So that's all, friends, and it was a great session. I hope you guys enjoyed. And in case if you still have any questions or any doubts after the live stream goes on end, don't worry. We will still take those questions, and we'll definitely get back to you. Till then, don't forget to like, share, and subscribe for such informational webinars and also for such informational videos. And also press the bell icon so that you get the notification whenever we come live with any attorney, and you can directly participate in that session. So that's all for today's episode. And also, it would be lovely if you could, join us on our session that is just coming live at 4 p.m. EDT, that is Daily Immigration Dose. So, till then, friends, take care, everyone, and fill yourself with lots of information. Don't lose hope. Stay vigilant, stay resilient all the time, and stay motivated, because we are here to spread a lot of information and to keep yourself updated. Don't forget to like, share, and subscribe to Immigration Talk Show. So, thank you. Good luck, everyone, and take care.
Hello and welcome back, everyone, to Immigration Talk Show. I'm Napasa and I'm going to be your host for this session. Thank you so much for joining us here once again. And friends, this is Immigration Talk Show. We have a very interesting webinar lined up. And before we have our guest for today's discussion, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, welcome once again to this very important session, I would say, because it's going to be on a very interesting topic, what we are all wondering and reading a lot about, especially because it's the season. So, what is the impact of new H1B regulations and FDNS site visits? And of course, we are going to also discuss about the April 2025 visa bulletin, which is already out. So it came out yesterday, and we are going to discuss some highlights with our guest. So, yes, let me introduce you to none other than Uma Mantravadi. How are you doing, Uma? Thank you so much for joining us. How are you? So,
I'm doing great, Napasa. It's such a pleasure to see you again and to have this session with you.
Same here, Uma. It's exciting. I think this year we didn't meet, I mean, like this for a discussion. So I'm really happy to be here. And folks out there, for those of you who I'm sure are wondering who is this familiar face, let me tell you that she is none other than Attorney Uma Mantravadi from Mantra Law Office, which is a highly reputed firm, and it's located in Houston, Texas. So, United States, at around this area, Mantra Law Office is where it's going to be also very busy. So yes, Uma has expertise and experience for over 3 decades now. So I'm sure, friends, you must know her or want to know her for sure. So go check out www.mantralaw.com. And yes, thank you, Uma, once again. So,
My
um,
pleasure, Nipasa. So much going on under the Trump administration, as you know that, and there's every hour by the hour we get information that is updates and can be surprising to our listeners. I mean, there's people even ask me this question: how are you able to digest this information? By the hour it comes out, and then the changes. There's so much that's going on, and in fact, me and Sam had talked about a couple of weeks ago that the forms were retracted back to an old edition, which caused
mhm,
a lot of problems for attorneys where the forms were being not accepted and the packages were sent back by many attorneys, especially the 485s, many other forms.
yes,
So, as a group of attorneys, we have filed a lawsuit against the government, and now they are
okay,
accepting all additions and will give us additional time to let us know what addition they will accept in the future.
very
So I
interesting.
guess
So,
it's going to be a game of lawsuits, going back and forth.
how's the response so far? Are they reacting well to this?
A good question, Nipas. I wish I could say there's anything good, but we always take the positive side of everything. There's always a negative side, but there's always a positive side, and that's what we bring to this show to the listeners, to ease their lives, to kind of give them a path, a guidance, hoping that they would go on the right path. So.
Absolutely. Thank you so much, Uma, and it's always a pleasure to have you. So, as we start today's discussion, also, you said you have a couple of updates. So, would you like
Yes.
to give them first?
Yeah, that lawsuit was one of the updates that I wanted to bring about. And then, second thing, the Department of State, they've eliminated what's known as the deference policy on non-immigrant visa waivers. What that means is, a deference is kind of going to your history and giving weight on your history and your documentation. For example, if somebody had an H1 and had an H1 approval, they would give deference to that approval from the past, not just the current one. And that would give some benefit to the applicant filing an application. And but this one particularly, they're talking about removing the policy from consular officers recommendation of approval of non-immigrant visa waivers. They're talking about waivers. Like, for example, if somebody had an individual waiver for a non-immigrant visa due to any ineligibility for in or called as inadmissibility due to medical grounds, criminal grounds, immigration violations, fraud, misrepresentation, any of these grounds, if somebody has been denied a visa and they applied for a waiver, now they could use that waiver that was obtained in the past, even for the current situations, and move on. That's what was the deference policy. But now the department is saying, that Department of State is saying, we don't have to go with your deference of the non-immigrant visa waiver. We can definitely request you to get another waiver before we can grant you the current visa. It can be an H1, an L1, or a B2, doesn't matter. Just because you got the waiver in the past, we're not going to give deference to that. We're going to ask you to get another waiver so that, we want to make sure you've not violated anything in between. So this is going to place additional burdens on people who've had violations and then who've got a grant of the waiver now have to go back and get a second waiver, so they have to review each waiver application independently, and a new waiver has to be approved before the officer can give any undue deference or rely solely on the previous officer's decision to grant that waiver for the approval. So this is going to put additional work on people, additional delays on cases. So it's not great news, but that's what it is.
Well, thank you so much, Uma, for that very important update. And folks, yes, thank you so much for joining us. Rahul, thank you for your questions. Please stay with us. We are going to address them a little later in this episode. So, yes, and Uma also, the visa bulletin is out for April
Yes.
2025. Yeah, so let's look at some of the key updates and changes, maybe. What do you say? So,
EB1 for India has advanced to Feb 15th, 2022. EB2 category has moved to Jan 2013, and EB3 for India has progressed to April 2013, April 1st. It's a little bit of an improvement. I wouldn't say it's extraordinary, but I think, even if it is moving at a snail pace, I think people from India are still happy to see some improvement in
improvement.
the visa bulletin.
Right.
So we can
Well,
talk more about it, but those are the cutoff dates. And EB3 other workers is also at April 1st, 2013 for India.
mhm, mhm. Right, right. So, thank you, friends. There is little movement, of course. There are also retrogression that you can see, but it's not that great, like Uma has mentioned. It's not extraordinary or wow that we can talk much about it. We'll just have to be patient. But congratulations for folks whose dates have finally come, and all the best for the rest of, the process. And
Right.
yes, Uma. So, coming back to some of our questions, our topic of
I know you
discussion.
mentioned
Yeah.
about the retrogression, and I didn't talk about that, which is the EB5. EB5, India's unreserved EB5 immigrant visas numbers that are not set aside for rural or high unemployment or TEA. Cutoff date is retrogressed to November 1st, 2019.
Yeah.
That is the retrogression. And
Right.
EB5, of course, right now there's still the 800,000 for the rural as well as urban investment for target employment projects, as well as, high unemployment areas. But if you're doing an individual investment, it's still 1,050,000. But of course, Trump has discussed about the gold card that is not yet the law. Right now, EB5 is a legislation by Congress, and so this will remain in place until September 2027. But we
Mhm.
don't know what the Trump administration still can do, as you know that. They can always bring about executive orders to create chaos. Will they do that? We don't know that.
Well, we'll just have to wait and watch. But I know the gold card is also making quite a lot of noise. Just the $5 million news, I would say, and so many hopefuls out there. But let's wait and watch. We never know what's going to happen. So, also, our topic of discussion for today is about FDNS site visits. So, if Uma, you can also provide sort of an overview of the FDNS and what significance it has in the context of H1B visa rules and requirements.
Yeah, sure. Thanks. Napasa. First of all, FTNS site visits is not something new under the Trump administration. It's been there for a while, even under Clinton, even under the Obamas, George Bush, all of the presidents, pretty much we've seen it. But I think the enforcement is going to be much stronger under the Trump administration's second term because immigration has been the discussion and focus for President Trump under the second term. And, as you can see, deportations are on the high priorities, and this has been going on. So, what is FDNS? FDNS is the short form of the Fraud Detection and National Security Directorate, which is a division of the USCIS, which conducts, let me use the word clearly, unannounced site visits, particularly to H1B employers as a part of the compliance and fraud prevention efforts. And this visit is the aim is to verify the legitimacy of an H1B petition and making sure that an employer and employee are both adhering to the program requirements, And because of the recent changes, as you know, the H1B modernization has come about in 2025. These visits will affect both employers and employees because of this. And it is widely expected that the CIS will increasingly shift its focus towards enforcement efforts more under this second term of the Trump administration. And that's why the employers should be very, very familiar with what or how these FDNS site visits are conducted and how can one be prepared with these visits in advance. So that's what I wanted to talk about. Just to give, I can't tell word to word what the FDNS officers can really mention, but we can what are the things that they possibly can ask, So that's what I'm talking about.
Yes, that's right. And they are surprises, like Uma has already said that they are unannounced. So it can happen anytime. All we can do is play safe. So abide by the rules that you have to follow. The of course, company policy, and goes without saying that your workspace has to be your workspace, and you should be working while it's your time to work, right, Uma?
Absolutely. Well,
And documents.
go ahead.
No, and what about a document? Should suppose there is a visit, and what will they be asked for? Of course, their identity card, probably.
Let me go through possible scenarios where, there's typically an unannounced USCIS officer visiting the work location specified in the H1B petition. And if they give a third party site, they're going to go there. If they give their own office location, they can go there. Or if they are giving the location of a remote, for example, if the employee is working from his or her own apartment or home, they can go there also for a site visit. And when they do go, they typically engage in one or more of the following things. They verify the physical existence of the business. For example, if the employer has given their office address, they can go there to verify if they really exist or they don't. Confirm the employment of the employees' designated work site. They want to make sure if they're, like I just said earlier, if it's at a third party location, interview the H1B employer or employee or their representatives. They can review the payroll records, timesheets, work schedules, any other connected documentation. and they can probably assess the compliance with the H1B regulations. So basically, the idea is to prevent fraud or misrepresentation by the employer and the employee.
Well, well, right, very rightly put, and thank you so much, Uma. So these were some of the documents that or questions that you could be asked for. So, Uma, thank you for highlighting them. And also at this moment, I'll quickly say hello to Yash and Echo Alex. And I think let's take Echo Alex's question. So he's asking for El Salvador TPS extension. Do I need to fill out form I-765 and pay the fee, or just I-821 form?
If you need the work permit, definitely you need to fill up the 765 and pay the fees accordingly. There is a whole chart of fees that you need to make sure you're paying the correct fee.
All right.
This is for TPS, which is also known as temporary protective status.
Right, right. So all the best to Eco Alex. And now let's also quickly address Yash's question. I've heard that FDNS site visits are becoming more common. Do you How do they decide who to inspect? And are certain industries, companies, or job roles more likely to get a site visit?
Not really. They don't go by industry or they don't go by employer. It can be a Microsoft or it can be a mom and pop kind of small employer with only 2 people or 10 people or 100 people. So it all depends on the officer. If they feel there is a red flag somewhere, the documentation was not clear, or they feel there is some kind of a fraud in their own mind, how do they determine they're not going to tell anyone about that? Or if they get a tip from somebody, it can be any of the following reasons that can lead them to an FDNS site visit. So we cannot say it's because of a job duty, job role. It can be for any umpty number of reasons.
So it's just like the lottery then. How lucky your day is today. Anyway,
Exactly.
but thank you so much, Uma. And thank you, Yash, for participating. Thank you for your question. Very interesting. And also, let's take up Rahul's question. I am an H1B visa holder working at a third party client site. With these new regulations, is there a higher risk of denial or site visits? And what kind of documents should I keep ready in case of an FDNS inspection? So, Rahul, I hope you were watching us. We've already addressed these questions and also discussed a few, possible questions or, demand for documentation by the inspection officer. And also, maybe we can take up the first part, Uma.
I've
Third
lost
party
you with
client
the
side.
first part. Oh, he's
Yeah.
working at a third party client site. Okay. That has to be, they'll check the LCA possibly to make sure that the LCA has the third party client site listed, or if it is a hybrid work arrangement. And, they can, FDNS officers typically have a wide and great authority to assess compliance at multiple work sites. So if they don't actually come to you, they can go to the third party client to verify your employment. They necessarily don't have to come to you, the employee, to get this information. They can get it from the third party vendor to get that information. So under the new H1B regulations, we are definitely expecting increased scrutiny, increased FDNS site visits, verifying job duties, employee qualifications is going to be a big question too. Employees placed at third-party client sites, depending on each case by case or circumstances, Nabasa, FTNS may check with end clients, like I just said, whether the end client's minimum requirements have been met with or matched with by the employer. For example, if the end client is requiring a software engineer, but then
Mhm.
you placed a software developer, so now that is a red flag.
Okay. So the job description is very important, and doing what is said in the job
It's a
description is
meeting with the job requirements of the end client.
right. Right. So thank you so much, Uma, for taking that up, and Rahul also for a very important question. So third-party client site. And now, Arpita, hi, thank you so much for joining us. I wonder where you have joined us from, but thank you for your question. So let's take it up quickly, Uma. So she's asking, I've been with my employer for over 4 years on H1B without issues. But now I'm hearing that even long term employees are being scrutinized under these new rules. So, why is that? And should I be worried?
I wouldn't say long term, short term. There is no uh, reason to say a long-term employee will not be scrutinized by a FTNS visit. FTNS are equipped with lots of additional sources to detect fraud. Nipasa, for example, they have leveraging data analytics with their USCIS office to flag any inconsistencies in employer filings, be it old, be it new. They have the data analytics to do that. The employers found to have submitted any kind of false or misleading information also will face heightened penalties. So, they have every um, information and leverage to get the information. And based on that, they can go with an old employer. Old employee doesn't matter. Somebody's
Mhm.
been beyond the 6 years, filing for an extension, even that can be an FDNS visit.
Okay, okay.
So it's got nothing to do
Thank
with how long or how old, how long you've been with one employer or employer two or employer three. And as I said, there's a lot of questioning about the verification of job duties, employee qualifications, whether they meet the end client requirements, whether employer is in compliance with the LCA salary. A lot of employers I see that they don't pay as per the salary. In fact, some
Yes.
of the employers pay a month later. If they're supposed to pay the feb wages, typically are not paid till March or till April.
Hmm,
So
hmm.
there can be problems too.
Right, right. So pay stubs are going to matter as well. Who knows? They would ask.
Absolutely.
Right.
Absolutely.
Thank you, Uma, for addressing this for Arpita. And folks, thank you for your questions. I would like to say that we also have a calling in line available. So why don't you call us to ask your questions? Echo Alex, Arpita, thank you for your questions. Why don't you join us on 425-436-6335, and the access code is 988-888. So if you call in, we are available and you can talk directly with none other than Attorney Uma Mantravadi. So you can also email Uma in case you want more attention on your case and you want proper guidance or probably just a one-on-one consultation. You can call her on her number 713-787-5297, or email uma@mantralaw.com, or go visit www.mantralaw.com to get to know more about attorney Uma Mantravadi. So, Uma, also, we have more questions to address.
Yeah.
Let's quickly take a couple of them. My next question to you would be, about the main changes in the new H1B rules. How are they affecting employer responsibilities?
Well, like I said, Nipasa, the F1, H1B modernization brought about a few good changes, and there's also great length of discussion about enforcement and FTNS site visits. The good changes are, for example, in the past, an employee could not be a partner or hold any kind of partnership or stock, holding stocks in that company. In the past, you could not do that. If you did that, that would be considered as a bias. But now they're saying it's okay, you can be an employee and be a part owner of the company to file the H1. So that is one good new rule that is coming about. They're also saying we're going to give deference to your previous H1, previous H1B approval. So if we see that you've had prior H1 approvals, we're going to give deference to that to make sure, that you have a greater weight on your possible approval of the H1. Of course, they're still going to go through and make sure everything is in compliance, even though, they're going to give deference to the previous H1B approvals. But one of the key compliance requirements for H1B employers is maintaining also the public access files. The public access file must be readily available for inspection and contain, the certified LCA, the wage rate, explanation how the wage was determined, documentation of any previous wage sources, statement of notice to workers, meaning where did you place the LCA. All this plays a crucial role when there is a FDNS site visit, and it serves proof that the employer is complying with the wage requirements and the labor conditions. And if you don't maintain the PAF, which is a public access file, it can lead to penalties and compliance issues. And Napasa, we've seen some employers in the past, they were also banned from filing H1s if they felt the violations were extreme and the persons did not maintain the proper public access files. They even blacklisted them and did not allow them to file H1s.
Right. Right, Uma. Thank you so much for bringing that up again and highlighting them as well. So, um, yes, a lot of things are to be kept in mind, and there are new rules which, you would like to check out as well. It's always best to stay updated, do your research properly, especially when
Absolutely.
whichever, visa that you are applying for, get to know more about it and what, rules govern all that, and play safe, of course. So also, there were new rules much before even the new administration came into being. A couple of days, right? I think it was January
Yes,
17th.
this modernization rule was implemented on Jan 17th, 2025,
Right.
exactly 4 days before President
Trump.
Trump took the office.
Right. Right. So yeah, now coming to my next question to you, Uma, would be, how does these new rule make FDNS site visits mandatory for employers?
It doesn't make it mandatory for employers, Nipasa, but then, as I said, with the data analytics and information available to USCIS, if they feel there's a red flag going off, they can always, come to an employer to make sure they, audit your existing public access files. They can ensure the records are kept complete. If you haven't, you need to make sure that you maintain accurate and up-to-date employee records, which is keeping copies of their paychecks, W-2s, in case of any FDNS visit. So, right now, as I mentioned, this Trump administration is looking for more of enforcement rather than just looking at compliances alone. Compliance and enforcement kind of come together. So definitely there's going to be more site visits, and employers should mandatorily maintain a proper public access files.
Okay, and just in case, these employers, they do not cooperate with these FDNS site visits, inspection officers maybe. So what do you think is going to happen next?
As I said, possibly penalties could be also a risk of getting blacklisted where they will not be allowed to file for any future H1Bs.
Mhm. So, all right. But is there
Employers need to,
anything?
sorry,
Okay.
go ahead, sorry.
So, and I was just going to ask, is there any way they can avoid these, maybe answering to these FDM, politely, of course, maybe saying that I would like to have my attorney while I answer or something
They
like
can
that?
always do that. They can, if there's any legal matters that they don't know that is complicated for them, they can always say, you know what, let's schedule a time where my attorney can be present and explain. I have the documentation, what I can, but if I don't have, maybe I'll keep it ready. I should have, but I didn't, or maybe my attorney has it and I don't. They could definitely,
Okay.
and not that the attorney would be immediately available for them to
Hmm.
show up at their physical location, but they can definitely ask for time. So, in order, I would say the best practice for the employer is to make sure your public access files are kept up to date in case of an inspection, maintain employee payroll records, payroll information, train your HR personnel to be prepared for these unannounced FDNS visits,
Visits, yeah.
um, and make sure that your employees know their job roles, their wages, their work site location. Sometimes people get nervous, if they are a programmer and they'll say, I'm a software developer, they're completely giving wrong information. So they need
Right.
to be, addressed properly and keep your documentation organized with the LCA,
Mhm.
employment agreements, uh, any kind of organized org charts are very important. So employer needs to maintain that.
Right, right.
These are the
So,
ways to avoid uh, intricate FDNS questioning.
mhm, mhm. Thank you so much, Uma, for bringing them up and highlighting them. So I really hope that people are pretty much ready for all these more site visits, you can say, this year. And also, we were speaking about what can happen to employees, but do you think the same is going to happen to the company also who doesn't follow these FDNS site visit rules? Maybe do you think it'll affect their reputation and even the ability to maybe even hire
It
H1B
can,
workers for them?
it can, and it can, I mean, once they've had an FDNS visit and they find a lot of violations of the employer, then anytime you file an H1, you can expect RFEs, you can expect NOIDs, which is the notice of intent to deny, or in a situation where they feel they violated, they can always do a notice of intent to revoke that current H1B as well.
All right. Thank you so much, Uma. Now, well, we got Kaylee Huey saying hello. So, hello to Kaylee, Kelly. Sorry if I've got your name wrong. But thank you so much for joining us. And if you have any questions, do ask or join us on call. You can dial this number 425-436-6335, and the access code is 988-888. So, especially folks out there whose questions we address, don't forget to also like our channel, subscribe to our channel, and our handle is at Immigration Talk Show. Follow us, connect with us. We are not just on YouTube, but also on LinkedIn, Facebook, X, Instagram, and stay connected with us. Watch out our space because we have so much information all the time coming up, the latest ones, updates that you don't want to miss, and also so nice to have attorney Uma Mantravadi today, from the Mantra Law offices. So thank you so much, Uma. Now, I have another question, and if an IT company faced an FDNS site visit in February
Mhm.
2025, shortly
Mhm.
after the new H1B compliance regulations took effect,
Sure.
unprepared and unable to provide the required documentation or personnel, the company was flagged for non-compliance, and this led to several H1B petitions being denied or revoked, severely impacting operations as well. So following this, the company implemented strict compliance protocols to avoid future issues. So how can companies ensure, especially immediate access to necessary documentation during site visits?
First thing I tell employers, please have an attorney who can help you with your public access files. Make sure your I-9 is in compliance. Make sure you're an e-verified company. There are many things you can do to avoid even being red flagged and having a site visit. As I mentioned, as long as there is no fraud or violations, everything should go well. But first thing is to contact an attorney. There are attorneys who also specialize, particularly in public access files, how to maintain, what do you have to do, what are the documents that are required, how do you be ready for an FDNS site visit. So there are attorneys who do that, and I do assist my employers who are working with me to make sure that they have a complete and proper FDNS visit public access file so that they don't have too many problems.
That's really very kind of you and thoughtful of you, Uma. So um, I think it's always best to have an attorney by your side and lead you and guide you in the right path. So why not contact attorney Uma Mantravadi, and you can do so, by asking for more attention on your case by dialing this number 713-787-5297, and you can also email Uma about your case to uma@mantralaw.com. You can note it down, it's there on the screen below. And also go visit www.mantralaw.com to get to know more about Attorney Uma Mantravadi. But for now, I would say stay with us. We'll just go for a short break and we'll be right back with Attorney Uma Mantravadi on Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. So, this would be the second part of the webinar today. We are having with none other than Attorney Uma Mantravadi from Mantra Law Office, Texas. And it's very nice to have you, Uma. It's such a pleasure always, you know, to have your expertise, your knowledge, you imparting that with us in our show. So, thank you. And
Most welcome.
And also, it's really lovely, folks, that you join us with your questions. So I would really like to quickly take up this next one. This is from Mohammed, and he's asking, what are the new regulations? We
New
already
regulations
be a
about
little time.
what? I think we've already discussed it over and over again. So,
Yes.
all I can tell Mr. Forget his name, Mr. Muhammad.
So here.
Uh-huh. Mr. Muhammad, you can go to the USCIS website and go to H1B modernization rule, and it's all there. You can look at it if that's what you're looking at. I don't know, it's a generic question about new regulations. So if it's about H1, you can go there and look up the new regulation.
Yes, in fact, if it's about H1B, we already discussed a little while back on this very episode. So you can always stream this episode again watch this episode again after the stream is over as well. So thank you, Mohammed, for your question. And now we have our next one. This is from RK. Oh, Kaylee asking, I currently live in Ethiopia and trying to take USMLE. I am a medical doctor. What will be the next step after my USMLE?
I wouldn't know that. That's something you'll have to check in the medical field whether you need to go do additional education, residency, board exams. I'm not familiar with that. That's something you'll have to check it out.
Okay.
I don't know
Well,
what step, because all I know is USMLE is got a step one, step two, step three, and then you have to match to the residency programs. And if you do get into the residency, that's what you do. But I don't know more details than that. It's only a general information.
thank you. And thank you, Kelly, for your question. Now, let's take up this next one. This is from RK. If a site is done and the employer is found to not be in compliance for one or two employees, what happens to the other employees at the same employer?
Possibly even they can be, their cases can be questioned because there was a red flag on this employer. So there is a possibility that, you know, once a doubt, they can, go into other cases too.
Okay.
Possibly. We don't know that.
All right. So I also have another question which I received in my WhatsApp. But before that, Kelly is already saying, okay, thank you. Thank you again to you too, Kelly. And this next question I received in my WhatsApp is I'm Abraham. I get your contact from the internet. Thank you so much for joining us. I am from Ethiopia. I need to go abroad, work hardly, and help others. So, my question is, how can I get H1B visa? Could you help me, please?
Well, right now the H1B lottery is going on, and if you have an employer who's willing to file your H1, you can file your H1B electronic registration. And if you're lucky, you get picked in the lottery, then you go forward. And the deadline for filing is March 24th, 2025. So make sure your employer files your registration, electronic registration, before that date.
All right. Thank you so much. And thank you, Uma, for taking that up. All the best. I know it's a very vast question, but I really do hope that you qualify and have a job waiting for you. So, all the best to Abraham. All right, now next question to you, Uma. Let's get back to our questions. Okay, let's take these from our Facebook groups, or this is from our YouTube channel. And this is, if I petition from August 2017, got welcome letter and numbers from a couple months now, but the payment is not opening for me to pay. It's for my over 21 children in Jamaica. Now, this
I
is
didn't
interesting.
understand the question.
If I petition from August 2017, got welcome letter. I think
Welcome
his,
letter meaning they got a green card welcome letter.
yes, probably their
Is
dates are,
what I can assume.
yeah. So maybe, so a couple of months of petition for child over 21 years. Okay, could be that too. But for a couple of months now, he's received this petition, but the payment is not going through.
I don't know
Uh,
what payment they're referring to. Is that the NBC payment? You would have already done it if you've already got the green card approval. You're saying you've got the approval, but then you're talking about the payment. So it's confusing. I would suggest whoever this is, please reach out to me individually, and I'll be glad to take it up and then, answer your question. Please send me
yes.
an email to my email address, uma
It's
at
Hermione.
mantralaw.com.
Thank you, Hermione, for your question, and do message Uma. Now, this one is from an anonymous participant in Facebook, Uma. So they're asking, hey everyone, I was rejected twice for my F1 visa interview 3 years ago when I applied for my bachelor's. Now I'm planning to apply again for my master's in the United States, and I want to make sure I address any political issues and strengthen my application this time. What factors should I be careful about, and does anyone have insights or advice on improving my chances?
Uh, all I can say is I don't know what happened in the past. So I would have to look at the past history, why he or she was denied twice in order to make sure they strengthen their case this time. And a lot of
Right,
times, what happens if you've had a denial in the past, few people keep getting denials, and few are lucky enough to overcome those denials and get a visa approved, be it a B1, B2, F1, H1, it doesn't matter. But we have to look at the history to determine what went wrong there in order to correct it now. So,
right.
again, if you want to reach out to me, you're more than welcome to.
Right. Thank you so much, Uma, for taking that up. And anonymous participant, you can always reach out to attorney Uma Mantravadi at uma@mantralaw.com. And you may even call her on this number, 713-787-5297. So let's go on to our next one. This next one is a typical situation. I am on H1 and recently moved to US. Since my wife can't work on H4, I'm thinking of applying F1 to get her to the US. Please suggest, what if they ask why F1 instead of H4 in the visa interview?
Well, my advice would be, or my suggestion would be, let her come here on an H4, and then you can always change it to an F1 when she's in the US to avoid any issues.
Absolutely. Thank you, Uma, for that very direct and prompt answer to this typical situation. And this next question is, hello everyone. I have a query regarding H1 transfer. The current employer, they see where I'm working, filed H1 transfer in normal process on January 15. At that time, I got another offering from a big tech company, but they were doing background verification and now they completed and processing my transfer premium. So the attorney is asking latest pay stubs, but my employer is saying that they have a payment period of 45 days. So I will get my salary on the 15th of March. I joined on receipt notice as my grace period was about to be over in a few days. Initial document I gave to attorney was my previous employer because that time I was in grace period. Now what should I share with the attorney?
This is way too much information. I'll have to, speak to this person individually,
Mm,
Nipasa, because I'll have to get a lot more information before I can give them any kind of guidance. So I would advise them to reach out to me, and then, we can take it up, because there's a
absolutely.
lot more
Anonymous.
information that I need other than what they are saying here.
Right, right. So, anonymous participant, do reach out to Attorney Uma Mantravadi, and her contact details are already on the screen. I hope you have noted it down. Let's go on to our next one now. This next question are okay. We have addressed all our Facebook and YouTube questions for now, but also another question I have for you is Uma, if you can tell us,
Sure.
how to follow FDNS site visit rules affect H1B employees' ability to work and stay in the US, which
Sorry, would you repeat that question?
how could failing to follow FDNS site visits, the site visit rules, they affect these H1B employees' ability to work and stay in the US if it's an
Well, if the
H1B?
employer doesn't comply with the FTNS site visits, during the FTNS site visits, as I said, they can get a notice of intent to revoke or a notice of intent to deny. And would that be all the cases possible, or some cases? We don't know. So they need to, first of all, during or prior to the FTNS visit, an employer is required to cooperate fully with the FTNS site visit to demonstrate their compliance with the H1B regulation. So, in order to do that, they need a point of contact, somebody who knows all about the company, the H1s, like an HR or an immigration attorney, to handle site visits. And they need to make sure that all the essential documents are there in the public access files, including pay records, work schedules, everything. So they need to make sure they are in
Mhm,
compliance, or at least make sure they're ready for the compliance.
mhm.
Speak to an attorney. FTNS visits can be very, very damaging to an employer if they don't maintain proper documents.
Right. So, and anyway, like it's very important to have your documents right, and uh, there are documents that you should also keep with yourself at all times: identity card, of course, and your visa status, with no doubt, and also your passport, maybe, because you may be asked anytime.
Absolutely. That's for the employee, keeping a copy of the I-797 approval, copy of your passport, your current driver's license. All of that is, yes, a requirement. But for the employer, the FTNS site visits are more stringent on the employer.
Right. Right. Thank you so much, Uma, for that. And maybe, before we wrap up, are there any points or end notes that you would like to make, especially with regard to our topic of discussion today, that is the April Visa Bulletin, and what is the impact of new H1B regulations and FDNS site visits? Anything more you want to add before we leave?
Sure. I always like to tell people this, especially now under the Trump administration, the second term. Don't take chances. Please, contact an attorney. Ensure that you're in compliance with all the, whether it's an H1B regulation, L1, TN, E2, E3, F1, doesn't matter. And second thing I would advise is, this is not a time to travel. Do not travel. Avoid it. Just stay put. Because if you have issues, when you come back at the port of entry, CBP is not being very kind on people. They're even deporting permanent residents. So I wouldn't take a chance.
It's
Do
crazy,
not
but
travel if it's not necessary.
Thank you so much, Uma, for those very important points and advices. So, with that, I think we have come to the end of our episode today. This very important webinar, full of important updates and a lot of discussion, a lot of important points to keep in mind as well. So, I would say thank you so much, Uma. It's always a pleasure and an honor to have you here
My
with us.
pleasure. Have a good one and a
You too.
wonderful rest of the week.
You too, Uma. All the best. And friends out there, thank you so much for joining us once again. And if you want to have a one on one consultation with attorney Uma Mantravadi or contact her, do call her on her number 713-787-5297 or email uma@mantralaw.com and go visit www.mantralaw.com. Also, you can email me or WhatsApp me in this number. My number is 408-335-6444, and my email address is nipa@staffingly.com. But before you leave, friends, don't forget to subscribe to us if you haven't as yet already, and do like and share. Also, don't forget to hit that bell icon and get notified whenever we have discussions like these. And that said, thank you once again for joining us on Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, Instagram. Check us out, connect with us, and watch out our space because we have a lot of important updates you don't want to miss. Bye for now. This is Napasa signing off.